Lord, may I have your lordship's kind leave to mention, my lord, this is a matter where, my lord, I had, my lord, indicated to your lordship that I'll be, my lord, I mean, led by Mr. Gopal Jain, who's come up from Delhi. My lord, only thing is that, my lord, this is a matter with grave urgency, where, my lord, we have, my lord, this is appearing as item 36 in your lordship's list. But I'll be praying for a humble indulgence, my lord, if it can be accommodated any time, my lord, during the day. Because, my lord, the urgency is this, that, my lord, section 95 petitions have been filed against one of the petitioners. Where 95 of the Insolvency and Bankruptcy Code, my lord, petitions have been filed against the petitioners, where, my lord, these applications are due to appear on, my lord, 3rd of, my lord, December. My lord, that's, my lord, on Wednesday, my lord. And, my lord, the difficulty is that, my lord, the applications which have been filed, my lord, without there being any default. My lord, the entire amount has been, my lord, paid. My lord, substantial sums have been paid to them along with the interest penalty,
We have
everything.
overpaid, my lord. We have paid for January and February 26, and yet they want to put us under the bus. So we are only appealing to my lord's gracious
Wait
mechanism.
for the other side.
But I have given notice, my lord. I'm mentioning upon notice to them.
So Argus is there.
Argus is there, my lord, as, my lord, the
36.
36, my lord.
Other matters are also there. How much time will it take?
10 minutes. I can do it in 5 also, even now with no files.
काम को इसको 12 बजे कॉल 12 noon.
I'm so grateful.
12
I'm
बजे
grateful.
फिक्स है 12 noon कोई फिक्स है नहीं है ना 12 बजे you give the notice to the
Yes.
I will again give them notice.
हाँ
Deeply grateful.
I'll inform.
May I?
I'm
Your Lordship, with your leave, may I mention?
yes
Your Lordship, yesterday at 4:30, when the bench was
matter,
rising,
which
I mentioned,
matter?
Your Honor.
matter
Please, Your Honor, Your Honorship, Your Honor, the new rate which Your Honor had directed to release.
record or not it is submitted by the Learned Counsel for the petitioner. The matter is listed before the other court and as per the prayer made by the counsel for the petition, the matter is released from the list of this case court. The
To Court 5, Your Honor.
the parties are given liberty to mention before the appropriate court having determination.
My lord's
I am
kind leave
deeply
to
obliged
mention
for the
one.
kind consideration, Your Honor.
My lord's kind leave to mention one matter, my lord.
Released from this court.
Your Lordship, with your may I permit your
May I be permitted to mention one matter, my lord?
It is in my list.
Not in the list.
Ah,
Filed it.
mention the court number this.
We have mentioned before urgent clearance your lordship.
So what you want to if it is not listed?
Release this matter.
It is not listed. What is the how the release? It is not listed. In the presentation form, what you mention? Court number, what court number you mention?
5.
Huh?
Court 5.
Court number 5. The
For this matter, yes. But we are just we want to release the matter from the
how the matter has come before this court? How this matter has come before this court?
Your Honor, if I may have a leave to mention, Your Honor, the matter has been inadvertently wrongly filed and mentioned before Your Lordships. Yesterday, Your Lordship said Your Lordship doesn't have a determination. Your Honor,
Correct.
straight away I mentioned to Court 5. Court 5 said that you get it released, I will hear the matter.
But the
Your Honor,
matter
I
is
mentioned.
not in the list of this court. How the matter be released? You go to the department will place the matter before the appropriate court.
You have to release it from your lordship may
Your Lordship had yesterday told that Your Lordship will pass an order for release so that I file it before Court 5. Your Lordship, I am in a difficulty, Your Honor. It's a petition against challenging the illegal
Madam, you
arrest, Your
tell
Honor.
me whether the matter is listed before this court. Then how the matter will be released?
maybe listed
Why you are not understanding?
for the Monday. We will
If it is not been, you have not mentioned in the presentation form of the court number 25, how the matter will be listed before this court? How I can mention list the matter as a supplementary list? Where is the, where, in the supplementary form, we have which court number you have mentioned?
You have mentioned 5.
Then automatically it will go to the court 5.
Your lordship,
Your
Lordship, kindly
lordship,
leave to mention
inadvertently,
one
when
matter,
we
my
had
lord. I'm
filed, we had
appearing
filed
online.
according to the determination of this court.
may I permit to mention one matter, my lord? Item number 32, my lord. I mention your lordship, taken it for urgent motion, but every day, my lord, matter is not taken up, my lord. Your lordship, take only 5 minutes is required, my lord.
In the list, it will be taken up.
Well,
As per
all
the list.
5 minutes, my lord, you will not get the service.
Matter cannot be
You will not get the service, my lord.
Lord, I pray your lordship's kind leave to mention a matter.
No mentioning will allowed. Yes.
My lord had indicated yesterday, my lord, item number 42 from yesterday's list, under the heading extension of interim order, my lord.
My lord's
My lord,
kind leave, my
allowed-
lord, I've been trying online, my lord. One for inclusion in the list, my lord. This is a leave matter.
May please, your lordship, my lord. This matter has come up at my instance under the heading to be mentioned.
Yes.
My lord, we have repeatedly been serving the state notice to come and appear. Even at the time of mentioning yesterday, also we sent them a notice indicating that the matter will be taken up today. I'll just briefly indicate, my lord, there was an order passed, my lord, on 6th August 2025, by which, my lord, we were directed to pay certain amounts of money and get 2 sale deeds returned to us. There was an issue with regard to assessment of stamp duty. We had submitted the sale deeds, my lord, back in 2003. Then, my lord, for whatever reason, my lord, the authorities, my lord, sat with it in 2021. Finally, they intimate us that a particular amount has to be paid. So we challenged that, my lord, saying that the amount has to be based on when we had submitted the sale deeds. So nonetheless, my lord, without prejudice to our rights and contentions, we have paid up 28 lakh. Now the issue is, my lord, the court will have to decide as to on what prevailing date will the stamp duty have to be collected. So 6th August, this order was passed. They were directed to file their opposition within 4
Now,
weeks.
whether the sale deed has been written.
Yes, we have got the sale deeds now.
Got the sale.
Now the only issue is, my lord, whether I will get back the extra amount which I claim I have paid. That is the only issue which is left.
The amount which you have paid to the.
Yes.
At the time registration.
At the time, yes. Because we have paid about 28 lakh. According to us, about 6 to 8 lakh was payable. So there's a balance extra, according to us, about 20 lakh. So they were directed to file their opposition, my lord, within 4 weeks from 6th August. Today, my lord, we are end of November, my lord. The opposition has still not come. My lord, I am led by my lord, retired Justice Muralidhar in this matter. My lord, I was humbly praying, my lord, that the date be fixed for hearing this matter, subject to your lordship's convenience, of course.
So Muralidharan will be available.
Yes, he's indicated 3 dates, my lord. So one is 12th December, the other 2 dates are 9th January and 14th January. No, may I just suggest this, my lord, subject to your lordship's consideration, my lord? Kindly give them another week or 2 weeks, my lord, to file their opposition peremptorily, my lord. I will find my reply thereafter. I will indicate them also, my lord, that this order has been passed today. Oh, he's here. I'm grateful. My learned friend is here.
And then,
You will file. Have you filed the?
no, my lord, I have not filed. As a last chance, my lord, will kindly give me an extension, my lord. Today, my lord, they have no urgency also, my lord. They have got the deed. So your lordship needs to consider the issue.
When you want to be fixed it.
Well, the 9th January or 14th January, kindly give them a week or however much time they want, my lord, to file their opposition. And I'll file my rejoinder in the meanwhile before the matter is taken up.
14th January fix है देखो 2 बजे.
14th January will possibly be better because I'm told it's a holiday in Delhi for Shankranti.
Yes.
But we don't have a holiday here.
Myself might be.
Then 9th January. 9th January.
9th January.
well, kindly give me 2 weeks of time. Extension of 2 weeks, my lord.
No.
I will kindly fix a time, my lord, subject to your lordship's
Has to be mentioned on
Jamie,
the
what day of the week is it?
for the petition.
What day of the week is 9th January?
Petition submitted by an order dated
Ma'am,
6th August 2025. This court directed the respondents to file affidavit in opposition, but till date opposition is not filed. Accordingly, prays for fixing the matter for hearing. And at counsel appearing for the respondents, prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed by 12th of December 2025 after serving the copy to the learned counsel for the petitioner. Reply, if any, be filed by
2nd January, my lord.
by 2nd January 2025 after serving the copy to the learned counsel for the respondent. This is the matter on 9th of January 2026. ऊपर 26 होगा 26 at 2 p.m. for hearing.
Most grateful. Most grateful.
We are grateful, my lord.
Under the heading especially fixed.
This is peremptory direction, my lord.
Especially fixed. That's why.
Yes, yes. Grateful.
My lord, it's appearing at our instance, my lord, for extension of the interim order. My lord, the challenge in this petition is very limited, my lord. So I would pray, my lord, if lordship fixes any day, my lord, maybe in the month of January, whether, my lord, a deed of assignment of copyright requires stamping or not. This is the only issue based on, my lord, the provisions of, my lord, the copyright.
Why before this court?
No, this is, my lord, a residuary matter. It was entertained, my lord, interim order passed, and thereafter, my lord, it, my lord, could not be taken up for hearing. My lord, the interim order is still, my lord, the end of November. That's why it was mentioned. My lord kindly extends it and my lord keeps it, my lord fixes it any day, my lord. Even if it is in January, my lord, we'll have an adjudication, my lord, on merit.
Yes. Affidavit filed.
Yes, affidavits filed, exchanged.
The matter is listed under the heading to be mentioned on the prayer made by the counsel for the petition for extension of interim order. He submit that interim order is still the month of November 2025 and prayed for action from interim order. He further submit that the pleadings have been completed, matter fixed for hearing, may be fixed for hearing. Heard the land counsel for the parties. Interim, let the matter appear on 6th of January 2026 under the heading adjourn motion.
Is it my lord's pleasure to, my lord, give some, my lord, this has been pending for quite some time.
6 जनवरी में डेट खाली है, कोई टाइम खाली है? January at 2 p.m. as especially fixed.
Very grateful, my lord.
The interim order is extended till 9th of January 2026 or until further order, whichever.
Grateful.
Next.
Item number 4, my lord, this is appearing at my instance as to be mentioned. My lord, my lord passed an interim order. My lord kindly takes my lord's order, my lord, on 11th of September 2025. My lord, there was a direction, my lord, to file, my lord, oppositions on their behalf, my lord, which has not been filed yet. And my lord, the interim order, my lord, was passed, my lord, till 27th of November. My lord, this matter was running for quite some time before my lord's list on the returnable date as item number 166. It could not be reached. No, that's why 131. So it has been mentioned, my lord, for extending the interim order.
Yes, who is for the authority? Filed affidavit. Have you filed affidavit?
My lord, not yet, because it says already ready and sent to the department for vetting also. Before vacation, it will be filed positively.
Before vacation,
Before
1 month
vacation
is there. 1 month you will take for the approval of the.
No. Within 2 weeks, we will be filed.
Within 2 weeks. The matter is listed as to be mentioned for
Look at this.
on the prayer made by the counsel for the petitioner for extension of interim order. Counsel for the petitioner submit that in spite of the order passed by this court, the respondents have not filed affidavit in opposition. Counsel for the respondent pays for extension of pays for extension of time to file affidavit in opposition. That affidavit in opposition be filed by 12th December.
My lord.
By 12th December 2025, after serving the copy to London counsel for the petitioner, reply, if any, be filed by 23rd of December 2025. List the matter on 8th of January 2025. Interim order is extended till 8th January 2026.
End of January
2026.
Much of
Next.
2 weeks. 12 December.
Extension.
My lord, extension up to 2 weeks. 12 December. January.
12 December.
12 December extension also be there.
Extension till 6th of January 2026.
Okay,
you file by 12, reply by 23, hearing on 6th of January.
Okay, my lord. Much obliged.
Yes, sir.
Your Lordship need not be serious. I'm just reminding your Lordship, taking 2 minutes so I can earn the fee. That's all.
To your face.
Blood, this is blood. I had forgotten your Lordship's smile. Your Lordship's forgotten our faces, blood. Those who are on the original side, and we've forgotten your Lordship's smile.
Yes.
Now, blood, just to remind your Lordship, this is to do with that insurance policy. Now, the critical thing is only one thing, blood. Your Lordship will remember, admitted position is blood, acceptance of policy is not by manual signature, it's by OTP. Now, it turns out that there's a huge difference in returns, although the premiums are the same, in whether it is allegedly a digital or non-digital policy. So I wrote to them, no reply, repeated letters. And one letter is not critical over here. Please see that one letter which I showed your Lordship, page 65. Or before that, if I can show your Lordship the difference.
Not filed.
Your Lordship had refused directions for affidavits. Matter was heard. I'll give your Lordship the last order.
Yes.
And your Lordship wanted notes to be filed.
Correct.
So, my Lord, today's for filing of notes. I'm just giving a recap. Now, my Lord, if your Lordship comes to page 65, there's an email by the insurance company which says two things which are perhaps not admissions and finish the matter completely, which I had pointed out. It was set out in the order itself.
Yes.
At bottom of the page, email of 17th of June from the insurance company. Page 65, 65.
Of the repetition?
Yes,
The
Lord.
repetition.
Yes, Lord. Lord, your Lordship is looking at Bhavna Khimani or Shalin?
Item number 6 is Bhavna.
Shalin. Shalin.
Shalin. I see. Not the page will be one page different. Please.
Page 61.
Page 61. I'm very sorry. Lord, I had the wrong file.
Yes, page 61.
Lord, letter at the bottom, 17 June. If your Lordship takes the second para, we would like to inform you that as per our firm, digital stands as the online method of enrolling policies with the help of OTP. Just mark this. Sent on your mobile number, and non-digital as the offline method of enrolling policies with the help of manual. So this, according to them, is the difference. This is the difference. Now, I'm not one more line there. Please see the next line. And they've put it in bold. Further, would like to inform you that the above mentioned method does not impact any of the policies. So according to them, the returns will be the same. Now, in the page just before that, please see, I've given a chart. Page 53. Please see the difference in the returns. Now, there are two over here, husband and wife, they've done it for their retirement. Now, second column, your Lordship will find the policy premium for digital. Third column is for digital. It's the same.
Yes.
Now, my Lord, your Lordship sees, therefore, there is no difference. Now, my Lord, if your Lordship sees the benefit, they are tabulated on the next page.
Yes.
Under one, my Lord, after all these years, it will become 4 crore 43. In the other case, it will become 4 crore 58. My Lord, the difference is 1 crore 44 lakhs. 1 crore, my Lord, is the difference. And they say that there is no difference. Now, my Lord, not just that, my Lord, to authenticate this, we showed a screenshot. We showed the officer the screenshot from their app. Now, that your Lordship will find at page
182.
182 of that matter, my Lord. And, my Lord, your Lordship will find the figure, page 182. This is a screenshot from their app to show that the returns are completely different. I showed these all these to your Lordship.
Yes.
The returns are different, they are not the same. But they keep taking this stand. Now, my Lord, what happens is, once they don't, my Lord, give it to me, I apply it to the ombudsman. My Lord, the ombudsman did nothing. I filed a writ petition and came to this court. The order of this court, my Lord, is at page 152.
184.
Lord, the order of this honorable court, Lord, is at
146.
146.
Yes.
Not the same dispute, they were not hearing it, was my complaint. Lord, if your Lordship then turns to the second page,
Yes.
third last para, authority shall decide the matter independently on hearing all the parties. Reasoned order shall be passed and communicated. Reasoned. Decision shall be taken within 2 months from the date of communication. And Lord, if they have any point, I was permitted to deposit my premium without prejudice. Now, my Lord, comes to the impugned order, which is page 184. Now, please see this order. Lord, my complaint is, Lord, set out, that's 3/4 of the page. Then, Lord, contention of the respondent, that is the balance going up to, Lord, the bottom of page 185. So, Lord, two things here. Now, my lord, if I can just bring your lordship back to page 184 in their submission. Please see contention of the respondent. There's two things I want to show your lordship. Please see the last para 3 on that page. LA has confirmed that she received and read the application provided by the insurance company, and policy application and sales illustration was authenticated basis of OTP. Yes. In the insured mobile number. She read and understood the same by sharing her OTP with the insurance company, and she has been convinced about the content and features of the policy plan and has applied for. The policy was authenticated both basis OTP and no manual signatures opted for. So, my lord, even according to them, it's a digital policy. Now, my lord, please turn the page. This is their stand. We would like to inform you that as per our firm, digital stands as the online method of enrolling with help of OTP. So that, my lord, they admit also. So, my lord, if it is not being done digitally and, my lord, there is no difference, then why is there so much reluctant to classify mine as not digital? There should be none. Now, my lord, after all this, my lord, they record, my lord, if I may read the rest of it, with the OTP sent to your mobile number and non-digital stand as offline method of enrolling policies with the help of manual signature. So that's the distinction. In my case, there is no manual signature. Then, Lord, your lordship will see, Lord, they refer to the Calcutta High Court Order 14, then, Lord, last para, heading, observation and conclusion. So, Lord, your lordship has had 1.5 pages of setting out the complaint. Now, my lord, see observation complaint. The complaint's grievance is that policy under consideration was issued to her non-digital mode, resulting in loss of maturity benefits, and he requested to convert to digital mode with resultant increased maturity benefit from the date of issue of the policy was not acceded to by the insurance company. In support of her contention, she, via her email 19 December, has submitted, now my lord marks this, purportedly screenshots from Tata AIA app of the difference in maturity payment of policies in digital and non-digital. So I've given this. Now, my lord, please see the response. Clarification was called from the insurance company regarding any discount in premium or increase in maturity payout on account of digital mode of purchase of policy. Company has categorically denied any discount and has doubted the authenticity of screenshot shared by the complainant. Now, my lord, his own app, Lord, please see the stand. And, my lord, I'm not given a chance to respond. Lord, we wanted to be represented by a lawyer. He said, no, that's against the, my lord, rules laid down by a court judgment, but I'm not getting into it. Then she was allowed to appear online. My lord, these juniors, my lord, who wanted to appear were not allowed. She appeared. My lord, then she gave this screenshot. And then, my lord, they privately asked the insurance company, who doubts the authenticity. I'm not given a chance to respond. So, my lord, taking into account the facts and circumstances, go through the documents, it is observed complainant has alleged that her request to the respondent has to convert from non-digital to digital with resultant increased maturity benefit was not acceded to. So, my lord, no reason here also. Respondent insurance company on its part has refuted the allegation of selling and has denied the availability of any discount or premium or enhanced maturity due to purchase through digital mode. The complaint is dismissed. So, no reasons. And not if, according to them, there is no difference, why the reluctance not to convert it into digital mode? Yes. Not one, his method is if it's OTP, it is digital. Two, if there is no difference, and I've showed your lordship the difference, Lord, will this bear denial do? Lord, this is the long and short of it. Lord, it's been delayed for long enough. Lord, it's to do with the retirement. Lord, funds, Lord, Lord, my notes today was for notes, Lord, since my learned friend was not here in the beginning.
Other than this admission, there was the admission at page 61.
Lord, your lordship will only, Lord, make one note. That page number of that letter of admission, which I just read out to your lordship, that's page 61. It's not there in the note. Lord, if your lordship just puts this in the note at page 2, we have quoted it from the order itself, but the email itself is at page 61. The one which says there's no difference in benefits, yes, and the one which says OTP is the page 61 is the page 61 is the relevant portion.
So two admissions order. So
Yes.
Those are my submissions. And Lord, my learned friend had made 2 submissions, but those are to do with when I'm seeking cancellation of the policy. They have nothing to do with, I'm saying, look, this is digital, give me the benefit of a digital policy. Those rules don't apply.
I was
Lord,
being
those are
led
my
by my senior. I'm ready with the written notes of argument. I'm filing it.
ওদেরকে দিয়েছো?
In both the cases.
No, Lordship, that is item number 5.
Okay.
But both are identical. The difference is in the name.
Same.
And in one, my lord, there is a High Court order saying decided with
Item
all.
number 5, I
Oh,
believe
in both.
there is no ombudsman order passed in item number 5.
It was earlier a
Item
common
number 6, the
petition.
ombudsman order was passed. They did not participate in item number 5 before the ombudsman.
There is no order. Notice and I came up. Explained it here.
That's which one?
The parties have filed the written notes of argument.
First
Let
one,
us
there is
then
no
record with the record, CAV.
no.
Give that also.
First one, there is no order. But the difference is in the first one, there is no ombudsman order. I came up just on getting the notice of hearing. In the other one, I've come up after
Yes,
the order.
That's explained in my last one.
But that's mentioned in the notes. Not we filed a common.
I will see. Thank you. Thank you.
Obliged.
5 and 6 same.
Same.
5 and 6.
Taken you know.
7.
Item number 7, my lord, I am for the petitioner. My lord, this matter has wrongly come before your lordship.
My lord, it is appearing wrongly. I'll indicate, my lord.
This is, my lord, group 1 matter, my lord. We have filed. Now, we have also not mentioned it. I don't know. Strangely, this matter has come.
My lord,
We are for
instead
the
of
petitioner, my
WPS
lord.
6951 of 24, wrongly WPS 6951 of 25 has been listed. That is why, my lord.
And kindly release it, my lord, and direct for the.
That the petitioner has mentioned for listing the matter being WPA 695
6951 of 2024.
but inadvertently but the record is 619 of 2024.
My lord, 6951 of 2025 is listed.
Listed 2025. List गलत है but
951 is in the list.
क्या बोला? Counsel for the petition submitted. He has mentioned the matter for listing. He has mentioned the matter for listing has to be mentioned being WPA number 6951 of 2024, but inadvertently in the list, the WPA number is recorded as WPA 6951 of 2025. Let the department is directed to correct the cost title of the writ petition in.
My lord, the cost title is.
My lord, the present petition has to be released from your lordship's determination.
On Monday.
Your lordship, may I?
Unless your lordship release this matter, my lord, which is on board today, we cannot get it listed before the appropriate bench, my lord.
No, this is the you are in the you are mentioning about the 25.
No,
Yes,
your lordship.
no, 24.
24.
Yes.
You are also in the 24.
No, my lord. Our writ petition, my lord, this is the writ petition of 2024.
Correct.
Yes. And that writ petition lordship now required to be released from your lordship's determination because this pertains to the matter related to group 1.
Okay, let it come on Monday. I will release it.
Interim order is
My lord, there is no interim order in that matter, my lord. That is the problem.
Lordship, may I indulge? Your lordship, may I request one thing, your lordship? Since your lordship, the WPA number 6951 of 2025. My friend is saying, your lordship, that his writ petition number is, your lordship, 6951 of 2024, but our is, your lordship, 25. But that is mistakenly come off, your lordship.
Before your lordship, it is listed today. Our 25 matters has come before your lordship, my lord, today.
So this is to be released.
This is to be released, my lord.
No, 2020. He is appearing along with you.
No.
Yes, my lord. Yes.
25.
So Neva said, I am not passing any order on 25. What? Who has mentioned
24. I'm so sorry. 24.
Yes, Mr. Chatterjee is also appearing.
25, your lordship.
I am appearing in 25 matter, my lord.
25 is not here, only wrongly mentions. Why you are not understanding?
Lordship, this was listed as 25 matters. That's right. Grateful.
The counsel for the petitioner submitted. that in WPA 6951 of 2024, the interim order is still today and prayed for extension of interim order.
Grateful, my lord.
The interim order is extended till 18th of December 2025 or until further order, whichever is earlier. It is not in the list. No. Why?
No.
Affidavit not completed. Let the matter appear on 18th.
There are two can applications.
Matter appear on 18th December. Okay, it will come on 18th December.
The interim
order in 24.
24th of, yes, 24.
24, not in 25. No. ऊपर जो लिस्ट करेगा ना 24 में कर ऑर्डर 24 में कर बट उसमें wrongly mention as 25
Grateful, my lord.
कथा आंसर तो होगा एक सप्लीमेंट्री correction 24 फिर इसका yes next it will be listed as supplementary. The order will
But I am for the Union of India, my lord, in this matter.
Lord, I am for the petitioner, my lord.
yes
My lord, in this matter, my lord.
why to be mentioned was mentioned why to be mentioned
My lord, already, my lord, new tender has been published. It's a tender matter, my lord. The respondent has already cancelled my tender and issued new tender. So that is, my lord, almost during filing of this writ application, my lord, bid has been submitted, and most probably, as per my information, my lord, technical bid and financial bid has been opened. That's it, my lord. In this juncture, my lord, I am just.
what do you want? Not proceeding?
No, my lord. I'm not pressing. My lord, just.
What you want? Why to be mentioned?
The contract cancelled on 10th of September and he filed the writ petition on 18th of November. Now pleading urgency before your lordship.
So that's why I'm asking why it is to be mentioned.
My lord, it has been mentioned as because, my lord, work order will be issued immediately. So, my lord, my writ application will be infructuous because, my lord, work will be progress. So that's why, my lord, my urgency is that to consider this writ application because there is arbitrariness, there is illegality on the part of the respondent authority. So, my lord, hence this writ petition.
Once you your tender was cancelled, tender notice was cancelled in September. You file the writ application
immediately after procurement of the documents, my lord, I have writ application as early as possible, whatever, my lord, possibility. Lord, I have filed.
But the work order is not issued.
I will just.
There is an arbitration clause, my lord, and I will argue, my lord, that when there is a disputed question of fact and there is the arbitration clause, the proper remedy is before the.
Unless the tender is not been accepted, how the arbitration?
I'm ready with the matter. If you want to, my learned friend want to argue, my lord, he may place.
No, to be mentioned, how it can be argued?
Just there is urgency.
I will not take the hearing on to be mentioned. Why you're not understanding? That's why I'm asking. You're not submitted that is to be listed as an urgent motion. You have mentioned that it is to be mentioned as a to be mentioned. To be mentioned whether hearing can be taken. Under the heading to be mentioned, any order can be passed. The counsel for the petition submitted, there is an urgency in the matter. And praying for fixing the matters urgent motion.
Only, my lord, kindly excuse me on 3rd, my lord.
In view of the submission made by counsel for the respondent, prays for fixing the matter on 3rd of December.
My lord, not on 3rd.
Not on
any day, my lord.
But 2nd.
Tomorrow, my lord.
Tomorrow's holiday.
Let the matter appear. Tomorrow I will take come.
No, sir, I have.
My lord, I beg to be for the respondent number 6, my lord. It's a private limited company, my lord. I will make my necessary submissions, my lord, on the written.
Let the matter appear on 2nd December under the heading urgent motion.
Lordship.
Next.
My lord, I beg to appear. My lord, this is a matter, my lord, I have sought leave, my lord, with regard to, my lord, allotment of a shop, my lord, BRS. But what happened is this, my lord, during the pendency of the license period, my lord, I have received a notice that I have to vacate the shop within 30th September.
Correct.
My lord, thereafter, my lord, during the interim period, my lord, I have made an application for renewal of the license. stating various clauses, and your lordship is aware of the fact that since clause 6 postulates that a license can be further renewed for a period of 11 months. Now that provision is there. Now what the authority has done,
when the agreement was entered,
annexure P2 entered on 1st January 2025, and it is going to expire on 30th November
2019.
2019 is the first allotment. Thereafter, time to time, it has been extended.
That's why last extension when?
The annexure P2, 1st January
Page number?
2025. 32, my lord.
32.
Yes. So it is going to expire on
Yes.
30th November. Now, during the subsistence of the license agreement, but I have sought for extension. Because clause 6 provides that the party on mutual terms and conditions can agreed upon a further renewal for a consecutive 2 terms. Your lordship kindly sees my license agreement, my application for renewal, that will be appear at page, my lord, yes. Annexure P7, my lord, page 46. I am running a cafeteria, my lord. I have invested a substantial amount of money in the business, and also I have a legitimate expectation that this time, since I have not committed any default or breaches of the agreement, that this time also they will renew. Because I have already, that assurance was given me. Your lordship, kindly see my application at page 46.
Correct, I gone through. Yeah, then.
Yes. Then, my lord, in reply, my lord, I will, my lord, page 48, what they have done, well, during the lease license period, well, they have conducted the auction, and that auction I was not allowed to permit it.
When the auction was published, when the auction.
Well, there was, well, that auction, your lordship will find only a notice they have served upon me. Well, kindly come to page 43.
43.
Page 43, annexure P4. That is the first notice of 17 May, where they have asked me to vacate the shop room. Well, in furtherance of a policy, your lordship knows that 2018 policy that I have to vacate it. Although, my lord, in the subsequent license agreement, there is no reference and mention about this particular policy.
Correct. So this is the notice. When the tender?
Page 43 is the
when
first
the tender notice was published.
Lordship?
When the tender notice was
No,
published.
that was not published. That was not. I have not been allowed to participate.
Okay.
Lord, I am still, my lord, running, and I have been the one of the allottee, but I have not been allowed. Behind my back, they have done that. But that is my first limb of argument. That is violation of natural justice. Because since, my lord, I am the stakeholder.
Next.
This is the first one. Now, your lordship, kindly turn to the next page. And page 44, annexure P5. This is the second notice. My lord, similar term. My lord, asked me to quit again within the period. My lord, same verbatim, my lord, that particular, that the policy, you have to vacate it by 30th September. Apart from policy, my lord, there is no whisper about the auction and other things, my lord.
44.
Yes, but on the next page.
It is with your case. No, it is issued to whom?
But it is issued to, yes, my lord, to me, Sushmita Mishra, my lord, I am the petitioner here.
Daughter subject to 5 years. Break period, so and so.
The same policy they have quoted.
Correct.
Now, my lord, my application for renewal has been turned down.
Correct.
My lord, there is also, my lord, no application of mine on the same ground. That big. So, my lord, today, my lord, firstly, my lord, the agreement provides for a renewal clause. My lord, when they have entered into the agreement with an open eye, my lord, both cannot simultaneously proceed. But nowhere in the agreement it has been stated that any point of time you have to vacate it because of this policy.
Okay, yes, madam. What is the
Lordship, the initial leave and license agreement was executed in 2019, Lordship. Now the policy says that up to 5 years. If your Lordship comes to page 43, Lordships will see that all the licensees who are who had exceeded 5 years, Lordship, were all given notices to vacate. Lordship sees 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 people were given notice. Page 43.
Page 43, vacation.
In the writ petition annexed to P4.
P4, yes.
Yes.
Acha.
Lordship, it is addressed to 9 persons, 9 licensee who has continued above 5 years. They have been asked. So this is where, and Lordship will kindly see that as per, I'm just placing that document as para 2, Lordship. As per, it is seen from records held with this office that you are running shops for more than 5 years. As per para 2B of the general policy number so and so, Army letter number so and so, dated February 7th, 7 February 18. License period allotment shall be subjected to 5 years, and as per GOI-MOD letter dated 25th September 2024, the existing licensee of entitled category may be allowed to participate in the third auction proceedings without considering the cooling off period. In view of the same, you are under the cooling off period. You are requested to vacate your shops by the 31st of July, as the shops will be put up in the upcoming auction. You are instructed. So that was the first notice. Pursuant to that notice, Lordship, they had challenged this and come. That matter is pending in item number 291. Lordship, my instructions are that my clients have not received this writ petition. I had called them this morning. They were not aware of that. So, therefore, what my learned friend is saying about the auction and the notice, Lordship, I am not in a position to submit, as they are not
I will
aware.
not serve the notice.
That is, Lordship, that is
Well, this matter. I have filed. There, my prayer for renewal has been rejected.
There is the notice of service.
Earlier, that is appearing as to
This writ petition has been served.
yes.
Where is the affidavit of service?
This is the affidavit of service.
Just check. Lordship, that is the information I got. So in that,
served upon the Union of India.
the Union of India served that.
Authority.
That is in the that is I got the brief from the Union of India.
No, it is.
But the concerned
not served.
no, that is why they have
The
not
service.
received.
Well, because I have got only 1 day, so I will serve in the meantime.
It is fine that the notice has not been served by the
Correct.
petitioner to the respondents. The petitioner directed to serve the notice upon the respondent. Let the matter appear on 2nd December.
Lordship,
Well, in the
second, I will not be coming to court, Lordship. Could it be on the third? Third.
well, in the meantime, since there is already that demolition, that is looming large.
No, you could have been served the notice. Why you are not served the notice?
Well, only 1 day I have got.
No, under the urgent motion. Next.
Just for till 2nd December status quo, only limited, my lord. Till 2nd December, it will be hard on that day.
Yes, next.
Lordship, I am for the petition, Lordship.
Yes.
Lordship, if you
My lord, before my learned friend starts, my lord, the tender process, which is under question, my lord, we have taken I'm for the WBS edition, we have taken a decision, my lord, to cancel the entire tender for several other reasons, not for the reason my learned friend agitated, my lord, for other reason, we have decided, my lord, to cancel the entire tender process. My lord, it has become infructuous now.
Lordship, I don't mind, Lordship, but
Okay, I am fixing next week. If there, I am recording his submission.
Yes.
If they will
It will be-
cancel, you get the
it will be uploaded.
Lordship,
It
one
will
thing,
be
Lordship,
uploaded in the site.
Lordship, one thing, they have finalized the tender. Monday, they are going to giving effect.
He's telling that it's
Lordship,
cancelled,
Lordship,
but
kindly-
recording his
Lordship,
submission.
not to proceed with this tender.
He is telling that they are not proceeding and they cancel.
Lordship, they are not proceeding. They will not proceed.
They can
Lordship,
cancel the tender process.
Lordship.
It will be then
Lordship, much obliged, Lordship.
Learned counsel appearing for the respondents.
Yes, my lord.
Lordship,
That
Respondent.
private respondent, one and two. Lordship, 1 and 2.
Respondent number 1 and 2 submit that the authorities have taken a decision for cancellation of the tender in question.
Lordship.
And as such, they will not proceed the present tender for the
Lordship.
present. In view of the above, the case is adjourned. Let the matter appear on 8th of December.
Lordship. Much obliged.
That the heading urgent motion.
To be mentioned, Lordship.
Let it be mentioned. Let it be under
To be mentioned.
To be mentioned, Lordship.
Next.
May please your lordship. We are for the petition, my lord.
Yes, what is the can?
Can you see, my lord, regarding restoration, my lord?
Yes, yes.
Restoration.
Restoration.
Yes, that is paragraph
There is the order
8,
of dismissal.
7 to 7, 8.
7th October, 24th October.
Yes.
Why you are not appeared?
My lord, practically this is our fault, my lord. Practically this is our fault. It was transferred to another court, my lord. But that court.
What is the prayer in the writ application?
Writ application.
What is the prayer in the writ application?
Writ application is the prayer for the release of the terminal benefits. The petitioner is aged about 70, 80 years. Lord, he represented many times. At least, lastly, he made a demand justice. With regard to that,
When he retired?
He was dismissed from his
terminated. So termination, he has been terminated.
Yes,
From the service. When he was terminated?
In 1997.
So,
no,
if he terminated, what benefit he will get, sir?
No, sir, with regard to the provident fund, gratuity and all these things, they will get that. That will, and he also.
1999 you terminated.
Yes, but he preferred a writ application, which was also dismissed in 2014 on default, my lord. It could not be restored as yet, my lord. So at least your lordship can see.
This is the second default.
This is the second default. This is it.
And when you file the writ application? When you file the writ application? 24. 99 you terminated, subsequently you file, that is dismissed, now this file 20. How you maintain the writ petition, sir?
My lord, your lordship can see the demand of justice was made. They have assured that they will look into the matter, my lord. That is the annexure. This is my humble submission.
When they are assured, show me when they are assured.
Annexure 8 of the writ application in 2023.
Show me the document when they are assured, which year they are assured that they will release terminal benefit.
Page 68 of the writ application.
Yeah, 68.
Page 68. Last two lines, my lord.
Yes.
We are, however, we are consulting our records and necessary action will be taken very soon in consonance with the records.
Yes.
But till date, my lord, 2 years have passed, my lord. That's why I have filed the application, writ application for release of the channel.
Bank is involved in this matter, my lord. Bank.
You are appearing for whom?
I am for the Union of India, my lord.
Who is for the bank?
We have
you served the copy to the bank? Of this CAN application is served upon the bank?
Yes, everything. This is the only the respondent 3-4 was returned with the letter with the remark that they have left. We have sent it again with another address.
To whom?
Respondent 3 and 4.
Managing Director, UCO Bank.
Others are served. All are served.
Bank is the main party here.
Yes.
Where is the service?
Huh?
The petitioner has filed the present application, praying for recalling of the order dated 24th of October 2025. The petition was dismissed for default for non-appearance of the petition. Counsel for the petition submitted on the date fixed. The advocate, the learned advocate appearing for the petition could not noted the list wherein the matter was fixed. Accordingly, he failed to appear before this court. Consider the submission made by the counsel for the party. The order dated 24th October 2025 is recalled. WPA number 2214124 of 2024. is restored in its original file. Can number sensor disposed of.
Next, we have fixed for hearing for any date fixed,
They are not ready with the brief. Why the court
No,
waste the time? They are not ready with the briefs. They have not sent the notice to the bank.
No, yeah, we have sent
Yes.
notice, my lord. We have sent notice, my lord. This is the kindly sit, my lord. When it will come in?
Not my application. But your lordship need not be bothered by the papers. They look bulky. But it's an application for impleadment, not in a writ petition. But my learned friend will ask for it. But normally my learned friend is very fair. I thought he's going to concede. I'm only asking for impleadment. But I believe my learned.
I'm for the Jute Commission.
But
Number 2 and 3.
I believe he also has no objection. But I'll just give you a lordship the back.
The affidavit is filed.
My lord, I am for the Union of India, your lordship.
First time it's come. So I'll say give my affidavit.
Not very innocuous. I'll just tell your lordship what it's about. It's a fight between the jute lobby and the sugar lobby. Now it arises out of the. Don't be troubled with papers, I'll take 2 minutes. It arises out of an act under which jute bags have to be used for packaging various commodities. Your lordship is perhaps familiar with it. Now, notifications come out after a study every year. Last few notifications have said 20% have to be used by the sugar industry. Now, they have not been making available enough bags and there were various safety issues involved. We filed a writ petition in Bangalore High Court. An interim order is passed. They are made parties. My learned friend who's the writ petitioner here, he's impleaded as a party. He appears. I'll show your lordship the orders if required. They appear. Now, thereafter there's been a final hearing and judgment has been reserved. But before that, what he does is he comes and, before the final judgment, he comes and files a writ petition over here, does not implead me as a party. I am the sugar lobby, and he obtains a ex parte order. Now, the orders which he seeks in this writ petition are enforcement of those government quotas. Now, and enforcement against us in particular. So that's why I'm a necessary party. I am going to be affected any which way. There are many reasons, technical reasons that we'll go into once I'm added as a party.
Have you filed an application?
Yes, this is the application. This is Can 1. Can 1 is not what is my application for impleadment. Now, your lordship knows the test. But the test on this is not very liberal. My learned friend possibly can't have a ground, particularly since I am the party affected. And he's done something unfair. After I had gone to Bangalore court, filed proceedings, there was orders passed there. He comes here, gets a order without making me a party. That's all that there is. Let me be impleaded. I'll file an affidavit. Matter can be taken up thereafter.
Yes. Mr. Mitro?
Well, I will give my affidavit. First time it's come.
Can. Have you received the copy? Can?
Yes.
That's
file my affidavit.
Yes.
There can't be any need for affidavit. What's the need? This is just a dealing tactic.
After affidavit, I will show how misconceived it is. Many documents I will.
So, his writ petition will then succeed.
My lord, I am giving consent. My lord, I don't have any objection if he impleaded as a party.
I am the writ petition. I am the carriage of proceedings. Who are you to give consent?
It ought to be dismissed in my absence. He's lucky that I have not come in asking for.
My lord, I am for the Union of India, my lord.
Union of India. You are appearing for?
No, my lord, I am for the Jute Commission. 2 and 3.
2 and 3.
But
then you are for 1. What about the other? Government of India, Ministry of Consumer Affairs, Director Sugar.
They've all been served.
Okay, let me file. How soon you will file?
2 weeks, man.
In that case, just give me this. That no steps should be taken without further notice to me in this petition. Otherwise, one more ex parte I'll be hit with. That's the reason I'm seeking impleadment. I thought it will happen on the first. Let them not get any order without giving me notice. That's fairness. That's fairness. Until he files an affidavit.
Not a party as yet. You have been
Correct,
appealing. You
correct.
have
But
appealing throughout.
behind my back,
Unless and until you've been impeded, how the order can?
but how can he get orders not against me? Not please see this. Not please see the unfairness.
If Mr.
But can I show your lordship two documents?
If Mr. Mitra client is doing anything, you come. You come.
But I will not come to know. That's Lord, please see the unfairness here. Lord, take one page from my Lord petition. Please come to page 130. Please come to page 130. 135. Please come to 135. Now, my lord, your lordship sees this is the order by the High Court over there. And your lordship will see Mr. Abhijit Mitra appeared. Now, my lord, after that, yes, that is a ground. After that, my learned friends come here, don't make me a party, and my lord, file a writ, which is, my lord, directly the subject matter of the writ over there. And they obtain a, my lord, ex parte order, which they are enjoying till date. So, my lord, this is the reason I've come in. Now, my lord, the point is this. If he is going to get further orders against me, not in a matter where I am a necessary party and the writ should fail without me there, then, my lord, at least I should be given notice before he takes any further steps.
Go and also you made an application over there.
My lord, I'm sorry.
You go and file an application over there.
They have not, it's disposed of. Disposed of with a, not disposed of with a direction. I'll show the order. Please see the order. Lost. If his song is to show the client that is one, let me show your lordship the order. There's a direction by the Bangalore High Court directing the specialist body to go into each of these before fixing a quota. That's the, so my lord, please, let's not go into it.
2 weeks within the court.
But in the meantime, please ensure that nothing.
1,200 page petition. Yes, 4 volumes.
Lord, in that case, please not ensure that nothing is done without notice to me. He can then say, I'm not a party.
Praying for addition of party. And council appearing for the petition, prays for time to file in opposition. Of can number 1 of 2020. Let affidavit in opposition be filed by 12th of December 2025. A reply, if any, there to be filed by 19th of December 2025. List the matter on 22nd of December 2025.
But just that small observation. If they do, they will give me notice. Not, they will give me notice. Not, I'm not asking for stay of proceeding.
Come if they. Yes, next.
Lord, in that case, Mr. Mitra, in his usual fairness, will move ex party once more.
Now give me the idea. You given me the idea.
Lord, may I file the affidavit of service?
Affidavit of service be kept in the record. Yes,
God bless.
next.
My lord, I apologize, my lord, for the advertence. Lord, I've got a translated copy, lordship, and I've served it upon the respondents as well. My lord, my affidavit of service and the translated copies there. The learned
Union of India, lordship.
my lord, he's here, my lord. I've given him a copy as well.
Who is for the state of West Bengal? My lord, that we have followed the direction, but the whole grievance is that for the Anganwadi worker, appearing for the state, my lord. Correct. My lord, that for the Anganwadi worker, there is a scheme launched by the central government to provide them a smartphone. So the 10,000 rupees that is being allotted. How you can avoid the memorandum of the government of India allowing the you're sending the 10,000 rupees in the account of the Anganwadi worker for purchasing of the smartphone. Kindly, my lord, this is the my lord direction, my lord, given from by the government. Yes, my lord, from the government to the all the district magistrates. By the ministry? No. From our state to the department.
I don't know. 28th March, page 76. Lord, that is the central government term. So against.
এটাই কি সোল এটাই না Yes. So, my lord, then as per the page 76, my lord, it is mere, my lord, and directive in nature for the.
You show me that you can override the notification issued by the government of India. Show me. I am accepting this instruction. The state government can override the memorandum issued by the government of India, which is the centrally sponsored scheme.
My lord, no, this overriding provision.
I am asking one question.
My lord, not my lord. It
Then-
cannot be.
Then you are supporting this.
But just for smoother, we have others, my lord, criteria.
Can you give the 10,000 to the Anganwadi worker? Go and purchase the phone. Your officers are the paralyzed.
Then, my lord, let me come back, my lord. May I just convey this, my lord? What has fallen from your lord?
30 November is the tomorrow is the last date. How you can give the 10,000 rupees to Anganwadi workers for purchase of a mobile phone? Where are your district magistrate and the BLO?
We have that with that
They are not able
criteria
to
and that
to distribute the same in terms of the guidelines of the government.
that's device, my lord, specification with the specification.
Might be specification whether you can give the government money to the private persons.
What has been allotted, my lord?
How you can identify? You are having a technical persons. Your district magistrate will sit and see the specification.
For that, my lord, there is
You take the instruction. Otherwise, I will pass appropriate order. All the district magistrates to be present before this court at 2:30.
My lord, let me, my lord, come back at
Fixing at 12. Take instruction if you're withdrawing this or not. Not even not withdrawing. Then 2 p.m. all the district magistrates to be present before this court, and be ready with the happened.
My lord, let me, my lord.
You're playing the game here.
May I talk and what they are proposing to settle, my lord?
Again and again, central government has given a notification to you, do this. And at the 19th hours, you issued a letter. You already forwarded the 10,000 rupees in the account of the Anganwadi workers. Here now, I will initiate the case and sending it to the CBI.
May I just come back?
Who has transferred this amount to the private persons by violating the memorandum of the government of India? Can you do?
May I just come back and then
Yes,
if you can satisfy.
I will take at 12. Path over.
Lord, shocking state of affairs. Lord, politicians filling up a water body and selling it. For the last 3 to 4 years, we've been litigating every order in our favor. Every order. There are injunctions, there is status quo, there is demolition order, but nothing has been implemented till today. My lord, now this is, my lord, an addition of party application, but for your lordship to appreciate it, my lord, I want to show, my lord, 3 documents.
Your Lordship, if
No,
if
and why.
KN7, Your Lordship.
No, I have an application. I want to move it.
I have been served with this application at 5:10 p.m.
Lord, he is
This KN7 application. This application which is referring to, this is a fat application served upon me some hours ago, Your Lordship.
Can7?
Can7.
This is not against him.
And this is the same application, same players in Can6. Which was.
Lord, I am not asking for his impleadment.
You are appearing for whom?
Your Lordship, I am appearing for the cooperative society.
I am not asking for his impleachment.
That we are goons. They are extortionists. He is not telling this. Let him show what locus he has with the property.
Let me see the prayer.
Let me see the
Can
prayer.
6 prayer and the can 7 prayer.
Let me see.
I am praying for prayer A.
Directions be passed by adding the proposed respondent. Who are the municipal commissioner?
Yes.
So there is a direction for filing affidavits.
Can 6, kindly seize your Lordship. What is the prayers at the
The
can 6?
petitioner cannot move.
Can 6, if someone is
No, this is
serving it few hours ago, your Lordship.
this is a sad state of affairs.
Come with instructions thereafter. Let me come with instructions. With this application, they had preferred division bench, your Lordship. Division bench said, though, because the matter is pending before NGT, matter to be decided on affidavits. Your Lordship ordered on affidavits. 17th is the date fixed for coming up with the pleadings. Your Lordship, with the same identical prayers, one more application has been made and it has been served yesterday. Your Lordship, kindly seize the prayer 6 and 7, how they are playing with the court.
Can 6? Can 6 achegi? Can 6. It's a can 7. Can 6? Can 7 hai baba. Ek. Can 7. 6 nahi hai.
Because the point that we are serving a protocol law to
Yes.
Kindly seize can 6.
He won't let me.
Can 6 is not there.
Can
Lord, after he exhausts himself,
may I serve?
I will, my Lord,
Kindly
submit.
seize for your Lordship convenience. What are the prayers and what order was passed?
Management will be formal appraisal for party.
Shundaravan. Few hours back. Yesterday,
35 p.m.
5:10 p.m. Even the prayer to serve the KMC was not allowed by this honorable court. They went up to the division bench. Affidavits were directed because the matter is identical matter is pending before NGT.
When the matter is
17th of December, your Lordship, kindly
the
seize.
returnable date.
It is on 17th of December, your Lordship.
17 December.
Affidavits are required to be completed.
What is the urgency?
Now, my Lord, may I submit undisturbed?
Yes, yes.
My Lord, in respect of filling up of, I am a lessee in respect of a water body. In respect of filling up of the water body by, my Lord, members of a cooperative society who are, my Lord, politicians at the helm of affairs of, my Lord, the KMC, etc., and local councillor of the entire area, we, my Lord, went to NGT. NGT, in terms of a Supreme Court order, directed an inquiry by a 8-member committee and said that if it is found that anything, my Lord, has come up on DAG numbers 267, DAG number 268, that, my Lord, has to be demolished and the water body has to be restored. Now the NGT proceedings are over. Now this 8-member committee was constituted but did absolutely nothing because of political pressure. This is when, my Lord, we filed a writ petition before this honorable court, and, my Lord, at least 8 to 10 orders were passed, one after the other. Kindly take up, my Lord, can 7. My Lord,
So at present, what you want?
at present, to cut the matter short, orders were passed directing KMC to, my Lord, complete demolition, etc. Now, what KMC did was, it, my Lord, put up 2 notices saying that I am taking over the water body. It was asked to, my Lord, restore the water body, demolish the structures, but instead of doing that, to ensure that that does not happen, and to frustrate the orders of this honorable court and the NGT, it puts up 2 notices to say, I am taking over the water body. So I filed an application saying, please give me leave to serve the Kolkata Municipal Corporation and pass orders for enforcement. That matter is, my Lord, pending. I filed an appeal. Lord, please see the appellate court order once, which is why I have filed this application. My Lord, page 434. This goes up, my Lord, from Can 6, which is what my learned friend wanted to refer to. Can 6 is pending.
Correct.
My lord, first prayer is leave to serve KMC. I, my lord, didn't, my lord, get any relief because KMC is not a party. Now, when, my lord, I go up in appeal because I urgently want reliefs, the appellate court by an order of 4th September 25 says, paragraph 9, appellant did not apply for adding KMC as a party respondent in such writ petition. Learned single judge is yet to decide the application finally. Learned single judge has directed affidavits to be filed. So, my lord, the argument over there is what is leave to serve have to be added as a party to the writ petition. So now I file this, my lord, Can 7. My lord, please come to paragraph 30, prayers at page 35. And I have served KMC.
Yes.
Let direction be passed for adding the proposed respondent, namely Municipal Commissioner, Kolkata Municipal Corporation, as in the array of parties. That's all. And B, my lord, is amendments to be incorporated. My learned friend, who's so vociferously, my lord, opposing. No, I have to finish. My lord, we are not.
Amendment of any averment, something else, but no copy has yet been served upon us.
I just want them to be added as a party.
I will hear it, yes.
Now, my lord, this is all that I want because of the observation of the division bench. Now, my lord, why do I need KMC to be added as a party? My lord, please have a look at page 38. I'll be very brief, 2 minutes, my lord. Please see page 38. This is the NGT order. Now, my lord, please come to page, I'm sorry, my lord, please come to page 47, paragraph 22. In view of the above, we consider it necessary to direct an 8-member joint committee of National Wetland Authority such and such to, my lord, ascertain the factual position about the status and extent of the wetland and whether prohibition against construction applies to the area in question. If prohibition is applicable, remedial action for protection of the wetland in question be taken by the concerned statutory authority. The CPCB and the state authority will be the nodal agency. Committee may undertake visit to the site, etc., etc., take further measures in accordance with law, may conclude its proceedings within 3 months. In view of our prima facie finding that the area is a wetland and prohibition against construction is applicable, pending further action, no further activity be undertaken in the area in question, including DAG number 267, 268. If the committee finds constructions are in the prohibited area, committee will ensure removal. Now, my lord, this is January 22. Yes. Time given is 3 months. My lord, nothing happens. So, my lord, we file a writ petition before the same writ petition we file. First order is in September at page 49. This honorable court takes cognizance of the matter. Now, please see page 49. Page 49 at 50. My lord, third paragraph. After hearing learned counsel appearing for the parties, this court is of the view that in order to ascertain whether committee has indeed failed to carry out directions of NGT, committee shall file a report bringing on record acts of compliance in terms of direction, etc. And this been communicated. Now, report is thereafter filed at page 51. My lord, please come to page 57.
Yes.
This is, my lord, an interim report. My lord, please see, my lord, 57, third paragraph, interim report was submitted by the joint committee. The ADM and DL and LRO construction work on DAG number 268, which is BIL. BIL is water body.
Where?
My lord, 1, I. at page 57, my lord. As per ATM and DLRO report, construction work on dark number 268, which is bill, has been shown as dark number 267 in the documents given by KMC. Important, not please see duplicity of KMC. Then KMC has lodged 2 complaints. Then not please see paragraph 5. Shocking. KMC officials claim that as per the act, they do not require to check any records of the applied plot from the end of the BLN LRO to ascertain the land classification records. So, my lord, because a politician applies for, my lord, sanction of a building plan on a water body, KMC will not look. Now, my lord, please see the final findings at page 61.
Yes.
My lord, please, this is totally, my lord, gross. From the master plan, from the master plan, my lord, such and such, the eastern portion of Ukil Bhedi, then two newly created plots by filling up Ukil Bhedi. 3, inspection report of West Bengal Pollution Control Board along with photograph confirms that the eastern side of Ukil Bhedi has been partly filled up by construction debris on the eastern side, which is annexed herewith. 4th, report of ADM and DLRO dated such and such at point number 2 states construction work of 2 buildings were found to be under process in eastern portion of RS plot 268. G+4 building appears to be completely full of residents. Other buildings have risen up to 4th floor. Construction work has not been completed. 2 buildings are on RS 268. Then alleged land at RS 268 is nowhere mentioned in the deeds of the Cooperative Housing Society. That is my vociferous learned friend's client, available with this office. Most of the land on the eastern side of 268 and almost all of RS plot number 267 is occupied by members of Metropolitan Cooperative Housing Society, both water bodies. Finally, the committee and then Kolkata Municipal Corporation has submitted copies of complaints on such and such with the Pragati Maidan against filling up of Ukil Bedi. KMC issued notices under 401 against such and such. Nothing done. And this is, of course, an innocent man.
Yes.
Now, my lord, please see the final directions. This is, my lord, very, my lord, telltale. Plot numbers such and such have been created after 2013 by filling up of water body, that is Ukil Bhedi. Hence, they need to be demolished. 2. KMC shall take steps to immediately restore the water body in compliance with the order of the Honorable NGT. 3. After restoration of water body, KMC shall take management control of the same in accordance with the Fisheries Act. KMC will demarcate Ukil Bhedi boundary with concrete pillars with geotagging, shall submit a compliance report. Now, my lord, against this direction that they will take over the management control to that limited extent, my lord, I file this writ petition saying that I am lessee. You can't take away my rights. And I also, my lord, want enforcement. So in this writ petition, my lord, please see page 50. I'm sorry, my lord, please see page 118 and 119.
118
of this writ petition, my lord. The first order. So, my lord, the Honorable Court says, we will consider your exception, but immediate implementation. The first part itself, my lord. It's in 3 parts. First part itself, page 118. I am only taking exception to that part, KMC taking over, because I am the lessee. My lord, please see, 118. Learned counsel appearing for the petitioner seeks to take exception to a part of the report. Such exception to be taken within 2 weeks. List this matter on 2nd December. Authority shall be at liberty of implementing part of the report and shall not be interrupted in their work by reason of pendency of the writ petition. Then, my lord, next page, page 119, second order, at page 1120, second paragraph. As clarified in the order passed on 15 November, authorities shall implement a part of the report with regard to taking steps against illegal construction. Clear direction. Now it shall be made clear that the concerned respondent shall be at liberty of taking police assistance. Now, my lord, I file an exception, etc., etc. We discover subsequently, my lord, construction is still going on. So we file can number 3. My lord, prayers are at page 145. And the order is at page 148 on can 3. Injunction, my lord, is granted at page 150. I'm sorry, 149. And all these members of the cooperative society, 149, my lord, second last paragraph, upon considering submissions made by learned counsel appearing for the applicant, as well as 8-member committee and the private respondents, this court is of the view that immediate measures should be taken for ensuring that no further construction takes place in the plot numbers in which the applicant writ petitioner is interested. Now, my lord, allottees start coming and filing applications which are dismissed. I am not, my lord, on that. Now, please come to, my lord, again construction. Oh, I'm sorry. Please, my lord, see the photographs, volume 3, page 345.
Okay, now you want only for the implement.
Only implement. My learned friend, my lord, because I want enforcement subsequently. He is for the cooperative. Yes, he has nothing to say.
Yes.
Your Lordship, this is a cooperative society formed in the year 1970s. Your Lordship, it's a plot-based cooperative society.
Correct.
Your Lordship knows very well at that point of time only RS Dags were there. Subsequently, with the implementation of the West Bengal Land Reforms Act, these RS Dags were...
One sentence I missed out. Just one document. Then your lordship will, my lord, understand the problem. My lord, please have a look at page 278. Just one document. My lord, this is deed of conveyance. Of the society to one of its members. Please come to 278. Yes. Shaptarshi Chatterjee, son of Shobhan Chatterjee. Then, my lord, page 248 is Ratna Chatterjee, the wife of Shobhan Chatterjee. Then, my lord, 308 is Councillor of Behala. And these are all sales after the NGT order. Now, and the reason why, my lord, we are moving fast and we need, my lord, interim protection is, after all of this, what, my lord, is done by the KMC is page 173. Instead of implementing, they have put up a notice saying that the water body was being mismanaged and therefore show cause in the newspaper and we are taking over the water body. So, my lord, this taking over for Shobhan Chatterjee by the KMC is for the purpose of protecting him from all orders passed by your lordships and by the NGT. And that's why I want KMC to be implemented. And my learned friend is appearing for the cooperative run by Shobhan Chatterjee.
Yes. May I, your lordship? The deed which he has referred to at page 276 is of the year 2015. That was prior to NGT's order, even when there was no proceedings. Your lordship, in 2015, my learned friend's client's father wanted to fill up this water body. Police case was filed. He was stopped. He was charge sheeted. This person's father was charge sheeted because he tried to fill up the water body. This is his history and background, your lordship. Second thing is that, your lordship, the second point is that this cooperative society.
What is your problem for implementing the municipal corporation?
Your lordship, my, your lordship, I shall.
I am not going into the merit who has fault, who has not yet fault. Once in the NGT orders also there is a direction upon the municipal authorities, and subsequent orders also there are the report also consisting of the municipal authority. So why the division bench also held that yes, they cannot interfere because the municipal authority is not a party. So if the municipal authority is impeded, what harm you will face?
Your lordship, I cannot be booked for a single thing allegation, which according to them is an allegation, before different forums, Your Lordship.
They are not
Different
asking
forums.
against any order against you at this stage.
Your Lordship, there is
can
an
number
NGT proceeding pending that has also been recorded by the division bench. While Your Lordship kindly sees the order of the division bench which they have referred. The reference to the division bench.
That's why I'm asking you.
Your
First you
Lordship,
satisfy this court.
I have to.
What is the harm if the municipal authorities is been implemented? What prejudice will be caused to you?
The prejudice will be caused because the NGT proceedings, the municipal authority is a party.
Correct.
A proceeding is going on regarding challenging this 8 members committee's report.
Correct.
There may be some judicial order from the end of the NGT. And if parallel proceedings, by adding NGT a party to the proceedings, when the scope of this writ petition was very limited. Kindly see the initial prayer. The initial prayer in this writ petition was.
The court is not going to dispose of passing any order on merit at this stage. Only the question here with regard to whether the municipal authority will be implemented or not. They are the petitioner. They are the persons who can say yes, they are the necessary party. Now the court has to see whether they are the necessary party. So that's why I'm again and again asking why you are restraining the municipal authority to on record.
Your Lordship, kindly bear with me for 2 minutes, Your Lordship. I did not interfere when he was making his submission. Your Lordship, I will definitely come to what.
Putting a specific question.
Your Lordship, I shall reply. If Your Lordship see.
Why you are shy? Why you are shy?
Your Lordship.
That the authority
Your Lordship,
should be treated as a party.
in the earlier round of litigation,
You are not appearing for the municipal authority.
12605, there was a writ petition filed by on the same issue. The KMC has already been directed to take certain steps by this coordinate bench. Your Lordship, there is proceeding. Your Lordship, now kindly sees the background of this case, Your Lordship. 1970, this cooperative societies was formed. Several dags were purchased. It's a freehold land. Developments were made when it was dag numbers 267, 268. Your Lordship knows that thereafter LR Acts came in. The direction for affidavits have been directed in Can 6, wherein the land department has bought in the LR dag numbers, wherein it is seen that 95% of this land was already converted as Vastu in the year 1980 itself. Now, second thing, they are saying why the KMC authority did not look into the dag numbers. Your Lordship knows that the KMC Act, the LR Act itself excludes the jurisdiction of certain ward numbers from the KMC authorities. The KMCs are not required to look into. Thirdly, Your Lordship, he is claiming himself to be the lessee. During this short argument, he has thrice claimed himself to be the lessee of the Ukil Bedi. Kindly ask him to show a single document that he is the lessee of the property, and I will not make a single submission, Your Lordship. At one point of time, they had claimed that they are the owners of the property. Thereafter, when we asked for the documents, they claimed that they are the lessee of the properties. Thereafter, in one of the application in Can 6, they have said we are the occupier/lessee, and not a single piece of document has been annexed to show that they are the lessee of the property. If Your Lordship is going to pass an order, Your Lordship kindly decides what is his locus and what is his intentions, Your Lordship. His locus to prefer this application. He has claimed thrice that he is the lessee of the property while making this. Your Lordship, this Sabbosachi Malik.
Can 7 is filed by whom?
Sabbosachi Malik Chaudhary.
This Can 7 is filed by whom?
This person who has no locus. Writ petitioner.
Whether the writ petitioner is debarred for filing an application for addition of the party. And at the time of addition of the party, the court has to decide what locus. Once the court has already been passed several orders, went to the appeal, that point has not been raised by you.
Your Lordship, that point has been raised. Kindly sees the appellate court. Your Lordship, kindly sees the appellate court order.
Petitioner, several orders have been passed since 2022. The matter is pending. Now you are telling that for filing the Can 7, the locus of the petition is to be seen.
Your Lordship, kindly sees the division bench's order. Kindly sees the
first you clarify your submission, sir. In the Can application, when the locus of the writ petition can be challenged.
Your Lordship, a fraud has to be pointed out at any stage when he has made this is a fraud. Kindly ask him to show that he is the lessee.
You are telling that a fraud.
Your Lordship, he is saying if you would have said that I am the writ petitioner, I want to add him myself as a party, that is something different. He has thrice claimed himself to be lessee while making submissions, Your Lordship. He cannot be allowed to make fraudulent submissions before the court.
So that's why I have already specified to you. The court is not going to pass any order. Only court is dealing with the application for implementing the municipal corporation as a party. I have already clarified this. The court is not going to pass any order on merit.
then Your Lordship kindly seize the division bench's order in the manner I want to place it. Kindly seize the division bench's order.
Yes.
And prior to that, kindly seize the order against which the division bench's order was preferred, Your Lordship. 4/9/2025 order is of the coordinate bench, Your Lordship. 4/9/2025.
That is the page number 431.
Oh, I'm so sorry, Your Lordship.
49 is the division
Your
bench
Lordship,
order,
I'm
and
so sorry.
8
I'm
August is the signal bench.
I'm so sorry. I'm so sorry, Your Lordship. I'm just placing it, Your Lordship. Kindly seize. This is Your Lordship's order. There 8/8/2025 order, Your Lordship.
Yes.
The CAN 6 order.
No, page. Your
Your Lordship, this is the orders, Your Lordship.
Yes, order dated
8 August 2025. Kindly seize the order. This is regarding CAN 6 of 2025. Mr. Acharya, learned advocate, appearing on behalf of the writ petitioner applicant, submits that the present application has been filed to bring certain subsequent developments and/or events to the notice of the Honorable Court.
Yes.
According to Mr. Acharya, in order to render complete justice, the replication deserves to be allowed. He further submits that the applicant has also averred in the application that KMC ought to be impleaded as a party in the present writ petition.
Correct.
Impleaded. As its presence is necessary for the effective adjudication to the list.
Correct.
At the outset, Mr. Sen, learned advocate, learned additional advocate general, and Mr. Sureka, learned advocate, appearing for respondent number 9, this is my society, conjointly submitted that this application is not maintainable.
Yes.
Mr. Sen submits that by filing the present application, the petitioner seeks to enlarge the scope of the list, and the subsequent events which the petitioner wants to bring to the notice of this court have given rise to a fresh cause of action. The petitioner can maintain a fresh action before the appropriate forum. He further submits that the amendments made in the application suggest that KMC adopted a policy and in furtherance of that policy took the subject matter of the present writ petition, namely a water body, for certain purposes.
Correct.
Mr. Sen submits that the prayer portion appended to the application indicates that all prayers or reliefs sought by the petitioner are ancillary to the incident of the corporation, taking control of the water body. He submits that unless the action of taking over of the water body is challenged, the petitioner cannot claim any relief consequential thereto. Lastly, he prays for leave to file affidavit in opposition. Mr. Sureka, learned advocate, representing respondent, adopts a submission, so and so, so and so. In view thereof, respondents are at liberty to file their affidavit in opposition in regard to CAN 6, which was for implement of the KMC, and we were given the right to reply, Your Lordship. Thereafter, this order was challenged before the Honorable Division Bench, Your Lordship.
Yes.
And what was the view of the Honorable Division Bench? 4/9/2025, this order was challenged because implement was not allowed at that stage. Appeal is directed against an order dated so and so. Appeal is at the behest of the writ petitioner. Learned senior advocate appearing for the appellant submits that appellant is a lessee of a water body. In respect of such water body, there are proceedings pending before NGT. NGT formulated a 8-member committee to look into the allegation of conversion of water body. He submits that a portion of water body is filled up and dealt with inappropriately. There are structures which KMC sanctioned in respect of an area which was illegally filled up out of the concerned water. What allegations which they are now making was already submitted before the division bench.
Correct.
Learned senior advocate appearing for the appellant submits that the learned single judge erred in granting the interim order. He submits that the direction of the 8-member committee of NGT is that the illegally filled up area should be reclaimed and that the water body should be restored in its original form. He submits that KMC authorities cannot be trusted to undertake, this is the same submission, to granted sanction in respect of the structure to be made on the illegally reclaimed portion of the water body. Learned advocate appearing for the respondent number 9 submits that there is an application pending before the NGT taking exception to the report of 8-member committee. State is represented. The writ petition is still pending. In the pending writ petition, an application was filed by the appellant as the writ petition seeking various directions on KMC. KMC is not a party respondent in the writ petition. Appellant did not apply for adding KMC as a party respondent in such writ petition. See, learned single judge is yet to decide the application finally. Learned single judge directed affidavits to file. We do not find the exercise of decision. Your Lordship, now if Your Lordship allows addition of party at this stage, according to me, it will be in the teeth of the order passed by the Honorable Coordinate Bench and the division.
When the other matter is fixed.
17th December, Your Lordship.
Have you filed the affidavit?
Your Lordship, our affidavits are complete. Our affidavits are complete, Your Lordship.
You want to file affidavit or that affidavit will take a...
Our affidavit is complete in regard to Can 6, Your Lordship. And they are supposed to file their reply. If their pleadings are completed in respect to the Can 6, Your Lordship, I will be the last person to object to the adding of the KMC as a party to these proceedings, Your Lordship.
Yes. What is what?
The respondent number 7. State the listing magistrate is concerned, we have filed our affidavit. In terms of the earlier order, on Can 6 is concerned. Number of the so far water, the respondent number.
You are appearing for whom?
I will here for respondent number 7.
7.
Respondent number 2. The minority
Wetland authority.
I do not know what starts or not, but they are also necessary. So they should be represented in this matter. Wetland authority. Now, the original concern of the stating everything. Whatever we have stated before the court and the judicial bench, and then our stand in effect in our affidavit, it has been served. They have not yet filed the reply. I think so. Simple thing is that at this juncture, today, rightly or wrongly, whatever done by the authority concerned or the party concerned, private respondent. Now the question is, my lord, the Can application 6 is pending. And in that Can application 6, my lord, whatever be the the prayer, but the actual prayer is that the whether corporation can be added as a party, and they should be served the copy, and they are the appearance is necessary. But at this juncture, when
we have done that
pending, and there's a direction for filing application, and one of the appeal court also refused to entertain, because against kindly consider one thing. Against that simple order of direction to file affidavit, so that Can application can be taken up. 6. Against that order, appeal also kindly consider one thing. The appeal court otherwise refused to entertain. Then the otherwise Can 7. So,
no, with regard to Can 6, and that is not decided whether the notice is to be served upon the municipal authority, only with regard to interim order. In that case, they have not prayed for impleading the municipal authority as party, only they have prayed for issuance of the notice.
It was recorded, Your Lordship, by the coordinate bench that their prayer is for implement of the party, Your Lordship.
Maybe, but no, I am
Your
telling
Lordship, they had pressed it. They had pressed that application.
So, but when the matter came before this court, when I have taken this on the last week, the matter is taken. So, this court is of the view, they have prayed for issuance of the notice. The notice could not be served once you have objected, the affidavit direction is passed. Now, they have filed this at 7. So, let the both applications, the 17, the matter is let the both applications be taken up for hearing.
The problem, I've served KMC, KMC is present. Now, the argument is that all the directions, my lord, by this.
Yes.
Me. One of the so far my lord Can 6 application was concerned. Here, my lord, they highlighted a press development that the KMC they have put up the board that
That's why once the 6 is disposed of, if the whole prayer is taken into consideration, automatically 7 will become in
Your Lordship, kindly seize your order dated 11th November 2025.
That's what I'm telling.
Your Lordship had said that no notice to the KMC will be served.
Because you have objected.
In contempt of Your Lordship's order, they have served they had the audacity to serve upon the KMC. Kindly seize. Your Lordship, kindly seize 11th November order. Your Lordship, kindly seize the paragraph 5 and 6. Kindly seize for once. Your Lordship's order of 11th November 2025. Kindly seize their audacity and their hyperness to extort money. Kindly seize 11th November 2025 orders.
Yes.
Paragraph 5 and 6, Your Lordship. The learned counsel for the petitioner submits that the petitioner has served the notice upon KMC, but the KMC is not appearing. It is found that in Can 6 of the so-and-so, prayer A is to serve the copy of the application to the KMC. The court finds that the respondents are objecting to serving of the KMC Thus, this court is of the view, unless and until the application is not heard on merits, the exchange of affidavits, no notice can be issued to the KMC.
Correct.
Despite such order, your lordship, because this order was passed considering the division benches order, because they had earlier mentioned before your lordship without indicating that there is a division benches order. When we had pointed out that there is a division benches order, then your lordship had recalled this order. And thereafter, they had the audacity to serve this KMC. They are trying to put the pressure, your lordship. They are 6 and 7 are identical players, your lordship.
Okay, let's come on 17. Come on 17.
Milord, I have served 7. There is no question
Okay,
of
no,
content.
I am not taking
Milord, now
up.
may I just indicate 2 things. Order of NGT and order of this honorable court in the writ petition directs, Milord, implementation of the report. All the report, Milord, requires KMC to perform acts. Nothing has been done. So for that
That's why
to happen,
when the 6 will be taken up for hearing, the court will take a, if the court will find there's a
and Milord, only
the
now,
necessary
Milord,
party,
please-
automatically your 7 will be automatically
Milord,
disposed of.
yes, only thing is when the matter is taken up for hearing, they'll come and say that KMC is a necessary party. Without KMC, this can't be done. So the only objective, Milord, is to delay. Milord, just have a look
Correct, correct. That's what I'm telling Mr. Chaudhary. Let come on 17. It matter. It is
17th.
17th of this.
Milord, please have a look at page 345 once. And your lordship will understand why, Milord, I am crying before your lordship. These houses are built on water bodies. 345, 346, 347, 349.
Correct.
These are built on water bodies.
Yes.
They will fill up these houses with people, and your lordship will then, Milord, have difficulty in directing demolition where 5,000 helpless people have paid money to these politicians to buy houses. This is the reason. Milord, court is human.
See, if the persons
Now-
are purchasing the property or
Now, Milord, see, now
This
please,
has not been constructed by
please,
us.
no, no,
This
please.
has not been constructed by us.
please,
If you
please,
go on
please,
misleading the court,
please,
that's
miss,
better.
I don't know.
If you go on misleading,
My
that's
Milord, please, Milord, give me 1 minute.
without any
Hey,
substantive
what
proof.
are you saying?
I am saying the correct thing.
Come,
Your-
come, come.
I am
your
misleading.
findings are extraordinary.
Milord, no, please.
Come on
No, no, no.
17.
Please see page, Milord, kindly see page 439. Milord, please have a look at one page. They're taking water out of the water body.
Of 2025.
For the purpose
praying
of
for
restoring it.
the
Right,
Kolkata-
And they're Milord, please have a look at page 439.
want to stop the restoration of
in
water body.
WPA number
Sell it off to promoters.
of
They want to sell it
2022.
off to promoters.
Full stop. Learned counsel for the respondents submit that the petitioner has also filed an application being can 6 of 2025 wherein
Milord, let KMC file an affidavit at least by that day.
said
They
application
are not even a party as on date.
the petitioner has prayed for leave to the petitioner leave to serve copy of the application to the Kolkata Municipal Court. By an order dated 11th of November 2025, this court has passed this court by an order dated directed that no application was of the view that the respondents are objecting for serving the copy of the application to the KMC. Thus, this court is of the view, unless and until the application is not been heard on merit, after the exchange of affidavit, no notice can be issued. Now, the petitioner have filed the application being Can 7 of 2025, praying for implementation. I am pleading the Kolkata Municipal Corporation as party respondent. Considering the above, this court find that the prayer made in the present application more or less similar with regard
Milord,
to
this is for addition of party. That was for
more or less in pleading
leave
the
to serve notice.
Kolkata Municipal Corporation as party to the this by an order dated the matter is already fixed on 11th of November 2020 on 17th of December 2025 at 2 p.m. under the heading especially fixed matter. Let Can 7 be also placed on the same day for hearing.
Milord, I have served KMC. If they want to object, let them at least file an affidavit. Otherwise, on 17th of December, they will come and please.
Don't shout.
No, please.
Mr. Chaudhary,
Dominate me.
No, my lord,
Once
please
the
appreciate
Once
this.
this court has already passed an order in Can 6, the municipal no notice can be issued at this stage unless the Can 6 is disposed of. Now you filed an application Can 7. I was
Look,
there
Can
for the
6
several
is
years.
not.
How the practice used to be done. Let on 17th this Can 6 be decided. Once the Can 6 is decided, automatically your Can 7 would be disposed of.
My lord, may I request for a preponement of the these are environmental matters.
Court, that I am taking.
Court has to, my lord.
Ghosh was there on that day.
I'm sorry, my
in
lord.
presence of Mr. Ghosh, the time.
No, I know, but my lord, please see the situation. If court doesn't protect the environment, who will?
The matters before this court are urgent matter.
I know, but environmental matters, court gives special precedence.
I have given 17 December.
And this is a matter where, my lord, directions of court are flouted by politicians.
15 days is there. Come on 17. I fix especially at 2 p.m. I will hear all the persons. You already argue the matter.
Now, my lord, one last request. My lord, KMC is present today. My lord, on that date, if KMC comes and asks for time, and on the
not allow, I am telling in the open court, unless and until I will dispose of the 6, I will not hear the KMC. I am in the open court. I am sitting here with the open mind. I am telling you.
6. Now, my lord, 6 has.
6 is the main application. That is, if the 6 will decide, the notice is to be issued upon the KMC. Your 7 will be automatically infractuous or treated as a disposed of. Let come on that day.
No, my lord, the only difficulty is by the 17th, my lord, KMC is proceeding for the purpose of emptying the water.
If you prove that automatically all the things will be demolished, if you prove that.
No, the rest of the water body.
What can be done once you.
My lord, I am sorry, my lord.
Once this court has refused the interim order, that has not been touched by the appellate court.
My lord, but interim order was refused on the ground that KMC is not a party. Now, when I come to make KMC a party.
So on that day, why you not come with a 7?
No, on that day I said notice be issued to KMC. Today they oppose. Today I want addition.
Okay, I will.
No, my lord, addition of party prayers.
Mr. Chaudhary, it is enough. Yes, call the next one.
Your Lordship, I'm appearing for MOEF in this matter, Union of India. All copies may be served upon us, Your Lordship.
You communicate to the other party, they will serve the. If they
write to us, we'll give them.
Your Lordship.
Not here. Respondent is not here.
He was here.
Respondent नहीं है. Respondent is there or not?
He was here.
ये बहरा है. ओए, तो बहरा है.
Yes.
You are not hearing. Record. The petitioner has filed the presented application. Praying for a direction on the respondent authority for providing
respondent number 1, Lordship.
along with all necessary supporting tools and infrastructures to all members of the petitioners. Petitioner number 1, in terms of the guidelines dated 13th January 2021 and 28th of March 2023, and all consequential guidelines and all subsequent guidelines issued by the respondent number 1 for implementation of portion P capital OSH all capital portion 2.0 is petitioner 5, a memorandum dated 13th of January 2021, the Government of India, Ministry of and Child Development, Sastri Bhavan,
Yes.
My lord, kindly feel that we are not violation of any Union of India's order. The 16th May 2025, where the government of India and it has modified the program by saying, Para 2, the minister received representation from various states undertaking regarding the implementation of bring your own device policy for field functionaries, where the field functionaries, namely Anganwadi workers, supervisors, block coordinators, may be allowed to bring their own smartphones for the scheme work and are provided funds for the purchase of such smartphones as per existing cost norms. The matter has been examined. It has been decided that can also opt. So, in terms of this legislation and in consideration of the difficulties the state missionaries were facing, this thing has modified and pertain to this.
Yes, madam.
My lord, the difficulty, my lord, I will indicate. My lord, this was not.
You suppress the fact.
My lord, this was not within our knowledge, lord.
So,
it was not. My
For
lord,
the
there
last
is no
3 days, you are
suppression.
wasting the time of the court.
My lord, there is no suppression, lordship. This was.
How much cost? Tell me.
My lord, there has been no suppression, lordship. Kindly hears me, my
The
lord.
16th May, you affirm the affidavit on.
I understand, my lord, but this, my lord, was not brought to my knowledge. My lord, it
If
is
it
not
is
even to the
brought
knowledge.
what is the duty of the petitioner? First, you collect the
I agree.
document, then you file the writ application.
My lord, I agree, lordship, but my lord, kindly considers, my lord,
When
these are
you file
workers.
the writ petition?
Lord, I filed it, my lord, in
September 2025.
Yes, this
and
was not.
This
But my lord,
notification
I will still, my lord, I will ask, my lord, for 1 day accommodation, and I'll take instructions from them. Why, my lord? This notification, my lord, it does not say that I have to follow the specifications that is there in the 28th March.
Kindly see.
Well, I
the
don't even have
matter
a
has
copy
been
of
examined
this.
And it has been decided the state of unity can also opt the BYOD. BYOD means bring your own device.
Yes,
That
but
is
my
the
lord,
only scheme.
it holds me liable, my lord, because it is not possible for a layman to go and purchase a mobile phone.
So you challenge this.
My lord, I will file a supplementary and challenge this, my lord. My lord, I will withdraw and file a fresh
With the
petition
cost,
challenge it.
with the cost.
My lord, kindly does not
3
impose
days,
cost.
3 days time has been wasted.
My lord, yesterday, my lord, lordship had taken up the matter, my lord. And in all fairness, my lord, these are poor
Mentioning
women.
that 3 days
My lord, these are poor women across the state, my lord.
If you are
My
not
lord,
having the
they were not, my lord, it was not within their knowledge, lordship. I am withdrawing it and I will file a fresh writ petition. My lord, on this
One instruction, my lord, orally.
now.
My lord, when I just for that, my
Why
lord, I was talking.
First of all, why you are not bringing this document?
No, that is the difficulty, my lord.
When the court has given
no,
them.
my lord, since this issue was, my lord, long been pending for 2-3 years. Now the department is saying that our representative also there, and this it is with well within the knowledge of the Anganwadi worker.
No, it is not.
That this is the situation for that.
But you are not mentioned in any of the.
No, that is the my instruction was in. My instruction only this page that DM.
So the
Yes,
further direction you not mention
only
anything about this.
yes.
This notice.
Only since they said their voluminous records.
My lord, if lordship will grant me, my lord, I can bring this on record and my lord keep my writ petition alive.
The council appearing for the state has handed over a memorandum dated 16th of May 2025, wherein the Government of India, Ministry of Women and Child Welfare Department, Poshan Abhiyan, has examined the matter and decided that the states/UTs can also opt BYOD, capital BYOD, within bracket, bring your own device policy, full stop. Thus, the ministry has given liberty to the state and the UTs either to continue to procure smartphones centrally as per the existing guidelines or implement BYOD policy. Let the memorandum be kept with the record. Learned counsel for the petition submitted. Just only she got the memorandum dated 16 May 2025, accordingly pressed for time. In view of the submission made by the counsel for the petitioner, case is set down. Let the matter appear on 8th of.
My lord, this is the, my lord, will it be, my lord, any, my lord, benefits for the petitioners? We have followed the central government's order. Now she will, my lord.
And madam, you are for the Union of India. You are also not assist this court. There's a notice.
I did not get the instruction, Lordship. That is why I could not
You are
able to
appearing.
advise the Lordship.
What is going on?
The petitioners are not aggrieved by any means,
Of
not
course,
by
I
any
have
inaction.
on record. Well, grateful, Lordship.
Next.
Grateful.
Grateful, Lordship.
Pass your matter. Fixed matter है ना 12 बजे का.
May I please your lordships? My lord, there's a short point for my lord's consideration. I'll formulate it.
I appear for the private respondent numbers 1 and 2. The writ is directed against the Reserve Bank of India, who's the sole state respondent. Respondent number 4. I don't find Reserve Bank of India here. I don't.
Yes. Lord, may I just make the point for my lord's consideration?
No, but this notice served upon all.
Yes. Email and hard copy, both.
Reserve Bank of India received
also.
Yeah.
Email is there, my lord, whereby.
By mail.
Well, by mail, in fact, sent by post also.
Post is there is no report.
But
there is no report.
But there is no tracking system. But perhaps there's difficulty with the tracking system now. That's why, my lord.
Yes.
My lord, perhaps for today. May I just formulate the point for my lord's consideration? My lord, there was a relationship of a lender and borrower between the petitioner and the respondent, as well as a guarantee. This case is about the guarantee issue. My lord, this is a unique case where we have not only paid the amount, we have prepaid installments of January and February, which I will show to the court. Our case, my lord, is this, in a nutshell, that this requires equitable intervention by this honorable court, because if they trigger a personal insolvency action against me under the provisions of the IBC, my lord, it is automatic in the sense that there is no recourse, RP is appointed, there will be a complete financial choke. And when you're a solvent borrower and you are making a repayment, then, my lord, the question of having an action such as personal insolvency will be hit by the doctrine of proportionality, which flows from Article 14. And third and most important, my lord, under the contractual scheme, if there is a delay, on that delay, you have to pay interest and penal charges. So for the short period where there was a delay, interest and penal charges have been paid. The RBI master circular says that unless an account remains unserviced or unpaid for a continuous period of 90 days, there is no default. So it will be my submission for the court's consideration that in the absence of any default, invoking personal insolvency, my lord, would be contrary to law and would be hit by the doctrine of proportionality. And lastly, I will also undertake to the court that though I have time till the end of 26, by January, February, I will settle that account also, though I am not obliged to do, to show my bona fide. So, my lord, 4 propositions for my lord's kind consideration. 1, you have to see the matter in context and perspective. You have to see the matter in its holistic context and perspective. In that sense, initiation of personal insolvency will have irreversible, irremediable consequences, especially when I am servicing the account. And delay is not equal to default. RBI circular says, unless there's a 90-day period of default, my lord, there is no question of my account being declared a NPA. At the end of the day, a borrower must be interested in his money. If he's seeing the color of his money, then, my lord, taking recourse to this high-handed action, in my respectful submission, defeats the purpose, because you don't put a solvent company into insolvency. And the preamble of the act also says it is to preserve going concern and entrepreneurship. Now, my lord, straight away have one chart which will make the position clear. Page 9. Page 9 of the writ petition.
My lord has that. My lord, kindly see 5/10/24 was the installment due date. I paid an amount of 7 crores. Your lordship will see principal 7 crores. Then, my lord, 5/1/25, I again paid 7 crores.
I paid installment
Yes.
type interest component.
Yes. Now, my lord, because there was a slight delay in terms of the clause in the contract, I paid the interest and the penal charges. So it is curable, as in if you pay it, my lord, then you pay the consequence of delay. So there's no default. Now, my lord, please have.
What is the days in delay? What is the delay? That's
My lord,
5th January 2025.
10 to 70 days.
my lord, between 10 to 70 days, but on which I have paid interest and penal charges as prescribed in the contract, which I will show. So it is something which has a consequence, but it is remediable, and therefore you are not affected because it's time value for money. So if you pay late, you get interest and penal charges. Now, my lord, kindly move to the third one, 5th April 25.
Yes.
My lord, I paid 12.75. My lord says noted. Now, my lord, before 5/4 to 5/7, this is a slight bone of contention. So I will come back to it. I.e., my lord, June. This is the period where there is some. Now, kindly just have the next one, my lord, 5/7/25. I have again paid 12.75. Now, kindly turn over the page. 5/10/25, another 12.75. And now kindly see, my lord, 6 and 7, this is my prepayment. Even though January 26th and 5th April has not yet come, I have already paid this amount. So, my lord, as on date, I have paid 74.29 crores. The principal disbursed was about 102 crores broadly.
Yes.
And this balance 27.71, I will not, though under the contract, I don't have to pay till 31st December 26. I will do it in the early part of January or February of 2026. So the whole account will be resolved. This is my good faith bona fide first point.
January 2026.
Yes. My lord, the balance 27.71. Although there is no contractual obligation, I have time till 31st December 2026. That is serial number 10.
Correct.
I will prepay, like I have done for January and April, the balance amount between January or February 2026, so that the relationship gets over.
Yes.
Now, my lord, kindly just note the RBI in its master circular of 1st July 2014 says, my lord, that an account does not become a non-performing asset NPA if it does not exceed a period of 90 days. Here, as my lords have seen, there is no default because I have paid. Right, my lord? Now, what happened was, why the bone of contention? After April, my lord, that is the third item at page 9.
Correct. 4th April.
Yes.
5th April.
Now, my lord, in June, what they do in June, 16/6/25, they invoke my personal guarantee and recall the entire amount, saying that you have to pay the full amount, which was at that time some 88 odd crores. But as my lords have seen, subsequent payments have now been made. So it is 27.71. This amount is neither due or payable. This is only arithmetic to show. That if you have disbursed 102, I have paid you 74. 27 is balance. It is not due or payable, neither is there a default. Now, my lord, in this context, the submission for my lord's kind consideration is this, that the 226 power is the extraordinary power to do complete justice. If you now push a personal guarantor, so there's the petitioner, my lord, his wife, and another person, and son, it will be draconian, irreversible, because as my lord knows, under the scheme of the IBC, a section 95 petition, my lord, the resolution professional is auto-appointed.
This is that.
Yes. Now, my lord, your lordship, this is the borrow. My lord had an occasion, I perhaps to consider the suit, which was, my lord, the borrower action on the recall notice. I am now on the personal guarantee action and I'm here in the writ, but my lord has recollected the fact that this matter had a earlier innings. So, my lord, kindly now have, most importantly, 16,625 is the pain point. That my lords will get at page 201 of volume 2. Yes, sorry.
Yes,
My lord, just have the figure at page at 199. Sorry, my lord, 199. I beg your pardon. Where is the amount? Where's the amount?
Amount is this.
Yes, my lord, at 202. Sorry, 200. At page 200. My lord has that. Just the second para. In view of the recall of loan, the total amount of 92 crores has become due and payable by you as of 11 June 25. So, my lord, if my lord just has page 9, there was delay but no default, as my lord has seen.
Yes.
And after June, when this notice came, July, October, January, February, 5 further payments of 12.75 crores have already been paid. So this figure now, according to us, is not correct. It's 27.71, but I'm not on the figure. I am on the very fundamental point that initiation of a personal guarantee action, if the debt is being serviced by the borrower, as my lord knows, guarantee is like a safety net. The principal borrower is servicing the debt. Wherever there's delay, my lord, he has paid interest. If my lord could just note one clause at page 80, 17.1.10.
Yes. 17.1.
17.1.10. Last line at page 80.
Yes.
In addition to the above, as long as the event of default continues, the borrower shall pay default interest on the defaulted amount from the date of occurrence of the event of default until such time that the default is rectified and final payment has been made to the lender without prejudice to other remedies. Right, my lord? So, as I showed my lords at page 9, wherever there was a delay, I have, in terms of this clause, paid, my lord, interest and penal charges.
Yes.
They have accepted that amount.
Yes.
So this 16th June, with greatest of respect and humility, my lord, is an abuse of power because you have tried to recall and accelerate in the absence of a default. Delay, I have cured by paying interest and penal charges. This, the court has said, my lord, that what is the principle of proportionality? You take that action which is least invasive to suit the situation. I am not a case I'm not paying. I am not a case of a defaulter. I am not case of a NPA. And the principal borrower is paying you. So why come to the guarantor and initiate an irreversible and irremediable action? The moment that 95 runs its course, the resolution professional will get appointed. And I am adding icing on the cake to show, although not required, the borrower, by the time, my lord, January, February 2026 comes, will liquidate the balance amount because he has 3 ongoing projects.
There is no IBC proceeding started there.
Section 7. Section 7 is pending, but there is no order of admission. I'm instructed to say. I'm on a slightly different point. I'm right now only on the guarantor action. I'm not on the borrower. I'm saying the principle of
The IPC, the section 7 is admitted.
it's not admitted as yet, I'm told.
Your lordship had passed an order, your lordship recollects, staying the recall notice. So taking advantage of that order, the IBC proceedings in the 7 and 95 both were stopped.
But I clarified that.
Lordship clarified that the
No, my lord,
division bench allowed our appeal and they gave and they said that they will proceed with the section 7, all these defenses which your lordship heard there, your lordship is hearing again.
But can I just finish? Can I just finish without interruption? Then of course they'll have the chance.
Position in IBC
Just one
came
second.
on that day.
Now, my lord, I'm only making 3 points of the court's kind consideration. Point number 1, in the absence of a default and having received consideration, as in the loan is being serviced, invocation of the personal guarantee action will be an abuse of process. The very initiation, number one. Why? You only come to a guarantor when your principal borrower is not servicing the loan. Second, the clock can't be put back, as my lord knows, from section 95 to 99. It's a auto trigger process. Unless there's an interdict by this court, the clock cannot be put back. So it has irreversible consequences. It will completely choke us financially. Three, it is actually counter beneficial, because if the company goes under, my lord, financial, as your lordships knows, financial stigma and choking of the financial system. So it is like they say civil death as far as it's concerned. If it was and the credit score will also go down. So my lord, whatever money is being received from the sale of flats and units which are being sold by that company, all of which will be affected. So it's counterproductive. As long as a lender is seeing the color of his money and his debt is being serviced and he's getting interest wherever there's a delay, then, my lord, invocation of this extreme measure, according to me, would be wrong. This exact situation, akin situation, came up for consideration in the Swiss ribbons case of the Supreme Court, my lord. And I just wish to read one para. Yes. My lord, the citation is 2019, 4 SEC, page 17.
Yes.
Just have para 105 at page 101. Okay. Yes. My lord, at 104, it refers to the master circular which I mentioned to the court. Just for reference, my lord.
Yes.
At page 104, it talks about the RBI master circular. Right, my lord? In that context, kindly see. What is clear from the circular is that accounts are declared NPA.
That is paragraph 104.
My lord, 104 is only reference to the master circular.
Correct.
105 is what I wish to place for the court's consideration.
Correct.
What is clear from the aforesaid circular is that accounts are declared NPA, kindly note this word, only if defaults made by a corporate debtor are not resolved and or interest or installment of the principal remaining overdue for a period of more than 90 days in respect of the term loan. So I pause for a minute. 90 days, if you have not paid and it's overdue, only then it becomes NPA, which I've showed from the chart at page 9. There is no default. There is only delay which has been cured. Next line. Post declaration of NPA, what is clear is that a substandard asset would then be a NPA which has remained as such for a period of 12 months. Doesn't really arise. Next line is important. In short, a person is a defaulter when an installment and or interest on the principal remains overdue for more than 3 months, after which its account is declared NPA. Not so in my case. During the period of 1 year thereafter, since it is now classified as a substandard asset, this grace period is given to such person to pay off the debt. I pause. Even where you're a NPA or you have a substandard account, you have a 1 year period as a grace period to pay. My case is on a higher footing. I am neither NPA nor substandard account according to me, servicing the debt with interest. Now kindly see what it says. During this grace period, it is clear that such a person can bid with other applicants to manage. What is important to bear in mind is the fact that prior to this 1 year, 3 month period, banks and financial institutions do not declare the account of corporate debtors to be NPAs. As a matter of practice, they first try and resolve disputes with the corporate debtor. That's why I started by saying this is a case where the debtor is servicing. Why go to the guarantor when I've showed you the chart at page 9? So I stand on a much better footing than a ailing person. So my lord, even where there's an ailing person, there's a 1 year grace period and they say banks and attempts to resolve. I'm not resolving, I'm servicing. So my case stands on a much better footing. And the delay attracts interest in penal charges, which I have paid in terms of the contract. So my lord, 16,625, seen in this light, my first submission, see it in overall context and perspective. That action, I'm on the initiation action. That action is an abuse of process.
Where is that?
I just showed my lord at page 200. 199 at 200. 13 June.
Yes, yes,
Sorry.
yes. Got it, got it. Yes.
199 at 200.
Yes.
And my lord, very important, subsequent events have shown that this figure now, by virtue of 4 payments of 12.75, which is over 50, so over 50 crores has already been paid. So it's not that the situation is as on 13th of June. You have received further payment and 2 payments of January and February 2026 and a commitment to this court that by February 2026, I will liquidate everything, although I have time till December 2026.
Okay.
So second, my lord, such action is contrary to Article 14. It is unfair, unreasonable, and hit by proportionality is the second submission for the court's consideration. Third, my lord, the draconian and irreversible consequences,
Yes.
credit squeeze, financially choked, and I lose my credit point, which will have a cascading effect on the entire group. So, my lord, that with greatest of respect can never be put back. It's like a taint. Once you have a financial stigma or taint, that will always get attached.
Correct.
We have multiple projects which are running from which the sale of units, my lord, the borrower is willing to service as he has been doing. That will also be affected. So it is counterproductive, according to me, for a lender to disturb a party which is servicing the debt. Fourth, my lord, your lordships have always said IBC is not to be used to put an insolvent company into insolvency. If you're incapable of resolving your debt, this is the case prima facie, as my lords have seen, of servicing the debt. And fifth and most important, my lord, 226 power is the power to do complete justice, full and complete justice.
Yes.
It is variable to meet and flexible to meet varying circumstances. And justice always comes above the law, as your lordships have consistently held. This case calls for justice, calls for that intervention in the nick of time.
Yes.
And therefore, my lord, and lastly, principles of natural justice. There's no question of being heard anywhere. It's auto trigger. That will be, my lord, shocking the conscience of the court to say a man who's paying, he's now going to be subject to this consequence. And
This all the things now the online deduction.
correct. So, my lord, fortunately, we are in the physical court with a physical intervention. So we are seeking that. So, my lord, what am I seeing? I have no other efficacious remedy. Your lordships can consider either of 2 scenarios. One, your lordships can consider that these proceedings will not proceed. They're listed on 3rd December and 18th or 19th December, and record my undertaking that by February of 2026, the balance amount, my lord, will also be paid. Second, your lordships can consider asking for a deferment in the NCLT and have this matter sometime in January or February so that the writ petition is heard and events don't outrun themselves. Namely, those proceedings don't go first. Your lordships can hear it. The division bench has made a similar arrangement, which I will show. And third, of course, my lord, if I am right and I made out a strong prima facie case, your lordship can consider granting a stay of proceedings also. These are the 3, in my respectful submission, courses of action which are possible. Now, my lord, kindly just have one order passed by the division bench. I'm only showing on parity. I'm not citing the order. I'm just showing the nature of arrangement which the court can put in place. Just have page 3. Not that this order is in force. I'm only showing what arrangement a court can make as a division bench did. Take the other one also. Not till we decide the issues involved in this appeal, the NCLT is requested to defer consideration of the appellant's application which have been filed before it. That's one course of action. The other is, as I indicated, my lord, stay of the proceedings because of the fact that when there is no underlying substratum, there is no question of, my lord, going over the top and having a personal insolvency action. And, my lord, the Nagpur bench of the Bombay High Court also had passed a similar order. Courtmaster.
What has happened to the final in the appeal?
They did not They did not
No, no.
contest the appeal. They did not contest the
And they
appeal
consented to the matter being going to the NCLT.
without.
That's recorded.
My lord,
Their
that's
consent.
section 7. I'm on the guarantee action. I started by saying I'm only confining myself to the guarantee action.
But the guarantee, but that is already, the proceeding has been initiated
Yes.
before the one.
My lord, this is a separate action under 95. 7 is different and 95 is different under the IBC.
Address your lordship.
Now, my lord, kindly just have page 3 of this, sorry, page 2, para 3 of this order, another interim order by Justice Chandurkar as he was then. Now, my lord, he's in the Supreme Court.
Yes.
Kindly have para 3. Issue notice to the respondents subject to the petitioner depositing period of so-and-so till the returnable date. No precipitate steps will be taken in the pending matters. So the court says, subject to making the payment, no precipitate steps. My case is I have paid, overpaid, and I will pay the entire amount by February. And third, if I'm right, my lord, yes. Initiation, if it's wrong in my respectful submission, you could not have initiated 95 and 95 has irreversible consequences. I have no other door to knock on. Then as an equitable intervention, your lordships, no, that's my submission. 2 I have showed. As an equitable measure, as a protective measure, your lordship can say stay of proceedings subject to the petitioner by February 2026, resolving the entire matter and paying the full amount. So, my lord, the whole matter will be the personal guarantee action. I'm only on the personal guarantee action. There will be no list for the personal guarantee action to proceed further versus if that 95 goes, straight away a resolution professional will be appointed. The moment the resolution professional is appointed, my lord, the financial rating, credit score, cascading effect triggers in. That is an inescapable conclusion. So therefore, my lord, I'm coming to a court of equity with extraordinary power and jurisdiction to mold the relief in varying circumstances, this being one such circumstance where I am not a defaulter as I stand before you. There was no occasion to go and hasten an invocation of a personal guarantee. That would be hit by proportionality. You have to follow the least invasive rule first. And till then, my lord, kindly see, between May and June, he had received those 3 installments with penal interest. Where was the default? You cannot take delay to be default. In any case, it's not for 90 days. So, my lord, on conduct, see my bona fide that I have paid for January and February 26, and I'm committing to the court to do it. So, this is, my lord, molding of the relief. I beseech the court, my lord, in the interest of equity and justice with no prejudice. I can understand if a person comes and says he's not servicing, he's a rank defaulter, he's not paid for years. And with my further commitment.
So why you're not filing the appropriate application before the insolvency proceeding?
Because, my lord, under section 95 to 99, there is no power of adjudication the Supreme Court has held in Jivrajka's case. It's an auto-trigger process. So the moment they file its initiation, the RP is appointed and a report comes in. So, my lord, with greatest of respect, that's why I said natural justice. There is no recourse I have. Okay. And lastly, I'm urging the court as a full alternate option, my lord, that in the light of what I've said, your lordship can say, please sit, hear them, see the details, see the facts that they're given para 9, plus their commitment to liquidate the entire amount, nothing will remain. And the moment, my lord, somebody turns their back on this, that supports my point that this is malicious, this is not bona fide, this is to choke me and put an albatross around my neck. So therefore, my lord, on equitable grounds, and based on the fact that this initiation in my humble and most respectful submission was unwarranted in the context of the case.
Okay. Thank you.
Grateful, my lord. And of course, the RBI circular violation, no default, grace period. So in law, there's a grace period to a defaulter. A non-defaulter, my lord, must have breathing space. He's asking for 3 months.
Okay.
I'm so deeply grateful.
Thank you.
My lord, I'll be very brief. First is, there are 2 sets of proceedings pending before the NCLT. One, my lord, is section 7.
Lord, just for a few minutes, I'll excuse myself. My colleagues are.
Yeah, I'll call you outside.
You are appearing for Mr. Bose?
My lord, the respondent numbers 1
and
respondent. I am for 1.
2 and 3.
No, I am for 1, and Mr. Thakkar is appearing. My lord, for 2.
For 2.
Respondent number 2.
Who is for the 3?
The 3 is their supporting part.
Millard, let me tell you. Yes, absolutely right. Thank you for that. Yes. Millard, I believe 3 had filed a civil suit initially. And the petitioners here were respondents as guarantors, Millard, individual guarantors. Now, Millard, your lordship, I believe sitting in suit jurisdiction, had passed some order and saying that I had recalled the entire loan pursuant to a particular clause. Millard, that clause was not mentioned. Instead, your lordship referred to clause 2, which is servicing of interest. But my recalling was under 16 and 17, the entire loan. So such and such amount, 88 crores or 91 crores became due and payable. Your lordship said that no, the relying on clause 2, which is also putting in the default for interest, that is the relevant clause. My lord, whatever it is, that is the order. We preferred an appeal. Now, my lord, on the last day before the vacation, Justice Banerjee took it up and said, this is the position. My matter is fixed on 7th October. And I said, what do I do? Because if the entire loan notice is recalled, the amount, what is debt and due, they contended, my lord, that because of your lordship's order, your NCLT proceedings have gone. So, my lord said, very well, pray for an adjournment. Ultimately, my lord, it came up, my lord, and was disposed of. So, my lord, I respectfully submit this order should not be cited. This is just an interim order. Please take this order. My lord, may I... you will find, I underlined it. My lord, you will find that the respondent number 3, that the petitioner also appeared. My lord, just you will find the respondent number 3, last set of counsels, my lord, are the petitioners in this writ petition. And this was what was the order. My lord, kindly see, is against the interim order, etc. My lord, last learned senior advocate, last paragraph. Appearing for the appellant draws attention of the court.
Which paragraph?
My lord, page 2, last paragraph.
Yes.
May I just, this is my, I drew attention to the appellant, the attention of the impugned order. He submits, by reason of the impugned order, appellant was restrained from giving effect to the recall notices as a follow-up notices in respect of credit facilities. He submits that the same would tantamount to NCLT not deciding upon Section 7 application, since foundational basis of application under section is the recall notice and follow-up notices, which your lordship may not had stayed for a brief. Now, learned senior advocate appearing for the plaintiff submits on instruction, that's them, that the plaintiffs are anxious. They are only anxious about their pledge and mortgage. He submits, issue of validity of pledge and mortgage cannot be decided by NCLT. He submits on instruction. Maynard, please note this, that his client, that is the plaintiffs, does not object to NCLT deciding the application under Section 7 of the IPC in accordance with law. Now, Millard, I know what the argument is. Section 95 is independent. I will find the Supreme Court on that. I'm aware of that. I mean, NCLT proceedings. So this is something, because NC, the adjudicating authority, they have been arguing, harping so long. Please adjourn it. You decide equitable jurisdiction. Fine, do it. But with respect, you don't have the jurisdiction. I will cite 2 Supreme Court judgments, Millard, on this. This is my main contention. Now, Millard, contends the entirety was repaid belatedly. He also point out the belated concern, same is governed by the terms of the agreement, which allows that interest component was also paid. This is what they wanted to argue, Millard, and was arguing. Contention that entire amount stands repaid is disputed by the appellant. We find from the records that application is pending consideration. Such application is prior in point of time. In the suit, learned judge proceeded to pass an ad interim order restraining from giving further effect to notice of recall follow-up. Apparently, a portion as also follow-up notice deals with side. It is accepted at the bar that I said NCLT will not decide on the issue of pledge and mortgage while deciding the issue. I agree, you can't decide at the time of that's my. In circumstances, it would be appropriate to modify to press the application. NCLT will note out, decide application. So NCLT will decide whether it's correct or not. All points with regard to points are kept open by the NCLT. NCLT will decide. Now, my lord, after this, the matter came up because the interim order was being extended before the learned single judge. My lord, Justice, now your lordship's successor in the interlocutory, it's a short extension of the interim order and refused to extend, my lord, the interim order. So there is no extension. The matter, I believe, is fixed on section 7, admission. They will decide whether it is admissible, whether recalling notices are bad, etc., etc. They will decide in accordance with law. Now, this is the position, my lord, you will find that it was not extended. Now, my lord, next point is, now, my lord, after all this has happened,
yes,
this is the second round. Now, no longer the borrower is applying before you. Now, my lord, the respondents, my lord, who had appeared in the appeal about section 9, now they say, my lord, section 95 has also been initiated. Section 95 is against an individual,
correct,
the guarantor. My lord, section 95, and I place it before your lordship, stands independently of section 7. It is against an individual. My lord, the law, I will show you the sections, my lord, the relevant provisions. I might as well show it to you so that all this apprehension about what my creditworthiness is disappearing. I'll be, it's a matter of course before the resolution professional, my lord, to negate that argument. It has been considered, all this, by 2 Supreme Court judgments, and I will place it before you. So, will you please take the act once?
Yeah,
Sorry, the code. My lord, just give it, open it, yeah. Mine is a, give a small book. Yeah, Krishna. Maybe your lordship does not have it here because writ jurisdiction is not maintained. It's just Millard, yeah. Now, Millard, please come.
On a lighter note, but the sweep of hands of the court are long enough to get it.
Yes. True. And also long enough to fetch the book from another court.
Long arm jurisdiction.
Yes. Now, Millard, will you please come to section 78 once? Or rather, section 4 once.
section 4.
First 4. My lord, right at section 4.
Just a minute. Yes.
My lord, you will find section 4 is under part 2, and it is against corporate persons. Right, my lord. So creditor against corporate persons.
Yes.
We are not concerned here with corporate persons. We are concerned about individuals.
Yes.
And kindly come to 78 once. My lord, has your lordship come to 78 once?
Yes.
Yes. Just above 78, my lord, it's part 3. And you will find insolvency, resolution, and bankruptcy for individuals. So, my lord, under part 3, I can approach, my lord, go against the corporate guarantors or the individuals. Now, my lord, straight away come to 95(1). My lord, under chapter 3 of part 3. My lord, if you see, if you've gone through, my lord, have you found that? Sorry. My lord, all this is being considered by Supreme Court. I'm just showing you the sections. Now, my lord, 94 is when the debtor files for initiation. 94. We are not concerned here. My lord, 94, we are not concerned. 95, we are concerned. My lord, 95, kindly come to section 95(1). It is that the creditor can jointly or through, we can find jointly or through a resolution professional to the adjudicating authority for etc. etc. And if you straight away come to my lord 97, my lord 97, 3, 97, 3, my lord 97, 3, my lord, I am showing you because straight away I will come to the judgments and give you the paragraph numbers. My lord, it says 97(3), where an application under section 94 or 95 is filed by creditor himself. Here, I filed it under 95, my lord, creditor himself, as the case may be, and not through resolution professional. The adjudicating authority shall direct the board within 7 days to nominate a resolution for insolvency. Please mark the words. Now, so this is a matter of course that you, as he said, my lord, I'll be tarnished if it's a matter of course. Incorrect. That's what the Supreme Court has held. It's incorrect because resolution appointment under this provision, Part 3, is completely different from resolution professional under Part 2. My lord, that's the reason I wanted to show you the section. I'll show you, my lord, kindly come to 97(5). Then, my lord, adjudicating authority shall by order appoint a resolution recommended as nominated by the board under 4. This has not happened as yet. Now, my lord, kindly come to 97(6). Then what will a resolution professional do? A resolution professional appointed by the adjudicating authority shall be provided of an application for the insolvency resident. So, my lord, after it is appointed, then it will get a copy of this application which I have filed. My lord, this is the procedure. Then you come, please come to, my lord, 99(1). Then what will the resolution professional do?
Examine the application.
The resolution professional shall examine the application which I have filed, as the case may be, within 10 days and submit a report. My lord, what will he report? Recommending approval or rejection of the application. So that's all he will do. He will approve. My lord, file a report. Now then, my lord, kindly come to 99(4), if you don't mind. Yes. For the purpose of examining application, may seek further information or explanation in connection with application as be required from the debtor or creditor, who in the opinion may provide such information. Then, my lord, 99(7) says, after examination of the application under 6, he may recommend. So, my lord, it's a recommendation which he will give. Why? For what? Either accept or reject the application in his report. Yes. And kindly come in 99(9), the resolution shall record reasons for recommending the acceptance or rejection in the report. So it's a reasoned order of a report asking, this is my recommendation. Then, my lord, kindly come to 99(9) and 10. And then copy of this report will be given to debtor and creditor as the case may be. My lord, he has to serve a copy on both, on everyone, the creditor, and the reason is you challenge if you want to. And then, my lord, is 100. This is so when does the adjudication happen? The adjudicating authority shall, within submission of report, either admit or reject. my lord, this section. So then is the question of rejection. I will point out, my lord, and then, my lord, this is 100. So adjudication comes, my lord, and from section 100. So all this argument, image is tarnished. My lord, with great respect, this has been recorded in two judgments, my lord. One is a constitutional bench judgment. Learned friend mentioned Juarachka or whatever. But the recent one is, my lord, more important. Yeah, just give me. Farooq Ali. I have now memorized. Thanks. Sorry about it. Just
I got a glimpse of his arguments.
no, yeah, yes, sorry. Bank of Baroda, where are my marked portions here? Just get it. Oh, where is the marked portion? It's all gone. Yes, I've got it. My lord, may I read this? The question for our consideration is whether High Court could have invoked 226 to interdict personal insolvency proceed initiated by under section 95, directly in question, whether under article question. The High Court jurisdiction was invoked against order of adjudicating authority dated appointing a resolution professional and directing him to examine under section 95 and file a report. Having considered facts, legal submissions, we set aside the order of the High Court and restore proceedings before the adjudicating for the time or its order dated such and such. My lord, exactly what they are wanting now. I will come to the next page, my lord. My lord, in the middle, third line, it is written that respondent number 1 had entered into deed of guarantee, just like our case, my lord. Deed of guarantee. Have you found that, my lord?
Yes.
Yes. Then para 4, my lord. After issuing a demand notice informed under Rule 7.1, it's an appellant filed application under 95.1 to initiate personal. So there is a particular rule. My lord, this has been done. If you want this page, they have annexed it. My lord, at page, I believe in the petition, this has been done under 7.1 rule notice. It has to be done.
Where is that?
Yes, they have annexed, my lord. Page 230, volume 2. My lord, kindly see paragraph 5.
Yes.
My lord, in the middle, on objections being raised by the on limitation validity of existence of personal guarantee, the validity, adjudicating relying on judgment of Dilip B. Jiwatkia stated that the issue stroke objections raised by the learned counsel for the personal guarantor will be considered after submission of the report of resolution. My lord, on the same, just as I was telling your lordship, respondent number 1 preferred a writ petition under to prohibit adjudicator from entertaining the personal petition against primary ground that his liability stood waived and discharged. Exactly what has been pointed out here, waived or discharged. Or, my lord, this is, then kindly see High Court by held that personal are not maintainable as respondent number 1 liability had stood waived. My lord, by considering all these documents, which inviting your lordship to do it. Then, it further held that court in Jiwachka, my lord, this is the constitutional bench, was not considering an application that was not maintainable before adjudicating, thereby distinguished, pursuant to the impugned order, adjudicating authority disposed of the insolvency proceedings against the respondent. Then, my lord, paragraph 8. The simple question for our consideration is whether High Court, my lord, this is also the simple question I'm urging, exercise its writ jurisdiction to interdict the personal insolvency proceedings against, it is necessary to appreciate the statutory scheme regarding admission of a petition for initiating personal insolvency under Part 3, Chapter 3 of the insolvency such and such. The court in Jiwachka, while considering the constitutional validity, has delved into the same and has held as follows: pursuant to an application for initiating, appoints a resolution professional under 97, a little below, my lord, a little below. Resolution professional examines the application, determines the date that has submits a report. Then it is only after submission of this report that adjudicating authority commences under section 100. Has your lordship found it? That's exactly. At this stage, adjudicating authority determines to admit or to reject this. Right. Then these principles have been summarized as follows: no judicial adjudication is involved at the stages under section such and such. Exactly what I was saying. Then, my lord, the submission that a hearing should be conducted for the purpose of determining jurisdiction from the appoints a resolution professional is rejected. No such adjudicatory prong is contemplated at this stage. My lord, just as I was saying, look at para 9, my lord. My lord, say adjudicating authority has followed the procedure, my lord, envisaged on 95 to 100. This is exactly which is being prevented at this stage. And a little below, this is correct approach, as the appointment of resolution at the very threshold is statutorily mandated under section 97. Adjudicating does not adjudicate any point at this stage, need not decide jurisdictional questions regarding existence before appointing resolution professional. This is because section 99 requires resolution at the first to gather information regarding payment and ascertain whether it satisfies the requirements under 94 to 95. My lord, this is then para 10, in light of the which has been framed, we are of the view that incorrectly exercised jurisdiction first is precluded statutory mechanism and procedure under from taking recourse. Second, to do so, High Court arrived at a finding, my lord, regarding existence of debt, which is a mixed question, my lord, which is a contractual dispute again. Writ jurisdiction, second is does not interfere, my lord. Then it is well settled law. Statutory are constituted to adjudicate, determine questions of law. High Court do not substitute themselves the decision-making authority. In the present, has not reached the stage I was reached. My lord, kindly come. It goes on. And while there is no conclusive judicial authority, exercises must exercise are well articulated. Primary issues involved, including factual determination date, is a part of statutory and regulatory regime of insolvency bankruptcy code. In fact, entire rationale before 97 to facilitate this determined by the adjudicating authority. High Court ought not to have interdicted the proceedings under statute and assume what it did while exercising jurisdiction under 226. My lord, in paragraph 13, there's a quotation from Tanzania Limited, and I read the quote: the High Court should not have noted insolvency is a complete code in itself, having sufficient checks, remedial revenues, adherence of protocols, procedure, maintains legal discipline, vested, and such. And the last paragraph, in view of above, we allow this and set aside the and send it back, my lord, to the tribunal, my lord, to do. Now, my lord, your lordship will rise and take it up at 2 p.m. I'll just refer to one more. Oh, I'll come. Your lordship will sit. No, I have one matter fixed at 2. So therefore, no, it's okay. No. So you will say, may I? The important.
How much time you will take?
My lord, I will take maximum 10 minutes.
Then because 2 p.m. other matter is there.
No, 5 minutes maximum I will take them.
Then Mr. Thakkar?
Mr. Thakkar. 10.
Then 2 p.m. it will be.
2 p.m. I can come.
2 p.m. other matters are there. Other matters already.
One day. Whatever your lordship feel, but I can give
Monday in. Monday 11 or 11:30.
But no, whatever, because technically speaking, they say that the matter is fixed on 3rd. So Monday, I mean, is not 3rd. If your lordship is inclined to stay, the proceedings on 3rd or defer, whatever it is, they are not prejudiced if the matter is taken up on Monday. That's what I say.
I will take some time to
They-
some guidance.
He has a
Yes,
matter
sir,
fixed
I
at,
fully appreciate. Whenever it's convenient to the court.
मंडे देखो 1 तारीख या 2 तारीख को क्या कौन सा
as per your convenience, whenever you want.
Time fix कर देंगे ना जज साहब.
I have said whatever. I'll take 10 minutes, just the decision and the rest facts and all. I mean, if you want.
then he will give reply also.
Yeah. Are you Monday's okay, na?
Any day which is convenient to the court.
Third, it's fixed. Huh? So I said. I mean,
Huh?
you are coming, na? No, you come. Or you can be on time. What day is Monday?
First of first.
First. So you want it second? I mean, whenever you want.
2 बजे फिक्स है.
Hey.
2 बजे फिक्स है. 2 तारीख को 2 बजे नहीं है. Sure. देख लीजिए.
Tuesday को time don't
No, Milord, let's say Milord, Monday.
Monday my diary is packed.
Maybe come back after
Any time on Monday. I mean, I'll be there.
any time post lunch when your lordship's matter gets over.
Monday क्या time में?
Or even today, my lord, if post lunch your matter gets over.
The fixed matter gets over, my lord, we can come.
Today?
Today?
Yes, no problem.
Well, my lord, only I may not, it's a fix. May I give the cases and note it, and he will
Because
place.
2 p.m. one fixed matter is there. AG will be there.
Milord, can we now?
AG and
my management takes 5 minutes.
Mr. Ashok Banerjee
I'll
will
also
argue.
take 5 minutes. We can finish it now.
No. He will.
I'm for the respondent number
He
2. They've
is
added
also
me also, so.
Mr. Thakkar will also cite some citation. Without citation, Mr. Thakkar argument will not be completed.
That is true. He had given so many. I said no, I will not. I picked, but he says. I said you do.
Monday.
So will your lordship
Tuesday
now?
you are having difficulty.
Tuesday I'm not. I will not be
Already.
Security trustee, security documents. But we are the
फिर 1 बजे भी
guarantees in corporate trusteeship and there's a security trustee.
Yeah. 1 बजे तो आधा घंटा में न होगा.
Milord, Monday 3 p.m. if it suits, my lord.
3 p.m. my original side matters, sir. 3 p.m. original side matters I take. That also fixed matters are the original side matters.
Milord, can I be a little adventurous?
एक काम करो 12 बजे 11 बजे. Then the total the other matters will not be taken. Okay, come. I am keeping as a urgent motion at the top on Monday.
Grateful. Very good.
I'm grateful.
The counsel for the petitioner has concluded his argument. Counsel for the respondent has argued the matter at length. Respondent number 1 has argued the matter at length. But due to paucity of time, hearing could not be completed. Let the matter appear on 1st December as adjourned motion at the top.
Very deeply
At the
grateful.
top. Huh?
Very grateful.
My request, your lordship, on second. But I sorry that I missed the date, but instead of second, first or
Second.
third immediate.
Second, I don't. Second, any date. Which matter?
But item number 9, but this single matter, but my request, your lordship, is to fix on second. But I missed the date, but I have difficulty on second. Third or first.
That is. I don't think you will get the date.
This following from your lordship to fix the matter on third. I request your lordship to.
Third खाली है? हाँ? No, third हम लोग उसमें खाली है.
Urgent motion. Here is urgent motion. I will inform the other side on.
Okay, then let them. ये जो है ना second के जगह तो third में urgent motion में appear होने.
Grateful.
दिन के टॉपिक
So, my lord, I will not detain your lordships today much. More or less, I've finished, but I'm really tempted to draw attention also once again, page 537, for obvious reason, para 11. 543, sorry, 543.
543.
Volume 4. Volume 4. পড়ি ওটা। Have you got? Oh, sorry. Got it, my lord. Kindly take time to look into this submission of Advocate General to the other court. It is further submitted that in the facts of the present case, even if the hearing is granted to the petitioner, no different conclusion could be reached than the one that has been reached by the authority while passing the order that is and such. So that is their closed mind. My lord, they have already decided what they will do. It's very dangerous, my lord. And to prove that they wanted to cite some judgment, Justice Rai threw away. No. It's a lengthy judgment, Justice Rai. How can you say like this? I'm really surprised. So, my lord, this is one of the vital aspects.
Yes.
And other point I have also stated. Now, my lord, as we know, my lord, Supreme Court is supreme. Especially they have got a blessing from the constitutions because he is constitution above all, Article 142. So they can do what they like. In one occasion, I had a privilege to argue before Justice Kurian Joseph, and then regarding appointment, Justice Kurian Joseph told the council of the other side, yes, there is nothing, but we have got something. By exercising that special property to, we direct you to have created the post. I give that 62 persons were appointed. I'm really grateful to Justice Kurian Joseph. Now, my lord, as we know, my lord, there's a basic and fundamental difference regarding invocations of special power under Constitution by the Supreme Court and the High Court. My lord knows better than me, my lord, from experience from both sides. No, experience both sides. Now, so far, Article 32 is concerned, my lord, if I'm not wrong, a foreigner cannot challenge because it's touching the fundamental rights. And who can enjoy the fundamental rights? Unless a citizen, he cannot. So they are very limited scope. But so far 223 is concerned, enormous power. In one occasion, before Justice Suhas Sen, unfortunately, he has no notice of deportation issued to some foreigners. So I challenge Suhas Sen after elevation of 8 or 9 months. Normally, my lord, ratio during matters, senior, junior judge, it is not given, but he has given that. So when I moved this application, Mr. P.K. Roy then opposed me as, my lord, it is not maintainable. Why? He is a foreigner. Suhas Sen says, Justice Suhas says, no, Mr. Banerjee. Then I convinced the Honorable Court, yes, Article 14 will certainly come. They may not get the privilege of Article 19. But 14 is always there, Article 21 also there. So, my lord, order was set aside and got it done. Now, in deciding one case, Supreme Court, Justice Madden, sitting with Justice A.P. Sen and R.S. Pathak, I had the privilege to appear all of them in a different case. Very nicely explain the power of your lordships, my lord. I am giving one judgment copy, my lord. Supreme Court, 537, 87. I request the lordships to come, paragraph, very interesting interpretations. Paragraph 19, kindly take time to come. Paragraph 19, my lord. The last part. Paragraph 19, last parts.
Yes.
It starts with in Halsbury's Laws of England. 4th edition. 1, 2, 3, 4, 5, 6, 7, 8, 9. 12 lines from the bottom.
It starts with, in Halsbury's Laws of England.
Yes.
Have you got it, my lord?
Yes.
4th edition, volume 1, paragraph such and such. It is stated that the purpose of an order of mandamus is to remedy defects of justice, and accordingly it will issue to the end that state may be done in all cases where there is a specific legal right and no specific legal remedy for enforcing the right, and if so in cases where, although there is an alternative legal remedy, yet that mode of redress is less convenient. It's a normal, then paragraph 20, my lord, which is very relevant. May I place it, my lord? There is thus no doubt that the High Court in India, in exercising the jurisdiction Article 226, has the power to issue a writ of mandamus or writ in the nature of mandamus, or to do pass orders and to give necessary directions, where the government or the public authority has failed to exercise or wrongly exercise the discretion conferred upon it by a statute or a rule or policy decision. Even in the case of policy decision, because sometimes point is taken, the government policy, my lord, that can also be challenged. Policy decision of the government has exercised such discretion, modified or on irrelevant consideration, or by ignoring the relevant consideration and material, or in such a manner as to frustrate the object of conferring such discretion or the policy of the implementing with such discretion has been conferred. In all such cases, and in any other fit and proper case, a High Court can, in the exercise of its jurisdiction under 26, issue a writ of mandamus or writ in the nature of mandamus, or pass order and give directions to compel the performance in a proper and lawful manner of the discretion conferred upon the government or a public authority, and in proper case, in order to prevent injustice resulting to the conferred parties, the court may itself pass an order to give this direction, or which the government or the public authority should have passed or given, and it properly and lawfully exercised the discretion. Well, kindly consider the
Power of the High Court.
Power of High Court, and it is Justice Madden clarified in its as part of Capuchin and part of. So, my lord, it's a huge power, my lord, huge power. Justice. Law doesn't mean to be mere theoretical abstraction. It is an instrument to do the justice, and justice for all. And to implement the justice, my lord is here. My lord, here is a case. But the way it has been dealt with is very unfortunate. Their whole intention somehow to kick me out and to allow someone else. Someone else. And that is apparent from the records. The person who was not qualified, disqualified means then subsequently he was qualified and having the same polity. Then the last part of the list, my lord, sometimes, my lord, we are citing so many judgments. It is a law, my lord, as I have cited. Proposition of law. Power of the High Court has been clarified by the Supreme Court. Yes, you are one of the most powerful authority. You can do whatever you like, of course, my lord, not in a legal manner. But if it is found there is a gross injustice, forget about any other thing, you should take care of it and squash it. Now, my lord, sometimes we are citing so many judgments. Now, Justice Arijit Paswar is a very witty person, my lord. I had a privilege to appear before him. His judgment is very interesting. Of course, there are several judgments regarding precedent, but this judgment I like for obvious reasons. But which is reported in, I have one copy. No, আরেকটা কপি কোথায় গেল? আরেকটা কপি কোথায় গেল? না, এই কপিটা দিতে বইটা দিলে কি করে? Which is reported in the All India Reporter 2008 Supreme Court 690. My lord, sorry. Because I know they will come with a several judgment. That was done by Justice Home, right? And they are also, he is also materially, they will try. Kindly come to paragraph 13, inverted command. Last part. referring one case. There is always peril. I'm sorry.
Yes.
Paragraph 13, inverted comma, last portions.
Yes.
Have you also got it, my lord?
There is always.
Yes, there is always peril in treating the words of a speech or judgment as though they are words in a legislative enactment, and it is to be recommended that the judicial utterances made in the setting of the facts a particular case. Now, circumstantial flexibility. Have you also got it, my lord?
Yes.
Circumstantial paragraph 14. Circumstantial flexibility. One additional or different fact may make a world of difference between the conclusion in two cases. Disposal of cases by blindly placing reliance on a decision is not proper. The following words, Lord Tenning, in the matter of applying precedent, have become locus classicus. Each case depends on its own facts, and a close similarity between one case and another is not enough, because even a single significant details may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide cases, as said by Kotojo, by matching the color of one case against a color of another, to decide therefore on which side of the line a case falls. The broad resemblance to another case is not at all decisive. Precedent should be followed only for so far as it marks the path of justice. But you must cut off the dead wood and trim off the side branches, else you will find yourself lost in the things of the branches. So, my lord, very interesting. Whenever I have to cite any judgment, is a basic law I'm just pointing out that, well, are some justice, natural justice. Signature.
Yes.
So, my lord, judgment will come and go. Today, honorable judge, according to his perception, this is the correct proposition law. He delivered a judgment. Tomorrow, another judge may come and say, I don't think it's correct. I'm referring to the matter of judgment.
Not require the judge to change. The same judge can, I can say tomorrow.
Even my lord can say, probably.
This is not the correct.
This is the correct approach. So, my lord, that's why decision is something else. But basic law will always be there. I cited to judgment for basic conception, basic law. So, my lord is very much aware that, well, what is precedent? What is the power of my lord? So, here, then my lord suddenly ask me, Mr. Manager, why you are citing these two judgments? One, I'm just citing the precedent. 1001 judgment may come. Each and every case, fact has its own characteristics, and all cases to be decided on the basis of best fact.
That's what it says.
And
all cases it their own fact.
And the Madan judgment is a guidelines.
What is that?
Yes, power.
Power of the eye.
That's why again at the constitution, law doesn't mean to be mere theoretical abstraction. It is an instrument to do the justice and proper justice that can only be done by your lordships. If your lordship is able to see that the manner in which my client has been deprived to participate, the manner in which a person has been accommodated, favored child to participate, or selections earlier, he has been selected.
Thank you.
I'm grateful.
Could I start till such time till such time the learned advocate general comes? Could I start?
Yes.
My lord, I'm just begging some time, so
There are 3-4 clauses of the NIT which are of utmost importance. My lord, may I start by placing those, my lord? Lordship would kindly have a look at page 74.
I'm being unconditional approach. Actually, my junior friend has not very nicely for the convenience of the court. No. The PPR this one, keep it.
Thank you.
I'm grateful.
My lord, will kindly have a look at page 74 of volume 1 of the writ petition.
Yes. 74.
74. Now there's a table. It's continuing from page 73. And the relevant portion is at page 74. Capital B, financial ability. Has your lordship got it, ma'am?
Yes.
Financial ability as PQ credential in preceding 3 financial years.
Yes.
Average of gross annual turnover of the bidder, except for consortiums and joint ventures for any 3 financial years within immediate preceding 5 financial years of the date of publishing NIT should be at least rupees 22,63,99,792, which is 30% of the amount put to tender.
What is the amount of the tender?
Yes.
What is the value of tender value? 75 crore 46 lakh 65,000. This is the tender value.
110, my lord, will kindly have a look at.
No, 73.
Yes.
73.
Yes, but
This
exact
73.
73, my lord.
That is the tender value.
73, my lord, will kindly give me a moment. Yes, my lord. 75, 46, 65, 973.
These are the tender value.
This is the tender value.
Yes.
So, my lord, the other bidders required to have a greater, my lord, turnover.
So this tender value.
Yes.
The 20% of this tender value.
30% of this tender value has to be the annual average turnover for 3 years.
Correct.
So that turnover had to be 22,63,99,792.
So where is the clause 7V?
Yes.
Clause 7V be at
Yes,
least.
I'll indicate. Kindly comes to page 84. But I'm led by kindly.
Now, my lord, clause 7V would be, my lord, at page 84.
84. Yes, good.
7V B. Please take B. Average of annual turnover from business of any 3 financial years within the zone of immediate preceding 5 financial years, as stated in clause 4.2 B4. I'll take your lordship to this clause. Should be at least 30% of the amount put to tender of work in which the bidder intends to participate. However, for consortium, we may not be troubled with that. Now, 4.2b, Roman 4 is at page 78. Kindly have a look at page 78.
Yes, 4B.
Yes.
4.2B.
But this here, page 79, financial credential explanation. Might have found that?
Yes, 4.
Yes. Before that, if your lordship may kindly take me, lord, page 78 also, financial information. At the top, there's a box.
Yes.
Table. One is profit loss and audited balance sheet for the year 1, then for 2, 3, for 2 and then 3. Then on the right hand side column, 1 to 3, profit and loss accounts and audited balance sheets along with relevant annexures containing the designated forms 3CA, 3CB, 3CD as applicable under Income Tax Act. This is important. In the name of the bidder for 3 financial years, etc.
Yes.
Then if your lordship may kindly take me at page number 79. 4.2C, Roman 4. Financial credential explanation.
Yes.
Profit and loss accounts and audited balance sheet of any 3 financial years within zone of preceding 5 financial years duly authenticated by the licensed auditor regarding annual turnover from business containing relevant annexures of IT form 3CA, 3CB, 3CD under section 44AB of the Income Tax Act as applicable for the bidder in each year, financial year. It is to be evaluated by the tender evaluation committee as average or arithmetic mean over the said 3 years to be uploaded in the profit and loss and balance sheet auditor's certificate should contain his, her membership, etc. Therefore, whatever was under the requirements under the under section 44B AB of the Income Tax Act, Millard, was also notified to the bidders that that would be taken into consideration. Because the entire case of my learned friend was that you have not said that that GST is exclusive of turnover, etc. Now, if your lordship may kindly take, Millard, the page number 496. Achha. First is, Millard, what they had submitted, that my lord will find at page 54, volume 1. They were required to, Millard, produce a certificate of the chartered accountant, where your lordship has found from page 78.
54.
54 in the first volume.
Yes.
This is what, Millard, they had submitted, Millard, at the time of submission of bid, which says, Millard, this is the CS certificate. This is to certify that the following statement in this is the summary of the audited balance sheet arrived from the contractual business in favor of so-and-so for 5 consecutive years or for such period since inception of the firm so-and-so.
Yes.
Now, as against, Millard, each year, the turnover is 32 crores, 19 crores, etc.
Yes.
And the total is 84 crores. Yes. Now, if your lordship kindly takes, Millard, the first 3 entry, that is 2024-25, 23-4 and 22-23, which is 32 crores, 19 crores and 20 crores.
Yes.
Taking these 3 together, because the highest of the 3, highest amongst the 5,
Correct.
highest 3 amongst the 5, it comes somewhere around 23 crores. And he crosses the benchmark of 22 crores plus.
33.
Yes.
30%.
So this he crosses, Millard, in terms of this certificate which was submitted along with the bid. Then your lordship may kindly take, Millard, page number, please comes to, Millard, the 4th volume now. Millard, we give them a letter at page 493.
Yes.
During preliminary technical evaluation process for the ENIT under reference, you have been admitted as qualified. Where we say that you have been shown as qualified because he had met the criteria. And the TBO sheet is uploaded on the e-tender portal. Now, before final technical evaluation, you are hereby requested to provide a report of your chartered accountant containing the gross turnover excluding GST for the years under zone of consideration of this ENIT, that is for the financial year so and so. The statement is required to be produced in a letter on the chartered accountant having so and so with supporting documents, on the basis of which further course of action would be taken. The required document must reach this office by such and such.
Yes.
Then, Millard, please comes to, Millard, page number 496. Based on page 493, now he gives the chartered accountant certificate excluding the GST component. Now your lordship would kindly take away the second column. Second column, the heading is taxable value.
Yes.
Third column heading is GST, which was missing in page 54.
Because first he has given the total.
Total.
Taxable value plus GST 32.
Right.
Correct. Now, as per your clarification, now he has segregated.
Now he has segregated. Now kindly look into, Millard, the first 3 entries under taxable value.
27,
27, 16 and 17, Millard, average is around 20 crores. He does not meet the criteria.
Yes.
Then your Lordship will kindly take me to the next page, page 497. Your bid was prima facie, this is our letter. Your bid was prima facie declared qualified by the tender evaluation committee within so and so, published so and so, so and so. The committee has further reviewed and scrutinized your bid upon receipt of the complaint made by some other bidder and observed that the average annual turnover based on 3 years within the zone of 5-year preceding years is less than that mentioned in PQ criteria of ENIT under reference. Since annual turnover value is considered excluding GST as per para so and so of the guidance, where I'll take your Lordship through this guidance, note of tax
This is the
audit.
only main thing.
This is
how,
the main
how you coming to the conclusion that this GST is to be excluded?
Right, right.
That if you
Because figures
satisfied,
are admitted, figures are not disputed.
that you satisfied that the GST is to be excluded, then nothing.
Yes. So that Milord, I'll satisfy your Lordship. Milord, your Lordship, ওইটা তাহলে ইয়েটা দিয়ে দেয়, জজ সাহেব যখন ছোট করে দিয়েছেন। হ্যাঁ। So this is the guidance note, Milord, which is referred to, Milord, in page number 497.
Yes.
Milord, one of the pages are flagged. Kindly have a look to that page. Internal page 12 of that guidance note.
Yes.
Or if I may start from Milord, page number 11, internal page number 11, where there's a heading, clause number 5, sales, turnover, gross receipt.
Correct.
Where under that 5.2,
Yes.
the Central Sales Tax Act defines turnover as follows. Turnover used in relation to any dealer liable to tax under this act means the aggregate of the sale prices received and receivable by him in respect of sales of any goods in the course of interstate trade or commerce made during any prescribed period and determined in accordance with the provisions of this act and the rules made thereunder. Then we are 8A, I skip over. Please take the last part of page number 12. This is 5.5. The term turnover for the purposes of this clause may be interpreted to mean the aggregate amount for which sales are effected or service rendered by an enterprise. If GST or any other tax is included in the sale price, no adjustment in respect thereof should be made for considering the quantum of turnover. Very clear. Trade discounts can be deducted from sales, Milord, we are not concerned. Then, if however, GST or any other indirect tax recovered are credited separately to GST or to any other tax account being separate accounts, and payments to the authority are debited in the same account, they would not be included in the turnover. Crystal clear, Milord. However, sales of scrap, etc. Therefore, Milord, it's very simple, Milord. We need not go into all these things also. Milord, GST is something, Milord, as your Lordship knows, Milord, from 1st of July 2017, Milord, GST has come. There is a paradigm shift, Milord, in the tax structure of indirect tax. But all the indirect tax, 7 except few like excise and all,
Correct, yes.
Bengal excise and all that, Milord, have been subsumed into, Milord, GST.
Correct.
Where, Milord, which is called a consumption-based tax. Why? It is a consumption-based tax because the entire tax is borne by the ultimate consumer. Now, from the manufacturer till, Milord, the retailer, Milord, they don't pay the tax.
Because it is
Because ultimately it is borne by
recovered from the consumers.
It's recovered from the consumers. Therefore, GST can never be a turnover of a person who is an intermediary in between. GST is always considered to be the turnover, if at all, of the government, of the state,
Correct.
or the central, whatever it is. Therefore, Milord, the case that is made out, sought to be made out before my lord is that why have you not written in the NIT that turnover will not include GST? But this is obvious. And Milord, we have referred to, Milord, going back to Milord, page number 78 once more. Please comes back to Milord, I'm sorry, 79 once more.
Yes.
It's there both at 78 and 79, but I think it's more specific period at 79, which says profit and loss account, audited balance sheet of any 3 financial years within the zone of the preceding 5 years, duly authenticated by so and so, so and so, so and so, under Form 3CA, 3CB, 3CD, under Section 44AB of the IT Act, as applicable to the bidder in each financial year.
Yes.
Therefore, this is not a thing by, where, my lord, the bidder is taken by surprise. It is also, my lord, there is no, my lord, there cannot be any confusion in it, because you don't pay, earn a GST. It is even if you pay, it goes out of your pocket. So it cannot be part of your turnover. And therefore, my lord, we have taken this view, well, which is, in my very respectful submission, a correct view. That we have not moved out from the 4 corners of the NIT to take a decision against Mr. Banerjee's client. This is number 1. Number 2 is, my lord, the complaint. My lord, yesterday, my lord, the submission was made on behalf of the petitioner that why have you not forwarded the complaint? Some X, Y, or Z has forwarded the lodged a complaint for which you have dislodged me, but you have not given me a copy of the complaint. My lord, please consider one thing, my lord. Your lordships have held that natural justice is not an empty formality. You have to show a prejudice that by reason of non-supply of this complaint, I could not meet this point.
But one thing you
Yes.
tell me.
Yes, ma'am.
Okay, he has submitted the certificate.
Yes, ma'am.
Rightly, wrongly, or intentionally, whatever it may be.
Yes.
But subsequently, as per the clarification which you have asked, he has given the clarification whether it is coming under the purview of fraud.
No. No, there are 2 things. Well, first is, my lord, that is why, my lord, my learned friend's client is comparing with other bidders.
I am not going on.
Yes, I tell you, lordship, yes, I get your lordship's point. Why is it fraud? And why is it not fraud for the others? My lord, it is not fraud for the others because the other people, they have included the GST component in their turnover, but even excluding, my lord, the GST turnover, then also they qualify. Whereas this person, he comes into the fray adding the GST in his turnover, but once it is deleted, he goes out. Therefore, the question is, my lord, is it an innocent non-disclosure? When my respectful submission is, my lord, this was deliberate so as to show himself as qualified. And this is, and my lord, this is not something, my lord, which was not known to him. My lord, we need to, my lord, distinguish between a mistake and a deliberate act. For others, it may be a mistake. But for him, my lord, it is very difficult to, my lord, say, at least the department feels that it is not a mistake, it's a deliberate one. But there are other aspects also. For example, my lord, to answer your lordship's query, I'll come back to, my lord, the series in which I was. My lord, there is a document. Please come to this form 3CD. Your lordship has found 3CA, 3CB, and 3CB. My lord, this. Oh, it is not part of the writ. But this is not part of the writ. I'm so sorry. But kindly permit me to hand over this.
बंद करो बंद.
It has been flagged for my lord's convenience. My lord, please take, my lord, the flagged page, clause number 26. My lord has found that one?
Yes.
So on the top left hand side, your lord should find the page number 66.
Yes.
Please take clause 26 over there.
Yes.
In respect of any sum referred to in clauses A, B, C, F, or G of section 43 the liability for which, Millard, my learned friend's client, does not make any declaration about GST over here, which he was required to make over here. So this is one thing. The other is, please, clause 40 also. Now please take me to the next page. That is page, page 67 at the top.
Yes.
Acknowledgement number, serial number, then next. State whether sales tax, goods and services tax, custom duty, excise duty, or any other indirect tax, levy, cess, impost, etc. is passed through the profit and loss account. Answer is yes. And then professional tax is rupees 2,500. So in respect of sales tax, GST, customs duty, there is nothing, no declaration.
No, state whether the sale tax, good tax, customs, excise duty, or any other indirect tax levy imposed, etc. is passed through the profit and loss. Acha. Yes, shown here.
Yes, so he was to Millard mention the GST figure over here. What he does is he only says yes. Well, he was to mention the amount. Please have a look to Millard. Just above yes, the amount column is there.
Amount column 0.
Yes. Now this is again Millard something to mislead. Now kindly take Millard clause number 40, which your lordship would find at page 73.
Yes.
Here again, Millard, the total turnover of the SSE, here again Millard, he shows it with Millard GST component.
Details regarding turnover, gross profit, etc. the previous year and the pending previous year. Total turnover of the SSC 20 crore.
This is all in, he has included GST. In it.
Yes.
Now, Millard, we give him a show cause notice. Please have a look to Millard, the show cause notice, which your lordship would find, Millard, at page 551. It is in the 4th volume.
Yes.
But here, Millard, we give him a letter saying that during final technical evaluation for so and so work, it is found that clause 26 of Form 3CD, you have only declared the professional tax but no declaration regarding GST was found there. Moreover, in clause 40 of the said Form 3CD, it was found that the total turnover shown inclusive of GST. Such submission in tender is treated as concealment of information to influence the outcome of the eligibility screening in the tender process. But this was the precise query of the court, that why do you consider it to be a fraud? We have said that we consider it to be a concealment in respect of submission of bid. But the rest portion I am not placing. Now kindly take Millard his reply to the show cause at page 552. Where it starts at page 552, it's a long Millard reply. Now please take Millard page 554.
Yes.
Please take the 4th line from the top. The said certificate of the chartered accountant was forwarded under cover of our letter of 26 August, wherein we had inter alia stated that as per NIT minimum eligibility criteria, B, financial eligibility, we had duly submitted the gross annual turnover of 30% of the amount put to tender, which is inclusive of GST amount. It has been further stated that in the NIT, the authority have also followed the same procedure for inclusion of GST amount while arriving at that amount put to tender. In the light of the submission, we believe that uploading the technical bid, the authority declared us as qualified considering the same basis inclusion of GST amount. Moreover, all the tenderers proceeded by process by the department were done with inclusion of GST amount both in the tender value as well as in the turnover value. The IT department also accepted the balance sheet inclusive of GST value as filed by us along with the IT return. Then, your Lordship may skip over the rest part. Now, kindly take para 5.
Yes.
With the 7th line, we are at para 5. Where a sentence starting with conspicuous.
Yes, conspicuous. Yes.
Conspicuous to note, the amount put to tender includes the element of GST and for obvious reasons, and or by implication, the gross annual turnover should also include GST. Thus, the qualifying criteria of 30% of the amount put to tender should be the minimum gross annual turnover. The bid submitted by us includes profit and loss account and balance sheet for all the financial years within the zone of consideration. Then we are skipping over the rest part of 5. Please take para 6. 4th line in para 6, 5th line. In the said memo, the ground for declaring our bid as disqualified has also been the issue of average annual turnover, and that too on the basis of complaint received from another bidder. No other ground whatsoever was considered on the basis of declaring our bid as disqualified. Then,
Yes.
Milord, in respect of clause form 3CD, Milord, the submissions are at para 11. It is noteworthy that filing of information in form 3CD along with profit and loss account and balance sheet is a requirement of the IT department during filing of IT return by an SSE. Therefore, Milord, they go on, Milord, relying upon the IT clause. And finally, Milord, at page 560, please take Roman 4.
Yes.
The disclosure in form 3CD, clause 26 and 40, which is part of IT return, has no bearing for the purpose of determining QR. But this is the final submission. Well, if I am bound by the clauses, he is also bound by the clauses. But Miller, they are trying to get out of it, wriggle out of it by saying that income tax has accepted. And this form 3CD has got nothing to do with the qualifying criteria. But this is the basic qualifying criteria.
Yes.
Then, Milord, the impugned letter, your Lordship will find, Milord, at page 750.
Impugned order?
Well, yes, impugned order, Milord, it starts at page
750.
750, I'm sorry. In volume 5, the last page.
Yes.
Well, please take note paragraph 4, where this is a detailed order. Paragraph 4, Milord, the 4th line. Apart from considering the submissions made by the bidder on 29th October, the statements made in the representation on 27th October has also been taken into consideration. The bidder suppressed the material facts and documents at the time of submission of its bid in the tender process initiated by the department. May I kindly take the next volume?
Yes.
Government of West Bengal. In terms of clause 7VB of the tender terms, the bidder was required to indicate whether annual turnover from its business for any 3 financial years within the zone immediately preceding the 5 financial years as stated in clause 4.2B4 of the tender terms was at least 30%. In the present case, it would appear that the tender that from the tender documents that the amount put to tender aggregated to rupees 75 crores. In order to establish the eligibility, the bidder was required to provide so and so, and in terms of clause 7.5b of the tender conditions of ENIT. In the present case, though the bidder provided the average annual turnover, however, the average annual turnover of the bidder was submitted, including GST component. Average annual turnover, also referred to the aggregate turnover, excludes central tax, sales tax, union territory tax, integrated tax, and cess. Average annual turnover, according to the guidance note, tax audit under section 44B of the Income Tax Act, could not be included in the GST component. Then where turnover is, what is turnover is stated. Then para 7. Thus, from the above, there cannot be any iota of doubt that a turnover for a business enterprise cannot in any manner whatsoever include the GST amount. Then we have said how he has misled in Form 3CD in paragraph 8. Then paragraph 9 also we have said the same thing.
Yes, you have clarified all.
I have clarified, to the going by the tender conditions and the Income Tax Act. Now, today, this is under challenge. But only one clarification. If your Lordship may kindly take me to page number 491. Where in that process, this Chakraborty, against whom so many things were submitted yesterday, where please take 491. In that tender, this Adhunik and Chakraborty, both of them were not qualified. Kindly see the
He is not qualified. That's why he has taken the plea. He is not qualified. That is then how the secondary has been taken as a qualified.
No, that is in a different tender, not in this tender.
Not in this tender.
No. The tender pursuant to which today adverse steps have been taken against the writ petitioner. In that tender, which appears from page 491,
yes,
these two persons did not qualify. In a subsequent tender, where the benchmark was lowered down from 22 crores to 18 crores, there they qualified.
So this is a different tender.
Yes, that's a different tender. Number one, and in that page itself, in that page 491 itself, your Lordship will find that in para 4, where there was a scope to complain. The petitioner did not complain. Within 24 hours of uploading the TBO summary sheet containing preliminary technical qualification result, any of the aggrieved bidders may seek clarification, redress, review of the tender evaluation cell within such and such.
Yes. So this tender of 2020 July 25.
This is of July.
Last date of submission August 25.
This is 12th of July.
Date of publication and the last date is 4th of July, August.
Yes.
Correct.
But the tender date was 12th of July 2025. Yes.
And
now, yes. Now, in that tender, these people, they did not qualify.
No, that's why. So now I am giving other thinking. And the present tender of which date?
The present tender is of data also 26th of September 2025.
Subsequent thereafter.
Yes.
Correct. Now
in the 26th September 25 tender, this Chakraborty has qualified.
Yes. Now, what I want to say, in that Adhunik insufficient codicil 7 IIE.
Right.
So this is not with regard to this.
Right. Your option is absolutely right. Okay. On a different reason, it was discovered. I'm told this is of prior experience.
Yes. Next.
Therefore, we have taken this decision where he was given a hearing. I'm sorry, he was given a show cause. He has replied to the show cause. We have given in details everything. No external things have been included in our decision making process. Therefore, my lord, in my very respectful submission, my lord, it does not call for any interference by this court. But one judgment will, if your lordship so desires, my lord, this is of 2024, volume 8, Supreme Court cases 284. Though, my lord, this is on VAT, but my lord, VAT and GST is almost the same. VAT did not include services. GST includes goods as well as services. And, you know, but this arose out of the Gujarat VAT Act. But please take paragraph 3. What is the question frame? Two substantial questions of law being framed by the High Court were as follows. Whether the Honorable Tribunal has erred in law and in facts in holding that value-added tax paid on purchases is required to be excluded from computing taxable turnover on purchases under section so and so. The second question is whether the Honorable Tribunal has erred and in facts by holding that purchases on which value-added tax is neither claimed nor granted are required to be excluded for computing taxable turnover. This is what our case is also. Now please take paragraph number 9. In brief, the facts of the case are that the respondent dealer, as mentioned, calculated the taxable turnover of its purchases within the state of Gujarat by excluding the amount representing the value-added tax and the value of purchases of which no credit was claimed. This was asserted to have been done under the provisions of so and so. Accordingly, the taxable turnover was calculated and proportionately reduced by 4% on the quantity of goods involved in the manufacturing of goods dispatched by way of branch transfer. The Deputy Commissioner during the process of audit assessment determined the taxable turnover of purchases within the state by including the tax amount, that is the value-added tax amount, and the value of purchases on which no tax credit was claimed by the respondent dealer nor proposed to be granted in the assessment. So the Deputy Commissioner includes. On the basis of this assessment, the respondent agreed, preferred an appeal before the Joint Commissioner, which was dismissed, leading to filing of a second appeal under the before the tribunal, wherein the same was partly allowed by holding that the tax and value purchases on which no tax was claimed nor was granted in the assessment could not be included in the aggregate of the taxable turnover of the purchases within the state for the purpose of reduction of tax credit. The state then prepared an appeal, etc. Ultimately, the Supreme Court, at para 17, I skip over 17, please take para 21.
Yes.
Or if I may read 20 also, where after the sections, please take the last 3 lines. Accordingly, the taxable turnover of purchases would have to be calculated after deducting both the components as have been detailed herein above. Therefore, the calculation of taxable turnover of the purchases and reduction value of purchases on which no tax credit was claimed nor granted and component of value-added tax already paid on purchases was rightly excluded. So there were 2 components. We are not concerned about the first component. We are concerned about the second component, value-added tax, which is GST over here. Therefore, this is the law of the land also. We have not done something which is contrary to law.
Yes, next.
And since your lordship is sitting in judicial review, just your lordship knows everything, just a half sentence.
Don't worry. By the side, Mr. Gupta is there. He will not leave you.
Yeah. No, judicial review means not deciding like an appeal, not acting as an appeal.
That is the perversity.
Well, your lordship is not concerned about the decision. Decision may be right or wrong. Your lordship is concerned about the process, decision making process. That is what I wanted to emphasize. Where this is BC Chaturvedi, 95/6 SCC 749. Your lordship must have while at the bar referred this in service matters. But primarily it talks about the power of judicial review. Judicial review is not an appeal from a decision. Para 12. Judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that an individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct.
Correct.
In the eye of court. But still, I have tried to show Miller, in the eye of court, Miller, my conclusion is also correct. The last judgment.
Here the inquiry report is the question.
Yes.
Yes.
When the inquiry is conducted on charge of misconduct by a public servant, the court tribunal is considered to determine whether the inquiry was held by a competent officer or whether the findings or conclusions are based on some evidence. The authority entrusted with the power to hold inquiry has given power and authority to reach the finding of fact or but that finding was based on some evidence.
That is settled now.
Therefore, Millard, I don't Millard emphasize much on this. It is a decision-making process. I have made the process as Millard tuned with Millard natural justice. He was given a show cause notice. He has replied to it. We have referred to the clauses and Millard.
That is not the point with regard to the natural justice. They are not taken the point. Only they have taken the point consideration.
Yes. Well, I have not shown your lordship the penalty clause. Do I need to show Millard?
Which one?
The penalty clause, Millard, your lordship will find.
Of the of this impugn order?
Just Millard, the clauses, Millard, which we have invoked. First, kindly take Millard, page 87, clause G. This is what they call first degree offense.
Achha, yes.
For committing first degree offense of any cases referred to in 11D 1 to 4, forfeiture of earnest money and debarment for a period of 6 months. Now kindly come to Millard 11D. Well, 11D, your lordship will find
Second degree.
86. According to me, Millard, yes, I and II.
False documents,
False information or false documents,
yes.
I and II will get attracted.
Yes. That's all.
But these are my thoughts.
Thank you. Thank you.
I would request Mr. Ashok Banerjee, it will be inappropriate on my part. It will be inappropriate in my part to make a counter submission which the learned AG has given. Mr. Ashok Banerjee wants a small accommodation on any other day. On Tuesday, because it will be inappropriate on my part. I don't feel it is correct.
Where is Mr.
Mr. Banerjee? Mr. Banerjee will give a response on Tuesday. He's engaged in some other court. He's engaged in some other court. That is the information I got. Tuesday.
The Counsel, Learned Advocate General has concluded his argument. Counsel for the petitioner pays for accommodation to give the according cases that go. I will give only 10 minutes.
That's it.
Only 10 minutes.
Yes. Only 10 minutes. No, only 2 points will.
2nd December. Under the heading adjourned motion.
A note has been handed up today. If required, I may take Millard 2 minutes. Or else, Millard, I am concentrated.
What is that?
Your Lordship, may I have your kind.
I'm grateful, Millard.
Thank you. Yes.
Your Lordship, I'm mentioning with your leave only. Last day, Your Lordship, the item number was 28. Today is 31.
Your Lordship, the matter could not be taken.
What can be done as per
Your
the
Lord-
system?
your-
It will
I
come
understand. I
serially.
understand, Your Lordship. Your Lordship, kindly.
Neither this court nor my court officer change the serial list. My lord,
Kindly
may I just
accommodate-
see as per your submission, I
Your
brought
Lordship,
from
it's very
NCR
short matter. It's
urgent
Your
motion.
Lordship, on Monday, on any time, Your Lordship, 10 minutes, Your Lordship.
Who is for the other side?
Other side, we have served the other side. First time, Lordship, it's coming for the first time. Your Lordship, 5 minutes.
What is the matter?
Your Lordship, the respondent authorities have flouted a scheme. According to that scheme, I have to offer my land and they will provide me employment. Your Lordship, I have provided my land, but no employment has been provided to me.
Employment?
Yes, Your Lordship.
Which kya? Coal India?
Yes, Your Lordship. Your Lordship, we are poor farm. Our agricultural land has been given.
The urgency on that.
Your Lordship, all the petitioners and their families are holding sit-out protest outside the office of the EOCL. Still, no services has been rendered to them, Your Lordship. And more importantly, Your Lordship, other petitioners have been provided employment for the same project. Item number 31, Your Lordship.
31 টা কি করব?
Amit Das versus Union.
করব। ये मंडे क्या है? मंडे तो फिक्स मैटर्स है ना? मंडे फिक्स मैटर्स है ना? और उसको भी रखा है। ये पार्टेड वालों को क्या क्या टॉप में रखा है? पार्टेड वालों को टॉप में रखा है। जो आफ्टर बिफोर लंच हियरिंग हुआ था उसको कब रखा है? बिफोर लंच हियरिंग नहीं हुआ था? नहीं, वो 12 बजे नहीं। अरे अभी लंच से पहले की हियरिंग हुआ था ना, वो कब रखा है? कौन सा दिन में टॉप में रखो बोला था? मंडे? मंडे टॉप है ना?
My Lord, may I be Tuesday, Your Lordship? Monday or Tuesday, Your Lordship? Anytime.
You not taken note? Urgent na. Urgent motion at the top, I told. Yes.
My Lord, may I also trouble Your Lordship for a moment?
36, Your Lordship.
No, no.
My Lord, may I trouble Your Lordship for a moment?
तो पार्ट सुबह हियरिंग हुआ था, कौन सा मैटर हियरिंग हुआ था? इसीलिए तो अब सब गड़बड़ कर देते हैं। 36 ना? 36 ये तो टॉप में आएगा, तो नोट लिख लेना। हाँ, मंडे टॉप। हाँ, ठीक ठीक ठीक। No time.
Your Lordship, Tuesday, Your Lordship.
Tuesday, that's why I'm checking all the.
So only 5 minutes, Your Lordship. It won't take more than 5 minutes.
इसको वो कर दो। Tuesday रख दो टॉप में कर दो।
May I trouble Your Lordship for
My
a
lord, may
moment?
I be permitted to mention today's list, item number 268. This was a fresh matter, my lord. My mentioning was allowed by your lordship's kind indulgence. Because the only predicament is my SLP is pending before the Honorable Supreme Court, which is listed on 2nd of December. Your lordships had considered my urgency and therefore agreed to list the matter today. Since it could not reach, my lord, I'm only praying that the matter may kindly be shifted from adjourned motion because this has never been heard. This is the
Is it pending with the Supreme Court? Wow.
no, the difference, my lord, I'll just take 2 minutes of your lordship's time, my lord. Because I was benefiting under a 2008 scheme promulgated by the state government. Thereafter, some litigation ensued between me and the state, which culminated into the filing of an SLP. Now, during the pendency of this SLP, my lord, the state government retrospectively revoked all the schemes. Therefore, adversely affecting my. Because I'm only requesting that the matter may be listed on Monday on an urgent hearing basis.
See, Monday onwards, then let the monthly list come, then I will adjust all this.
My lords, because the Honorable Supreme Court we have already sought time from the Honorable Supreme Court.
Monthly list will come.
Right.
Then you mention that I will take on the.
Because on the very next day, the matter would be heard by the Supreme Court. This is the case status, my lord. I'm showing.
Why you want this is to be listed on adjourn motion?
No, urgent motion because this has never been heard, my lord.
So why you want to
Because we have already sought some time from the Honorable Supreme Court.
For?
Because we have already intimated that I have filed a writ petition before this Honorable Court challenging the Revocation Act. Because may kindly allow me this indulgence.
Which act?
The Revocation Act, West Bengal Revocation Act. of the Industrial Schemes Act.
So there are so many petitions are there.
There are, my lord, absolutely correct.
So I think
However-
these matters are pending on 40. I will start on 14th of December or 17th of December.
In that event,
I have passed an order. All the matters of this regarding will fix on 14th.
but
or
no
17th.
notices have been issued in my matter, my lord.
Okay,
That
you
is
do the notice. Let come on 17.
on 17th of December.
I don't know when, 17 or 14, I don't know. I don't know when.
But in that event, may I just seek a small indulgence? The matter may be listed on, or we are being led by learned senior advocate, Mr. Andhati
Sorry,
Karju.
yes.
Your lordship,
5 minutes, my lord.
Your lordship.
No,
My
lord, may I just make a
Your
mention,
lordship,
my
under-
lord?
Have your lordships kindly to mention this is
Yes.
for my lord extension of interim order firing today. My lord, I'm sorry to my lord.
Which matter?
My lord, this is not on any lordship's list. My lord,
AP.
the section 9 application, my lord, is specially assigned before your lordship, my lord.
When it
Two
is-
section 9.
When it's going to be expired?
My lord, today, my lord. Today.
Where is the interim order?
My lord, your lordship kindly takes your lordship's order, my lord. The next page, my lord, 13th of
Uh-huh.
November 2025. My lord, kindly turns over, my lord, page 2, my lord. Your lordship will find, my lord, it's my lord till my lord 28th of my lord November.
Where is the other side?
My lord, I have given notice, my lord. Your lordship can find, my lord, the first. Mr. Ray was there, my lord, as my lord.
Ray is there. Where is Mr. Ray?
I should have been there online, my lord, but I can see him online, my lord.
Mr. Kali is here. Learned counsel for the petitioner. Submit that. Praise for extension of the interim order. According the interim order is extended
Sorry, sir.
till
39.
19th December 2029, 2025 or until further order, whichever is certain.
Your lordship,
Well,
under
it's there,
prevailing
it's there,
circumstances.
but, as item number 39. I'm sorry, my lord, it's there as item number 39 today.
39. Item number
My lord, may I make a mention? If your
Your
I'm
lordship,
grateful.
under
I'm
compelling circumstances, I am mentioning this matter. It is running in the list at item number 35. No, your lordship, under the appellate dailies list.
No mentioning. Yes, call
Your
all the original.
Your lordship, may I be permitted to mention this
just
matter? Reiterate my request, my lord. May I just reiterate my request? The matter may kindly be listed from Monday.
Already in the list.
It is on the list. It is listed. It will not reach. I'm only praying that your lordship may list it on an urgent hearing basis on Monday. That's it. Nothing more, my lord.
Lordship, may we be permitted to mention this matter for non-prosecution? It is appearing at item number 26 and 27 in today's list. Original side. Original side.
Then let's go list down. To be mentioned for withdrawal. Yes, call the list.
My lord, may I seek my lord's leave to mention, my lord, one matter?
Huh?
My lord, may I seek my lord's
Mentioning
leave?
over.
My lord, one matter, my lord.
Yes.
Yes, my lord, recalling application, my lord, the determination is with my lord Justice Ray, but as it was your lordship's order, so my lord Justice Ray has released the matter, my lord, asking the matter to be listed before your lordship, my lord. My clerk is there with the my lord order sheet. If it could be, my lord, given.
Nobody's here. Nobody's here.
Yes, my clerk is there. My lord, my clerk is there. He's handing over the. Yes, my lord, handing over the order, your lordship.
Item number 1.
My lord, any day subject to your lordship's convenience. Deeply obliged.
GA5 of 2025 is dismissed. Grateful. Yes, next.
Item number 2.
I'm led by Mr. Ray, my lord, who is there.
Well, this for extension of interim order, your lordship will kindly consider.
Interim order. Well, like, interim order needs to be extended. Well, along with that, well, there was a direction to file, well, the facts and figures, calculations of the areas of last 50 years. Well, we have prepared the affidavit, but the calculation has not come from the authority. So I am seeking extension of that, well. If lordship kindly grant me 2-3 weeks extension to file the
Authority is taking time for calculation for 3 weeks.
18 September was the date.
Accountant and all these things.
No, I do have. Well, I do have. Well, kindly appreciate my.
Accountant.
Well, the predicament is that. Well, I have to calculate from the year 1974. That is the problem, Malan. That is the problem. Malan, I am.
Malad, I will be very happy if he does that, Malad. Because, Malad, my case is from 1974. They are already proceeded under the PP Act and they have lost up to the appeal. So they are again rewriting the same case. So let them do that, Malad. That is my case before your lordship. that once they are hit by that, my lord, how can they initiate fresh demands, my lord? That is my case. And now they're again calculating for 76.
So I am not arguing on merit today before your lordship, my lord. Kindly, my lord, see paragraph 10 of the order, my lord.
Yes.
Kindly
Interim
extend
order
it,
is
my lord.
there.
Yes, interim order is there till the 28th of November.
Sir, where is the interim order?
My lord, paragraph
Okay,
13,
okay.
my lord.
Paragraph 13.
Counsel for the respondent. Counsel for the respondents. Prays for extension of time to prepare and circulate an affidavit disclosing the figures and the dates of the rent paid and enhancement of the rent, etc. Let affidavit be filed by
3 weeks, my lord. Last chance.
by
by
18th, by 17th of December 2025.
Lordship, I'm grateful, my lord.
After serving the copy to the learned counsel for the petitioner,
There was an
so
opportunity
you will you will file an exception.
to deal with the same
Yes, my lord.
within a week from the reopening, my lord.
If any be filed within a week after the reopening of winter vacation, please the matter on 13th of January 2020.
Great. Well, the interim order be extended, my lord.
Interim order is extended till 16th of January 2026 or until further order, whichever is.
I am grateful, my lord.
Very grateful, very grateful.
So, Lord, 3 and 4, Lordship, is pertaining to that reconnection of electricity, my Lord. Lord, in terms of what had fallen from your Lordship, my Lord.
Where is Mr. Sanyan?
Possibly is appearing online.
Yes, my lord. My lord, kindly excuse me.
My Lord,
Where is your calculation?
yes, my Lord.
My lord,
This
my
is the
junior will
outstanding-
hand over it to your lordships the calculation.
দিবি আমায় একটু কপিটা দিবি একটাই কপি
7 lakhs আপনি
একটাই কপি yes my lord. Well, that is the outstanding bill which I've handed over, and he has handed over an the bill.
7,36,387 plus DPS.
And we paid 3 lakhs.
50% of total payment.
Yeah, right.
Reconnection charges equal.
And the shortfall of security deposit and reconnection charges.
Correct.
My lord, I have twofold of submissions, your lordships.
Yes.
The first, your lordships, he has to pay the current bill along with the installment. Whatever your lordship grants the installment, he paid for 2 installments. So, my lord, he has to pay with the current bills.
Yes, that's correct. He has to pay the current.
I have already paid.
And no,
I paid
with the
yesterday
current
3 lakhs
bills, the
rupees.
installments have to be paid.
Okay.
And the second one, your lordships, in case of any default of payment of any installment, kindly give us the liberty to disconnect the supply.
Agreed.
Sure.
And
But
then
I've already deposited 3 lakhs yesterday.
And
And my lord,
third
I will
one, your
deposit
lordships,
anything your lordship directs today, whatever is the.
What you deposited?
I've already deposited 3 lakhs yesterday. Before the matter, I didn't have instructions on that. I've already deposited. That's one part of it. The other is, my lord, now that there is around 4,36,000 which is outstanding. I'll deposit around 1.5 lakhs today. Let the, my lord, the writ petitioners in item number 3 deposit 1 lakh in court. Balance I'll put in within 45 days as you had fallen from your lordship. And rest of it, we can fight it out in the suit. There's no difficulty. And the 1 lakh also I'll not withdraw subject to outcome of the suit. But let him deposit something. Those 59,000 as has fallen from your lordship with regards to the bill of July. He has paid the entire amount. I'm showing the bill of July, my lord.
Where is the earlier?
Yes, my lord. Here it is. This is the bill. Kindly seize, my lord. That is the bill of July, which he paid on 15th of August, which comprises of. Kindly seize, my lord. Maintain electricity, utility, maintenance, rent, parking, everything.
Yes.
But I have taken instruction, my lord. My case is very short. Till the disconnection in 18th March 2025, I have paid the entire amount so far as electricity bill is concerned. That is recorded by this honorable court in the earlier
No.
order of August. And
That's why
my lord, may
59,455.41.
that I have paid. Not only that, thereafter also. That is the bill of my lord August. That is August. Subsequent that also we have paid, and that is recorded in the order of this honorable court. Which order? Previous order dated.
Which order?
Previous order, kindly see. 27th August 2025. Petitioner asserts that all outstanding electricity bill have been paid in full, whereas the respondent number 6 and 7 contain that an amount exceeding 60,000 remains unpaid by the petitioner in respect of electricity charges. Thereafter, my learned the annual report for the CSC was given by the charge, next paragraph, such and such, to my lord, see that the relevant documents of both the parties. But on the basis of that, I submitted this document also before this honorable court, that by way of document and supporting document and their bill, we have paid the entire electricity charges till the disconnection.
He had made an explanation showing that he had made payments towards
Till March 2025.
Yes, when the disconnection were effected. So, my lord, the suit in respect of other charges, it may be their legitimate claim. I am saying it is a disputed. That is the jurisdiction of the civil court in a pending litigation. So, I humbly request your lordship to submit before your lordship, my lord, kindly, my lord, let the civil court decide in its own, because we also might have a certain claim over there in respect of that. Because previous also we paid 5 lakhs, 2 lakhs in certain amount of time money we have paid. So, my lord, kindly let electricity be restored, and whatever amount on account of electricity, I'll definitely
So
pay.
you do one thing. Whatever the electricity amount you pay regularly, whatever the other amount you pay regularly in the deposit in the court.
That the civil court will decide.
That's why you
Yes.
deposit in the court, that will carry the
Whatever be the
interest.
electricity
Just
amount.
a minute. Whatever the electricity bill monthly, you are telling that till March you have paid. Correct. On March it was disconnected because you are not paid the utility maintenance other things.
Yes.
Correct. And you are disputing that you are not liable to pay that charges, utility charges and the maintenance.
Rent and other components.
Whatever it may be. So it is your contention. Now they have filed the suit recovery of the amount with regard to that.
Absolutely.
Now your contention is that you might have been an claim in the civil suit also. The civil suit is to decide with regard to the utility or maintenance charge.
Except electricity, other charges.
Other charges, correct. So that, okay, you paid till the March. With regard to other charges, whatever it is, what is the due? You deposit in the registry. Either he will take and continue deposit whatever the maintenance in the trial court, in the civil suit, and it will decided if you're entitled to get, you take back the amount. If it is not, they will get the amount.
Because the civil suit that they have then application pending there. Injunction application is going to be hard.
Whatever it is, I am deciding here in now the injunction.
Regarding the electricity charges, my lord, kindly give a specific direction that whatever unit consumed by me, I'll be paying the electricity charges.
See, sir. The electricity company, have you gone through the KC 9 case?
KC 9, yes.
KC 9 case. Yes. It is the company has to maintain all the things. Only by paying a charges, it is very difficult for the company to run the company. Correct. They are supplying you with regard to utility maintenance. I don't know what is the agreement entered between you and the other party with regard to utility maintenance.
But they are paying.
But you have paid till the month of August on the last occasion. You have paid 59. That is including
included here also.
Correct. So that's what I'm telling. I am not telling you. You pay to him. You pay the electricity charges continuously, whatever the bill raised, and regarding the other bills, other charges, you pay before the trial court. Month by month, it may deposited in the trial court. Decide yes, you are not entitled. You are not liable to pay. You take back the amount. If you are not liable to pay.
But with the best of respect, that amount has.
So then I am dismissing your assert. You go and pray before the court for interim order for reconnection. I am not interfering with your writ petition. That's all.
I leave it to your lordship because my lord, my fact remains that my lord, they have not a single piece of paper showing that the other charges.
Like you have paid last. See, anything is to be decided the last pay.
But
you have not challenged that.
A single proposition of law, unless it pains, no one goes to the doctor.
unless an illegality comes into the light of the day, no one
For
comes to the
20 years
court
he
of
has
law.
paid.
Yes, because
And 20 years he has got the
person
maintenance charge.
a person is
He
paying
becomes
rent.
wise.
Only one thing, Manu. A
That's
person
why
is
I'm telling. That's why I'm telling. I am not telling to
One-
pay
one-
to them.
Yes.
Deposit in the court, so
let-
that you can also get the security. There
Right.
will also be security.
Yes,
that
the
your relative can-
injunction order they are praying. My lord, the civil code will give certain terms on that. Give certain terms. Unless I pay, I
I
can't
don't
use
know.
it.
I am not in the civil court jurisdiction.
Now, if my
This
lord's
court is
order,
the writ
my lord-
jurisdiction. You file the writ application. Now the court can.
with the best of respect, my lord is always reasonable to us. My lord, with the best of respect, my lord, if any observation regarding the other deposit, that would
Subject to outcome.
Well,
I am not deciding. Subject to outcome. Till that time, you deposit.
rent, they are not the owner, not even
Of
my
course I am. Otherwise, why would he tender?
I have
There are two parts to the.
That's what the court
My
is
lord will
not
not go into
deciding.
that. My lord will not go into that.
Correct.
In that case, directing me to deposit that amount on account of that, that will be harsh on the part. My lord, it will be on me.
Then, my lord, let
on the
your
petitioner.
subject to what falls from your lordship. Let him deposit the electricity charges at least 1 lakh rupees in court before this court. Before this court, because I am disputing that he has paid the electricity charges. I am disputing.
Court
Has not held. It's a absolutely incorrect statement. Lordship will kindly see the order of the coordinate bench. It says he alleges. If the court records he alleges, does not mean that the court has held and that it's an admitted position. Kindly, my lord, he should refrain from making these statements.
On 27th August order, after later to my learned friend of for CSC, court being satisfied, pass the order, which they are trying to that order of disconnection.
No.
Disconnection is not my only intention. I am not on that. Let them enjoy electricity, anything. My problem is that my connection is, my lord, is disconnected since March. I am ready to pay electricity.
You're not staying there.
Regarding the
I am facing the brunt of the problem.
to civil court, and my lords had past experience regarding my adjudication in civil court. When any order passed from your lordship, that will be my lord. That will.
So that's him. I am passing this order without going into the merit of the case, and the civil court.
Yes.
Civil court
Yes.
deal with all the matters on merit.
Lordship.
If at all any observation, that will not affect your suit.
Because they
That's all.
approached the honorable appellate court from their order of the civil court, city civil court refusal to pass any order of injunction. The honorable division bench of our high court in an appeal in this matter, in that particular suit, directed you go and pray before the landed the court below. So any order passes from your lordship in this writ jurisdiction, that will harm my case in the
So
defense.
in that case, okay, then you also go to the civil
But
court,
I-
and pray for injunction for restoration.
That I leave it to your lordship. Man, I am before your lordship.
I don't want to suffer that, my lord.
No undisputed
Lordship restores the electricity at
That
my
was the
cost.
confidence I have.
His electricity till the time he deposits, I am not under any obligation to restore. He's not willing.
Whether your utility charges and the maintenance is increasing or the same.
No, my lord, it's the same rate. It's been going on.
It is continuous.
It is continuing on a regular basis. I have, my lord, kindly sees, my lord. It is electricity. If you're, I can hand over that bunch, my lord. There are bills from 2024. I've handed over that bunch, my lord.
Yes.
Lordship kindly sees there is nothing which is in excess, and there's no increment.
No, but you have how the parking charge?
Because, my lord, he doesn't have a parking spot. So he's parking his car. For that, the charges are being paid.
How the parking charge? Electricity.
Kindly sees, my lord,
The
not for,
electricity, yeah, it is a utility bill.
he's parking his vehicle there. And parking is zero.
No,
Whichever month he parks, my lord, that is the only month. What he does, my lord, I'll just indicate. He doesn't stay there. So he lets out his own parking spot, saying that you go and park there, and he collects money. From that, he pays us.
Yes.
And there's nothing which is exorbitant, my lord.
That is my substance of my submission, my lord. My lord will not pass any order, my lord, with the best of respect. That will, my lord, take my case there in the civil court. My lord, I leave
No,
it.
let him deposit electricity charges in court. Here.
You have to deposit something.
My lord,
In
on
court,
account
let
of
him deposit
electricity,
today.
If my lord directs directs to pay me something on account of electricity as way of advance.
No.
Because because on account of other charges, the civil code is staring at us.
My lord, there's a
Adjudication is pending, my lord. Civil code will pass the order.
You have paid the till the last
till
of
July
your
bill, he has paid.
Who has not even a owner of a property, my property.
Then why do you pay rent to me?
Yes, I have paid wrongly. I am making this submission.
You
because
very good.
I have
Lordship will record this, my lord. Lordship will kindly record that he has paid rent wrongly.
And what application you filed in the civil court?
So he becomes an illegal occupant.
They have filed application restraining me. What they have, because I
They filed a suit.
They filed a
Recovery
suit
the
along
amount.
with an application.
They filed an application for recovery of amount. You for what?
No, non-recovery. I am told that they have filed an application restraining me from using the parking area unless that amount is secured.
Because it's a common area.
Application has rejected.
What is the suit for?
Suit for money. Money.
That's I'm telling. They have filed a recovery of money.
Money.
What is due?
Yes.
Correct. What is your contention? What application you filed before the civil court?
Nothing.
There is a dispute in the amount because the parking charges they cannot charge in
That is your written statement. That is your written statement. What is any application is filed over there?
He has not filed anything.
No. Service has not been effected. I have told. That is my instruction.
What?
Service of summons has not been effected till date.
So you are not entered into the suit.
I have not entered into.
They have
the suit
entered.
because
They have appeared before the court.
their opposition, they have disclosed the suit.
Okay.
From the CIS records of this honorable court, I have come to know about the order passed by this honorable court.
Okay. Okay. I am passing.
Yes,
Yes, my lord.
I leave it here.
But you. How soon you pay the rest?
Lord, I have put in 3 lakhs. Today I'll put in 1.5 lakhs.
Today.
Balance there will be, my lord.
Today again you are putting the 1 lakh.
Yes, my lord, 1 lakh.
Yes.
Balance will be around 7.36. 3.36, not 7. 3.36.
As per your
Mine's-
there.
Yes,
7,36,387.
Yes, my lord.
Correct.
4 I have already paid.
57 will come 3,68,194.
Yes.
You have deposited 3 lakhs.
3 lakhs I have already deposited. 1 I'll do today.
Today you will deposit further 1 lakh.
Yes, my lord.
Correct. So remaining it will be a 2 lakh something, 2,66,000.
3 lakhs something. my lord.
3 lakh 70.
3 lakh 36,000 will be due.
3 lakh 36.
Lordship
No.
gives
3 lakhs if you paid the 50% is the 3 lakhs 68,194.
Yes, my lord.
The total is 7,36,000.
Yes, my lord.
50% will come 3,68,000.
Yes, my lord.
Correct. That 3 lakh you have deposited.
Yes, my
Now
lord.
further you will deposit the 1 lakh.
Yes, my
So and the additional security charges of 1,64,554.
That also I'll have to deposit. I will do it.
When you deposit.
Well, it's one submission.
When you will deposit.
In 10 days time I'll do it.
10 days. Then the reconnection charge you have to pay.
Yes, I will do it.
Yes.
The one submission, well, it's kindly peruses my instruction where it is written 50% of total principal dues additional security reconnection. The total amount comes to 5,33,448. Now, assuming they have paid 3 lakhs, which is subject to payment, I have taken specific instruction. We haven't received it yet. Might be cleared in one day or 2 days. So when I subtract in good faith out of that 5 lakh amount, 3 lakhs, the amount comes to 2,33,448. I'm saying this.
See, the total is 7,36,000.
That is due on account of unpaid electricity bills.
Correct. Come on that
Yes.
first. 7,36,387. The 50% will come 3,68,194 of the due.
Due.
Correct.
Due.
So he is telling that he has paid the 3 lakhs and 1 lakh today he paid it. The 4 lakhs he will pay. If minus 4 lakhs it will come, then again the 2 lakhs something will remain. 2,68,000 will remain. So he will pay within 45 days the 2,68,000. And the additional charges is 1,64,000.
Yes.
Additional security charges.
Yes.
Correct.
And the reconnection charge, my lord.
Reconnection charges.
And my lord, one more thing, my lord, may I assist your lordship? One more thing. Any payment of regular bill by installment.
And he will continue the regular payment bill raised by you. In case of default of any of the month, you are entitled to the.
And my lord, one more point, my lord. One more point. My lord, payment by installment of the regular bill will attract as per regulation late payment surcharge. That they have to pay.
Okay.
Much obliged to your lordship.
So what about this? How soon you will pay the electrical charges?
The electric charges till March we have paid.
You have paid.
If the reconnection is given,
What is
I'll
what
pay
is
the
the procedure
reconnection
for
charge
reconnection
and
by
the,
your
and the
you?
current
Lord, they have
electricity
their dues are 3,27,000, which is including everything. I'm only if the electricity is taken into account, it should be around, my lord, should be around 1 lakh rupees at the most.
What?
If only electricity.
Electricity.
Yes, it will not exceed 1 lakh.
What 1 lakh? For?
The electricity charges. It's not for maintenance. I'm saying.
He has not paid the electric. Yes, you're disconnected on March.
Yes, my lord.
March.
I'm talking about March 24 to March 25, which he has not paid.
There is no
I have
electric
paid
connection.
by a letter and document. I
There is
have
no electric
substantiated.
connection.
Lordship,
There is no electric connection.
there is no electricity connection from March 25.
Correct.
Previous dues are there, which he has not paid.
But he has given the details.
What he is saying,
Excess amount paid. Excess amount paid.
every statement contradicts his own previous statement.
A letterhead of my advocate on record, Chatterjee Seal and Company, my lord, kindly see
Kindly
that
see
details is given.
It is addressed to whom?
And being
Kindly
satisfied,
see, my lord.
pass the order of
You
disconnection.
have given some.
Yes, my lord.
Letterhead.
It's a letterhead of their advocate on record.
This is the document.
Addressed to whom?
Pursuant to this honorable court's direction.
Where is their?
Mr. Chanyal.
Where is their?
Yes, my lord, this is the document. One can see this.
Yes.
Would your lordships
Entire amount rather than excess some amount is paid. My lord has got it. I have got extra copy.
Yeah.
Kind.
Yes.
Well, past 27th August order, whereby my lord Mr. Soham Sannal was given my lord to see the look into the
Mr. Ghosh.
My lord.
Have you received that?
Yes, I have given a copy.
I have got
Can you
it.
see this calculation he has given?
This computation, my lord. Lordship will kindly see what he has
The
done.
referred page is also
Oh
given.
no, Lordship will kindly see what he has done.
Proof of payment is also
He has the bills Lordship has seen.
Hmm.
Those are composite bills. He has segregated the bills as per his own desire and only paid the electricity component. The process is, my lord, there are communication between the parties where, my lord, a part payment is first adjusted against the maintenance. So what he is saying is this: no, you will not adjust against the maintenance. I will only pay the part of the electricity. So he's saying electricity is paid. But the bill is not just for electricity. He's getting utility services, he's getting maintenance, he's getting parking, but he will pay only the electricity component. So I've adjusted, it's been adjusted against maintenance. So these
Lord, it is a fully disputed questions of fact between the two private parties.
Yes.
They are invoking the jurisdiction of your lordship's high prerogative
may
writ
I,
jurisdiction.
I think Mr. Channel
Mr. Ghosh, you are just entering into a dispute which
between
do
the
not
parties
come
is not
within the
required.
law of the public
You can
element.
only indicate what is due to the CSA, I'll pay that.
being
I am
satisfied.
there is no
of
satisfaction.
Compliance of 27th August order that I have paid.
Kindly seize the order.
Electricity bill. I'm coming to that. I'm entire electricity bill, my lord, disconnection. I have paid the entire amount.
Kindly.
Regarding his segregation, his bill itself segregates the electricity held separately, and I have paid so. And regarding the rest of the amount, they have resorted to the civil court.
Kindly seize the order of 27th August in that bunch. It records.
Where is the civil suit?
Civil suit, that is their opposition.
Well, it's part of my writ as well.
That is opposition.
It is part of my writ.
Opposition, my lord, kindly see, take my lord, Shriti Sharaf's opposition, 5th of August, 5th of July 25, page 37 onwards. Page 37 is the prayer portion, and my lord, kindly see, it starts from page 27. 27 to 37. And the figure is also matching.
Kindly
So
see,
kindly come to the prayer D. So I am referring the matter to the civil court. You go and agitate before the civil court. This court is not going to decide anything.
well, only with regards to the electricity charges. Well, I'll reconnect if he puts in some money.
He's adamant. What can be done?
My lord, it's a no question of
Lord, this is,
You go.
we are asking for 1 lakh.
Lordship sees.
Yes, yes.
My lord, Lordship.
My lord, up to my lord.
Only one
may I
thing, my
submit
lord.
only one thing, my lord,
His
only
writ
one
is
thing.
also about reconnection of electricity.
My lord.
His writ is not about not reconnection. So if he seeks reconnection, it also entails that he will pay some charges. I am bearing the cost entirely. It cannot be equitable that I'll bear it entirely and at my expense he'll enjoy electricity. Let him put in some money, my lord, for only
Ready to just
my lord, it's a direction of court. Because it's a direction of court,
He
my
is
lord.
not agreeing to pay what the
My
court
lord,
can
my lord,
pay.
it's not.
And your priority is something else.
My lord, my priority is for the entire composite amount.
Correct.
My lord,
So
now,
how the red court can decide all the
my
disputes?
lord, lordship
Let you
sees prayer A of his writ petition. Prayer A is reconnection of electricity.
reconnection, you are putting the connection, you are putting that all the payment is to be made.
Yes.
And you have filed a suit. In the suit prayer D, you are telling that all the utility is to be paid.
Yes,
The court can now in the sitting and unless and until is agreed, the court cannot pass an order.
My lord,
Correct. And whether he is entitled to payment of the utility and all these things, that cannot be decided.
no, that cannot be decided.
Let
In
he
so far
go,
as-
let he go to the civil court, file an application for reconnection.
Very well.
I will clarify in my judgment.
Very well, my lord.
I will clarify. in
Very
my
well, my lord. Well, I will put in the money as directed. Lordship will reconnect as far my property is concerned.
It's a licensee is drawing electricity with an undertaking that he will supply electricity to others.
Go to the civil court, you argue all the
Yes, my
matter.
lord.
Go to the
As far as my part, I'll put in my lord the balance one.
dispose of.
Yes, my lord.
My lords, one submission. My lords, kindly won't take me amiss. On the earlier occasion, yesterday, your lordship was the opinion 50% of the unpaid charges will be paid along with the security deposit and the reconnection charges for reconnection to happen. Propose what has fallen from my learned senior friend. He has paid 3 lakhs subject to payment. He'll pay 1 lakh today. What I am beseeching my lords is that this 1 lakh plus 3 lakh, 4 lakhs is lesser than the amount what your lordship had told on the last occasion. Is lesser because your lordship's direction was 50% of the unpaid amount plus additional security plus the reconnection charges. That comes to 5,33,448. But if my learned friend is
Sir, you have given the chart. Yesterday, what I was trying, then you, Mr. Sanya, told that he will give the chart. He has given the chart.
I'm saying, my lords, on the bottom portion of the charge, kindly, my lords, peruse 50% of total dues is 368194.
Correct.
Now, if I add 1,60,000 in terms of security deposit and 600,
Correct.
I am saying the total amount for reconnection to happen comes to 5,33,448. But now my learned senior friend is saying he wants reconnection because he has paid 3 lakhs and he will pay 1 lakh today. So the total amount is 4 lakh, which is less than this computation. This is what I'm trying to harp upon.
My lord.
So, please understand. Your total due is 7,36,387. 387. It is the total due.
On account of non-payment of electricity bill.
Correct.
Yes.
Correct.
Yes.
Now, what is coming to that? 3,68,194.
Yes.
That is a 50%. He has to deposit.
Along with, yes.
Just a minute. He has to deposit plus additional security charges plus reconnection.
Yes.
He has to deposit that. Then the remaining 50%, he will
Fair
pay
enough,
the
my lords. If
45%.
that's the direction, be fair.
That direction will pass. Since beginning, I am
Much
taking
obliged.
that
Much
on.
obliged.
He is telling that he has paid the whatever he paid. He has to pay the 50% plus 164 plus 6.
Much obliged. Much obliged.
That's all. Correct.
I will do that.
Satisfied.
Much obliged. Don't take me.
So grateful.
And the balance may up
Balance
to your lordship.
Within 45 days,
I will.
he will continue to pay the
regular bills.
Bill you raised, he will
Regular
continue to pay without. If he failed to pay this regular bill, then you are on
Disconnect, and also if he fails in the installment.
Yes,
Much
yes, of
obliged.
course.
I am going with
Grateful.
empty hands.
What can the court cannot do anything. In the jurisdiction, the court cannot decide the civil suit.
Yes.
I would try to decide, but you are not agree for that. Yes.
Item number 4, I am agree with the state case.
Give the name. Give the name.
Well, the 3 p.m. No, order debe এখন না Mal will pass order now in that manner. Mal the 3 p.m.
Your persons will allow me to dictate.
No. Mal 3 p.m. fixed matter. Milan Mr. Drole is here. He is saying that we can conclude today.
Conclude.
If Milan sitting, we have no difficulty. We are here.
Conclude. I am here.
করে দিন আরে ঠিক আছে আমরা আছি তুমি যাও না
Item number 3, what is give the name to my court officer? They will include their name.
মনোজ স্যার দাও
इसको भेज दो.
वो घर में वहां दे दो.
Yes, sir, on the last occasion, my learned friend concluded his argument. Now, my lord, I am giving a reply to the argument led by Mr. Dasgupta. My lord. Here, my lord, Mr. Dasgupta took point of that my point was limitation, my lord, and then he replied to the limitation. My lord, limitation, my lord, I said, my lord, that the claim, money claim, which was, my lord, aided by amendment of the plaint was time barred. My lord, originally suit was filed, my lord, in 4th of March 1914, my lord, and then, my lord,
1914.
2014, my lord, 2014, my lord, it was filed, and then, my lord,
If it is the 1914, then I have to pass the judgment here and now.
Yes. Then, my lord, then, my lord, this was the suit for injunction against the encashment of the bank guarantee. My lord, subsequently,
Just a minute,
my
just
lord, the suit was, my lord, the plaint was amended, my lord, and on 6/6/2017,
Yes.
my lord, a money claim was added in the, my lord, the civil suit.
Correct.
By amendment.
Yes.
So, my lord, I took the point that this addition was barred by limitation. So, my lord, my learned friend submitted on the last occasion that the plaintiff had made a reference of this amount to the arbitral tribunal, and the arbitral tribunal, on the ground of pecuniary jurisdiction, my lord, it was rejected. This was the ground taken by my learned friend. But in reply to that, my lord, I submit, my lord, defendant railway in this regard submit that a time barred money claim cannot be made by amending the plaint. The defendant railway further submit that section 14 of the Limitation Act 1963 provides exclusion of time.
That you already argued on that point. That you already argued that.
Here, my lord, that provision was not cited. This provision was not cited, my lord. Then this 14 exclusion of time proceeding bona fide court without jurisdiction have not been complied. No, there is a provision, my lord, to be compliance of that section. And what is that, my lord?
Which section you are referring to?
I am referring, my lord, section 14 of the Limitation Act 1963. Kindly have a look. My lord, I am having it. Give it.
Yes.
My lord, the section 14, my lord, this starts exclusion of time proceeding bona fide in court without jurisdiction. My lord, then, my lord, in computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against defendant, shall be excluded. Where the proceeding relate to the same matter in issue and is prosecuted in good faith in a court which form defect of jurisdiction or other cause of a like nature is unable to entertain it. So this is regarding the suit. And in 2, my lord, it is stated regarding the application. So we are concerned with the, my lord, rule subsection 1 of the 14. Then, my lord, subsection 3, my lord, this required the compliance. My lord, subsection 3, my lord, notwithstanding anything contained in Rule 2 of Order 23 of Code of Civil Procedure 1908, the provision of subsection 1 shall apply. In relation to a fresh suit instituted on permission granted by the court under Rule 1 of that order, where such permission is granted on the ground that the parts suit must fail by reason of defect in jurisdiction of the court or other cause of like nature. So here, my lord, it requires, my lord, that if it was proceeded in a wrong forum and they are asking for exoneration or that excluding.
Why you're telling that it's a barred by limitation?
Milord, this Milord.
When you cancel the revoke the work order.
Milord, I revoked the order on.
You cancel the work order.
Milord, I cancelled the work order, Milord, on 5th.
Huh?
On 5th March 2014.
5th March?
6th March.
6th March
2014.
2014.
Milord.
Correct.
Yes.
Yes. Then.
Yes. And this Milord, the this claim was made on 6th June 2017.
6th June
2017.
2017 suit filed.
Suit filed.
Yes.
Milord, that amendment, by amendment, this amount incorporated.
When the suit filed?
Suit was filed, Milord, in 4th March 2014.
2014.
Milord.
Suit filed.
Milord.
12th March
2014.
12th March 2014. 4th March 2000.
Prior to the Milord cancellation.
Correct. 4th March 2014 suit filed.
Milord.
Correct.
Milord.
Yes. Then amendment was carried. Amendment was filed on.
Amendment was made, Milord, on 6th of June.
6th June 2017.
2017.
Amendment.
Amendment made. So this is more than 3 years.
Amendment. Amendment was allowed.
Amendment was allowed.
Yes.
So
when amendment was allowed.
Bank amendment was allowed, Milord, and the money claim added. And Milord, so far the Milord, under the Limitation Act, Milord, the breach of contract, the limitation provided 3 years from date of cause of action.
Correct.
Milord, cause of action arose, Milord, when the termination took place.
Correct. Termination was March 2014.
Milord.
Correct.
Milord.
4th
5th March.
6th March.
6th March. 5th March.
5th March 2014.
Milord.
Termination was done.
Milord.
And he filed prior to that. He filed the suit, revocation, praying for against you to revoke the bank guarantee. Correct.
Milord, he filed the suit, Milord, on 4th March.
4th March 2014 with the prayer for not to revoke.
Not to
revoke
the bank
guarantee.
Milord.
Correct. Now on 6th March and 5th March you have terminated
terminate the contract.
Terminated the contract.
Milord.
Correct. Then 6th June 2017 he filed an amendment application.
Amendment application.
So you are telling that the amendment your work order, the termination of the contract was 6th March.
5th March 2014, and this inclusion of the claim is, Milord, on 6th June 2017. More than 3 years.
So that was after 3 years.
More than 3 years.
3 days delay. 3 days, 3 months.
More than that. Milord, this is March and June.
3 months.
3 months. 3 months delay.
3 months.
So it is barred by limitation.
Okay.
Milord, Milord, here it what requires, Milord, that if this period has to be excluded, there should be an application under section 14 of the Limitation Act 1963 and asking for leave.
When we invoke the provisions of arbitration?
Look, arbitration.
When we initiated the arbitration proceeding?
Milord, it was about, Milord, 2015.
2015.
Milord.
When the arbitration was terminated?
10th January 2017.
No, when you invoke the arbitration.
Milord, I invoked Milord in 21st February 2014.
21st February 2014. Filed arbitration.
Yes. That was Milord rejected ultimately because the claim was more than 20% on 10th of January 2017. Milord, I handed over a compilation of the orders.
Yes. Let for this.
Then Milord amendment made.
When it was rejected?
10/1/2017.
10/1/2017.
Amendment made in March.
17. Arbitration. Yes.
Therefore, Milord, after the rejection of the Milord on the ground of jurisdiction by the arbitral tribunal, proceeding in the wrong forum, the law provides, Milord, he should have filed a fresh suit with the leave under section 14 of the Limitation Act.
Sorry.
1963.
Milord, 21st December 2015 invoked arbitration. No.
Okay, whatever it may be, yes.
Very well. No, ठीक ही बोला.
So, Milord, my contention is this, Milord. as per the provision of the section 14 of the Limitation Act 1963, my lord, the plaintiff should have either should have filed a fresh suit along with a prayer for leave to condonation of the delay in proceeding in the
Sir, in the suit there is a provision for limited condoning
that,
delay.
my lord, that is under section 14, my lord, not to exclusion of the period of this.
In the suit there is no provision for condoning the delay.
My lord, then, my lord, here, my lord, this order 23, rule 1. Kindly have a look, my lord. Order 23, rule 1, my lord. This is the if there is a suit filed, already filed. Then, my lord, if already a suit has been filed, my lord, and
Order 23, rule 1.
Rule 1, as the in provided in the Limitation Act, my lord, that Limitation Act.
Who was Order 23?
Yes, my lord.
An application for leave under the proviso shall be accompanied by affidavit of the next friend and also minors represented a pleader certificate.
So it requires the order from the court.
Read.
Yes, my lord.
First you read the arbitration clause 3, 14 subclause 3, limitation 14 subclause.
Yes, I reading the Limitation Act, the subsection 3. Notwithstanding anything contained in rule 2 of order 23 of the Code of Civil Procedure 1908, the provision of subsection 1 shall apply.
Kindly see, read order 23 rule 2,
my lord.
How it is applicable here?
An application for leave under the proviso to sub rule 1 shall be accompanied by an affidavit of the next friend, and also if minor or such other person is represented by a pleader by a certificate of the pleader to the effect that person is that.
So this is, sir, order 23 with regard to the withdrawal.
So
how you are dealing with that? So I am surprised.
Yes, and subsequently, my lord, there the rule, my lord, rule 4, where the plaintiff abandoned, where the court is.
That is with withdrawal. Either you part withdrawal or part abandon. That is, kindly see the chapter. This constitutes withdrawal and the adjustment of the suit, not with regard to the limitation and filing of the suit.
Yes, my lord. And what has been provided in my lord, Limitation Act, the subsection
That's
3.
Order 23.
Order 23, and it says that this order 1, rule 1 of the order 23.
It is not applicable.
So here, my lord, my contention is this, my lord, there should be an application for leave to file, to make a claim for addition of the money claim in the existing suit, and that section 14 of Limitation Act should be filed, and court should have granted leave to exclusion of the period. So here, my lord, on the point of limitation, my lord, I said there was no application under section 14 of the Limitation Act. Praying for exclusion of the time proceeded before the learned arbitral tribunal.
Yes. Next.
The plaintiff had filed civil suit claiming the said sum of this after rejection of the arbitral reference on the ground of lack of pecuniary jurisdiction and the order rule 2, order 23 of the Code of Civil Procedure. Then point of authority. My learned friend, this was the first point which I took for limitation, and that was contention of that this plaintiffs that they proceeded in before the arbitral tribunal, and I said there is no leave under section 14. So there is no leave granted. So that amendment by addition of the money claim by amendment in the suit, that is barred by limitation. Then the second point which was taken by my learned friend, the point of authority under rule 1, order 3. Then what my learned friend submitted that it is submitted on behalf of the plaintiff that Sri Arpit Koteta, Mr. Arpit Koteta, the divisional executive engineer, Southeast Central Railway, Bilaspur, deposed as defendant witness number 1, and Sri Theophil Ekka, an employee of Southeast Central Railway, posted at headquarters of this said railway at Bilaspur, deposed as defendant witness number 2 in the instant suit, were not authorized to depose in the instant civil suit, as they had not submitted any power of attorney from the defendant numbers 2 and 3, being the chief engineer construction and deputy chief engineer construction, being the defendant number 2 and 3 of the Southeast Central Railway, Bilaspur. This was the contention argument. In reply to this, I submit, the defendant railway in this regard submit that by a circular number such and such dated 4/6/1992, issued by the Government of India, Bharat Sarkar, Ministry of Railway, Rail Mantralaya Railway Board, in pursuance of the power provided under Rule 2, Order 27 of the Code of Civil Procedure 1908, the central government hereby authorizes. So here, first I...
Yes, read. Hereby authorized?
Authorizes the officer specified in the schedule contained in the said circular to act on behalf of the Union of India. So we don't see this circular kindly.
Question is not that. Question is that the CPC, any authorized officer can file the suit, affirm the affidavit, verify the pleading, file an application, whatever it is. That is not the case here. Here the case is that at the time of evidence, now it is the evidence stage, and evidence is governed under the Evidence Act. If it is governed under the Evidence Act, you have to prove the document. Mere producing the document will not itself say that the document is proved. Unless contrary, you prove the document. You prove the document, there are two things. One is the first evidence, then another is the secondary evidence. If the first evidence is not available, then you have to adduce the secondary evidence. Here, your original documents, most of the original document is not there. You produce the secondary evidence of this Xerox copy. Secondary evidence is to be proved through a process as available under the Evidence Act. So their main contention is that all the documents which you have relied upon, that document has been issued by the deputy chief engineer, executive engineer, whatever is at the relevant point of time, who were posted in the set place of work. Let the court complete. Now, this person is now executive engineer, whatever it is, as per your notification, you are authorized to depose. No problem, court allow you to depose. Court is not discarded you not to depose. You depose. But what he has stated, this document, whenever you shown the document, he stated that he was not even he has not been appointed at point of time. So how you prove that document? First thing. Second thing, when your DW2 was examined, he stated that the persons who have issued the letters, they were very much available in the service. They are doing the service. What is the shy to appear before this court to prove the document?
Here, I will satisfy you, Lordship. Here, so far,
this has not been exhibited. This has been still
not required.
I am going with you.
This is the statutory provision, Milord. This circular has been issued, Milord. Kindly have a look.
I am giving you also go to the home and work. Take the Wildlife Protection Act. Wildlife Protection Act, the range officer has been given by a notification, a range officer has given a power as a wildlife warden. But it doesn't mean he will not come to the court and depose the evidence unless and until the person will come in the court and depose. That is only with regard to the proceeding of the matter. Still, I am telling the notification, your IS officer, IPS officer, IRS officer might be interpreting the document. That is only with regard to proceeding of the matter. But with regard to prove the matter, it is governed under the Evidence Act. Show me the notification that the evidence has been repealed by way of notification.
On this issue, my lord, I will come on that issue also, my lord. On this issue, my lord, power of attorney, point of power of attorney taken, that power of attorney was not filed by the my lord Kuteta and Ekka. My lord, here, my lord, I say, my lord, under this circular, my lord, the authority has been given several officers. And where from this circular has been made? That is the provision in itself, Civil Procedure Code. That is, my lord, it stated in this circular itself. This provision, the power has been derived from, my lord, this power has been derived from, my lord, Order 27. Kindly have a look, my lord. Order 27, Rule 2.
Yes, I am telling.
Yes.
Read. Read.
Person authorized to act for
Correct.
government.
Correct. Act for the government.
Person being ex officio or otherwise authorized to act for government in respect of any judicial proceeding shall be deemed to be recognized agent.
Correct.
They are deemed to be recognized agent.
Sir, I am not telling his evidence is not trustworthy. I am on that. The document have you proved?
Yes, I will come to that, my lord, also.
Show me.
My lord,
Show me the document. He can
my lord,
prove.
First, my lord, power.
I am agree with sir. I am not telling the DW1, the Poteta is the unauthorized person. This court is not telling.
No power of attorney required.
Not required. I am telling you,
Yes.
your notification is there.
Yes.
But you satisfied me, the person who is not the author, who was not present at the time of the execution of the work, who cannot identify the signature of the person, how the document which you relied is
There is also another restricted provision, my lord. I am coming to that also.
Sure.
I am coming to that. So here, my lord, I will, my lord, point of authority under Rule 1, Order 3, I have already placed that this circular authorizes Executive Engineer, my lord, to do on behalf of the railway. And being the, my lord, listed, one of the 52 is, my lord, the Divisional Executive Engineer is listed, my lord, to act on behalf of the railway litigation. So he came, my lord, he has the statutory authority, my lord, that is under circular and circular made under the Civil Procedure Code. So he came here for railway interest. So now, my lord, I am coming thereafter, my lord. This is the Civil Procedure Court which has authorized, my lord, that for interest of railway from time to time for the work of the railway, my lord, they are issuing circular and these are issued under the provisions of the Civil Procedure Code. Apart from that, my lord, the Railway Act, the Indian Railway Act, my lord, there, my lord, it authorizes all the employees of the railway. My lord, that is, my lord, kindly have a look. Section 195 of the Railway Act, 1989.
Yes.
This provides, my lord, representation of railway administration.
Yes.
1. A railway administration may, by order in writing, authorize any railway servant, here Ekka was authorized, or other person to act for or represent it, as the case may be, in any proceedings before any civil, criminal, or other court.
Yes.
So here, my lord, these two witnesses,
Yes.
my lord, one is the statutory authority, my lord,
Yes.
and another person has been authorized under the provisions of 195 of the Railway Act.
Correct.
So those were, my lord, duly authorized to, my lord, come before the court and all acts in litigation of the railway.
Yes.
So, my lord, My lord, here, my lord, my learned friend argued that that the Mr. Arpit Koteta, Divisional Executive Engineer, and Sri Teofil Ekka, employee of South East Central Railway, were not authorized to depose in the instant case is not correct. And Order Rule 1, Order 3 will apply in case of private litigation, not in the case of railway. Then, my lord, the plaintiff in their argument submitted that the defendant witnesses had not personal knowledge of the transaction.
Yes.
As because Sri Arpit Koteta, the defendant witness number 1, had joined the railway in the year of 2019, when the transaction under the work contract relate to the year of 2010 onward. In this regard, the defendant railway submit the railway is a big central government organization where a large number of officers as well as subordinate employees are working to carry out the varieties of works of the railway. Certain persons who were
you are having the Evidence Act. You are having the Evidence Act.
Right
Indian
now,
Evidence Act 1972. You are having.
Evidence
Or you see that. Read 106. Have you read?
Yes, my lord.
Yes. So, personal knowledge he has to prove. The Koteta has no personal knowledge. He has a documentary only on the basis of the document available. Kindly see 106.
Here, when any fact is specially within the knowledge of any person, the burden of proving that fact is upon him.
Upon him. So who is the person? Your deputy chief engineer or the assistant engineer or executive engineer who were posted at that point of time, not the Koteta. How the facts is proved?
My lord, here, my lord, there are documents are there, my lord.
And correct, sir. I fail to understand. Evidence Act is totally different. Evidence, you have to prove your case in terms of the document, and document has to be proved as per the Evidence Act. Evidence Act, the document, it's not. Yes, this is a document. Yes, this is a document. Unless it is admitted.
My lord, by the time, if many of the officers already retired.
Where you have proved? Your PW2 has stated that he is still working.
Only one.
Whatever it, he could have been come before this court. He can say, yes, he worked with me, and I know the signature. He was working under me, and this is signature. It was issued in on my instruction. That is the way to lead the evidence.
Out of, my lord, some officers, chief engineer, deputy chief engineer, and other officers.
Very busy person.
Here, busy person, my lord, they already by that time old matter, retired. Only one person by that time it was said was serving at that time.
Show me the evidence. Show me the evidence that all the persons died or retired. Whether have you issued the safina to the retired person to appear before this court? Safina, have you issued the safina to the person to come before this court and adduce the evidence? I am again telling, sir, for the evidence there is a procedure. And when you started the evidence, that time also indicated you, please, you consult the person who is conducting the evidence. But you failed to do so. How the court can help you? Burden of proof with the parties. And the parties has to prove their own document. Mere one notification, you cannot say prove. Yes, I am. That's why I have allowed Mr. Potato to give evidence. The court is not telling that he is not an authorized person. He is an authorized person. His evidence is taken on record. Cross-examination was done. But the proving of the fact, proving of the document is upon you. How it has to be proved. Your Potato has already stated, I was not present at that point of time when the notice was, the documents has been issued. The deputy chief engineer, he don't know the signature. He was not posted with him. How you can prove? Tell me. That is yeah, please you go through the evidence act. Please you go through the evidence act. First, secondary evidence, first evidence, how proof of document.
Very well, my lord.
That is the difference of the trial advocates or of the arguing advocates. That is the difference.
My lord, by oral evidence, which has been, my lord,
Now you can argue that yes, document is not necessary. You prove the oral document that the court can accept. Yes, it has been proved non-required to that. Show me which document is valuable that yes, court can say the document can be ignored. Show me that what document.
my lord, then my lord, I will have to place my lord, the evidence, my lord, recorded on behalf of the, my lord, this
You
Khoteta,
already given the written notes of argument. How
Will-
further time can you?
my lord. And, my lord, so for my submission, my lord, is,
Yes, you argue. I will take note of it. No problem. No, I am
my lord,
indicating. I am not restraining you to argue the
my
matter.
submission,
But I am indicating you.
yes, well, my
I am
submission is
indicating
this,
it.
lord,
In future, the cases you be alert.
being, my lord, yes, as a practical, my lord, that railway, it's a very big organization, people are coming, going. And in the process, my lord, here the officers are appointed after their maturity, my lord, their superannuation or retiring, and then some other officer coming after 3 years, they are being transferred. So this is, my lord, the administration. So if my lord, any officer, my lord, if deputed, if goes through the records,
If suppose leave aside your civil case, you are telling that your officer is not. Your officer is a prime eyewitness of the murder case. Murder was committed in Calcutta. Your eyewitness shifted to Pune. Can you say, yes, my eyewitness is in Pune, I cannot examine, the case is proved?
in criminal case, it should not be.
That is the way I wanted from your mouth. Criminal case, the evidence act is on either civil or criminal. That is the same. You cannot say criminal says it different. That's why I'm since beginning I'm telling the evidence act is the only one act which deals with the criminal, civil, all. Why you are filing the writ application with an affidavit? And why the court is accepting that the document which you are relying upon? That is also for the evidence. Then
those documentary evidence.
Then,
So therefore, my lord, what my submission is, my lord, the evidence have been laid after going through the entire documents, and it is not a layman. The person who laid the evidence, my lord, that is the Mr. Khoteta. He is the IIT Mumbai, and my lord, this person. Second, DW, my lord, defendant witness 2.
Yes, DW.
Defendant witness 2, my lord. My lord, he was brought only for this purpose to identify some of the signatures of the officers who already retired or transferred.
But he has not said anything.
He has.
What he has stated? Show me. What he said? Show the evidence. Yes, it is the signature of this officer signed before me. Where is that evidence? Show me. He has stated that yes, this is the document. I was present. The so and so signed before me. Show me. He has given a negative evidence.
So he has just verified that that letter was authored by the person who has signed. He aware of his signature and he knows that person. He worked under him. He merely for that, and he is a Group D employee and is as a railway, because the railway spared that person. If railway doing so many works, laying the new lines, so many passenger traffic and freight, so overloading. So therefore, sparing of the person is very difficult. So in the process, and therefore the act also authorizes the officers and persons to go and see the interest of the railway. And therefore they were Mr. Khoteta as a statutory authority and Mr. Ekka as per this authorization under the Railway Act, my lord. So therefore, my lord, their evidence kindly can be looked into, my lord. And then, my lord, my lord, my lord, so far the evidence, my lord, is concerned, my lord. I said, my lord, that the my lord, the person, merely one person at that time was serving the railway, and all other related officers were already retired. And that is the reason that those persons were not brought before this court, my lord, at the time of evidence, my lord. And then, my lord, the third point which was taken, the notice of production of documents to the defendant railway. My lord, what my landlord submitted, that this contract entered into in 2010. Then, my lord, they lost the coach file. They lost the coach file, and therefore they had made a complaint before a police station regarding that, my lord, misplacement of these papers. And thereafter it's submitted that there was a commissioner for taking evidence was appointed, my lord, in the court, my lord, and there they made a prayer for production of the documents from the railway. Those they lost, and they made the police complaint, and they wanted the production from the railway, and railway did not produce. This is their allegations. They made this. My lord, here, my lord, and the railway did not produce those documents. Similarly, my lord, the documents which railway relied and disclosed, some of the documents were not original, and those original were lying with the plaintiffs, and therefore the defendants also made a notice to production of those documents before this honorable court. That also not complied.
During the cross-examination of the plaintiff witness, have you put that question? The original is with you. You had the chance. You had the chance. If the defendant, I don't know, in my presence, you have not filed any application for production of document. I don't know. But when the court was here, and the cross-examination was going on, yes, 11. So if it is not, why you have not put the question to the plaintiff? Why you not put the question?
So these papers were, and
why you not file an application for production of document? You might be given notice, but after giving notice, if the defendant is not produced, can you see the CPC? There is a provision for filing an application for production of document.
So in that process, my lord, many documents itself proved, because many documents delivered to the plaintiffs, they are saying they have lost it, and I want the production, my papers. If they could not produce, and
so that's why you have to prove by putting a question to the plaintiff witness. Show me which question you put the question to the plaintiff witness. See, this is the document with you and not produced deliberately. Then the presumption will go against the plaintiff.
Some question were certainly asked, my lord, in the process, my lord, in the cross-examination, certain questions were certainly asked on this aspect, my lord. But my contention is this: they said railway did not produce the documents which they lost and asked for production from the railway. Similarly, my lord, document we asked for production, they did not produce.
Okay. Next.
My lord, the fourth point,
yes,
my lord, the further which my learned friend argued, my lord, the agreement to the impossible act. They said the agreement to impossible act, and they relied on the section 56 of the Contract Act. Lord, here this agreement to do impossible act, an agreement to do an act impossible in itself is void. This is the heading of this, my lord, this section, my lord. And then contract to do act afterward become impossible or unlawful. A contract to do an act which after the contract is made become impossible or by reason of some event which the promiser could not prevent unlawful becomes void when the act becomes impossible or unlawful. So this is, my lord, their line. Here, my lord, the plaintiff had submitted that works under the contract was impossible to perform. As such, it was itself void. The soil investigation report was delivered by the defendants, and the drawing and design was made on the basis of the soil investigation report, which was approved by the defendant number 2. In the course of construction of the well foundation, the plaintiffs had encountered with hard rock under the river bed, which was impossible to penetrate. Since such hard rock encountered under the river bed in well foundation of the proposed bridge, the plaintiff had sought more time to execute the work as per the contract, and same was declined by the defendant railway. The plaintiffs further submitted that as the work contract was impossible to perform due to hard rock, flood, non-availability of Ultratech cement, and insurgent and anti-social activities at the work site, it became impossible to carry out the works. Accordingly, the work contract dated 28/7/2010 shall be treated void in terms of section 56 of the Contract Act 1972. This is contention, my lord. My lord, to answer to this, my lord, I say, my lord, that to avoid repetition, the defendant number 2 and 3 submit that the defendant number 2 and 3 has already dealt with the above argument made by the plaintiffs in notes of argument dealing with the issue number 3 and 4. 3 and 4, my lord, the issue which I have dealt with, I have covered this. Issue number 3, my lord.
Yes.
Issue number 3, my lord, is the, my lord, whether the designs, drawings, and work methodology approved by the defendant number 2 on the basis of the subsoil exploration report and GAT made over by the defendant number 2 untimely frustrate the contract and render it impossible of the performance. This was the issue. Then, my lord, my submission was, my lord, the designs, drawings, and work methodology based on subsoil exploration report of Vision Lab, Hyderabad, handed over to the representative of the plaintiff number 1 was perfectly correct and as per the technical requirement thereof. The subsoil exploration report, that is Exhibit 2, page 36724111, was prepared by the Vision Labs, one reputed laboratory based at Hyderabad. The said Vision Labs had thoroughly made survey and soil testing of the proposed location of the bridge. In the said subsoil exploration report, a bar chart has been appended wherein the abutment 1 and Pier 1 to Pier 7 hard rock has been clearly shown. In that chart, it is mentioned, you know, that for this much meters, the hard rock is there, that it's shown in by the bar. The subsoil report was prepared and signed by the person having expertise and necessary qualification for survey and soil testing to carry out the big projects. The said subsoil report was signed by Sri K. Kasturi Nand, M.Tech IIT Madras, Consulting Geologist Engineer Sri K. Keswarao, MSc Tech, Senior Geologist. After getting subsoil exploration report from the defendant number 3, plaintiff did not raise any question regarding the authenticity or methodology suggested in the said report. On the contrary, the plaintiff by letter dated 4/5/2012 from the plaintiff number 1 to the defendant number 3 sought permission for use of explosive for blasting and for sinking the well in hard strata. The plaintiff prepared the design and drawings based on the subsoil exploration report of Vision Lab and submitted the same to the defendant number 2 for approval. The defendant number 2 approved the said, they submitted that defendant number 2 approved the said design and drawings with certain modification. In this regard, the Chief Bridge Engineer, South East Central Railway, Bilaspur, void its letter dated 31st January 2011, Exhibit 3, provided two major instructions to the plaintiff in execution of the said project. A. All necessary arrangement to penetrate the wells in hard rock should be made prior to fabrication of the well cup. B. It was further instructed that initially only one well should be lowered completely in the ground. So, after the success of the sinking of one well completely, the task of sinking of other well will be easier. The aforesaid facts have been confirmed by the witnesses of the plaintiffs as well as the defendant railway. Question number 85 to 91 of the plaintiff witness number 2 in cross-examination may also be looked into. Any question, and question number 65 and 66 of the defendant railway witness number 1 in its deposition dated 3/7/2024 may also be looked into. The plaintiff did not follow the said instruction, which resulted their failure to complete the project successfully even after extending the completion period till 31st March 2014. As a result thereof, defendant railway had to suffer huge financial loss as well as loss of traffic to carry the freight and passenger. The said subsoil exploration report, Exhibit 2, clearly indicate the presence of hard rock, and to penetrate the hard rock, the provision of controlled blasting and use of explosive have been provided in Chapter 12, Clause 5.1 and 7.1 of special condition of the contract. Provision is there, my lord. The plaintiff in reply to 7 days notice dated 30th January 2014, the plaintiff for the first time raised objection. While their reply dated 14/2/2014, Exhibit NN, to the subsoil exploration report of the Vision Lab and suggested two options to inter alia. In case option number 1 is not acceptable to railway, considering aforesaid situation, the contract may kindly be closed. This suggestion, without any liability on either side, under force majeure clause as per the clause number 61 of GCC, and our outstanding dues, EMD, security deposit, and performance guarantee be paid. In question number 68, the defendant railway witness number 1 in answer has stated the defendant number 3 in its letter dated 16/6/2011 referred that nearly 4 months after approval of the drawings, no detailed works program was planned and resources mobilization program was submitted by the plaintiff. The subsoil exploration report prepared by the Vision Lab Hyderabad at Exhibit 2 of the said report has clearly mentioned about hard rock down river bed in abutment 1 after 7.5 meters and from top presence of hard rock zone. Similarly, Pier 1, 2, 3, 4, 5, 6, 7 presence of hard rock down the riverbed zone in the chart annexed in the subsoil exploration report. Then this issue number 4 also dealt with that issue, my lord. If the answer to the previous issue is, if the answer of the previous issue is in negative, whether the supervening and intervening circumstances, including the work methodology approved by the defendant number 2, render the contract unworkable and unfeasible in terms of the contract condition. In answer to this, my lord, issue, my lord, the defendant said, my lord, defendant railway submit the alleged supervening and intervening circumstances and the design drawings and work methodology approved by the defendant number 2 on the basis of the subsoil exploration report and GAD made over by the defendant 2 will not frustrate the contract and render it impossible of performance for the following reasons. The law and order is a state subject, and the railway is not responsible for maintaining the law and order. However, after lodging FIR with local police, the working environment created and work resumed in the month of June 2011. Further, on 29/9/2012 and 29/5/2013, similar incident reported by the plaintiffs, and to facilitate smooth working at the site, defendant railway had requested Chief Security Commissioner, RPF, South East Central Railway, Bilaspur, to take necessary action. Accordingly, the said authority of the defendant railway took necessary action and about 4 persons arrested by the local police, and thereafter there was no such incident of threat, antisocial activities which occurred at the work site. The plaintiff have alleged obstruction by flood being flood being a natural calamity during construction period. The defendant railway submit that it has not found any declaration of natural calamity of flood.
How many pages you are having further?
My lord, I will take, my lord, the judgment which I have cited. I will, my lord, that.
Again?
No, my lord, my learned friend judgment which I have cited, my lord, I have to give a reply to that. Your lordship may fix it.
When you complete?
My lord, more or less, my lord, I will, even completion, my lord. So, if your lordship.
Only reply to the judgments.
Yes, yes, my lord, and this, my lord.
That is not necessary. I will deal with that.
And my lord, this, my lord, let me complete this, my lord. And it was found, flood, they took the point of flood. My lord, it is a natural calamity, and natural calamity was not declared by the state. And during the contract period. Further, in the rainy season, rains are inevitable, and as a result, risk of increase of water level of the river is also inevitable. But the said problem is for limited period
By
of
which
time.
document you have proved that?
My lord,
by which evidence you have proved that?
My lord, this is their allegation that there was a flood. My lord, that, and due to that there was obstruction to carry out the work, delay. So my submission is this, my lord, flood is for limited period. That year, particular year, my lord, that was limited period. If flood is there, it may be for a week. So that water will recede. So that, my lord, I have stated, my lord, that may not be a good ground for delay. Delay may be for 1 week. But here, my lord, that delay is about 3 years. Then, my lord, the risk of increase of level water is also inevitable. But the said problem is for limited period of time, cannot be excused for non-completion of said project. Then, my lord, by later date is 6/3/2014 from the defendant railway, being Exhibit S to the plaintiff, the aforesaid issue have already been described by the defendant railway. Further, plaintiffs have received about 6.7 crores through running account bills submitted to the defendant railway. The plaintiff in their letter dated 20th December 2011 has alleged non-availability of the Ultratech cement and consequent adverse impact of delay in completion of the project. The defendant railway submits the plaintiff cannot take the plea of non-availability of Ultratech cement in view of the provision contained in Chapter 5, Certificate of Familiarization being part of the contract agreement, Exhibit D. There is an agreement, there is a chapter of Certificate of Familiarization. And there, my lord, Chapter 5 of the contract agreement is a declaration.
Okay, close it.
Look,
File notes, Milan.
That's all.
The judgment, my lord, which cited my learned. Your lordship, if
or my lord, you can put it in the notes, my lord. You can distinguish in the notes.
If your lordship, my lord, they have relied on. If your lordship say that to answer to that, I will. Otherwise,
you can put it
How
in the
much time
notes.
take?
I will take, my lord, about 15 to 20 minutes.
Counsel for the defendant has argued the matter in reply, but has not completed the argument. Accordingly, is adjourned. Let the matter appear. There is no time.
Or my lord, we can put it in the notes, my lord. It can be closed today.
Yes, you put the note.
He can put it in the note, distinguishing
Your
that.
answer to the citation, you give in
Because
the
getting next 15 minutes will take us to 1 month.
Written notes.
Both of us can put it in our notes, my lord.
In the month of January.
Yes,
15th of
we can,
January.
no point.
This court has no time till 15th of January.
Anyway, my lord gives me sufficient time to file notes. We can put it in the notes.
You give what you want to rely, give the reply to the, you put the note.
Yes.
When you will give. I am giving sufficient time.
Reply those judgments cited, my lord. And instead of writing the entire fact.
But I can't give the time. I can fix the date tomorrow, day after tomorrow. I have no problem for fixing, but I cannot give the date, time.
Milord, even if Milord, if your lordship, if in fixing Milord any date, Milord at 3 Milord in original side.
That's why I'm telling you, I can't fix the time till 15th of January. My diary is packed. That's the matter appear on 8th of December 2025 for further argument by the
But my lord, we can put it in the notes. My lord, when my lord will pass the decree, my lord see the notes only. My lord not recollect what we have
That
said.
can be done, sir.
Or my lord kindly keeps it for 15 minutes on that date, my lord.
I fix on let's
Any my lord at the top at least, so that it can be done.
उसको बोलो ये जो परसों जो नंबर 1 में रखा है इसको 37 है शायद हाँ? वो काम दूसरा में ना डाल दो, मैं तो बोलो इसको यहाँ से हटाओ मत दो, ना तो इसको हटाओ मत दो।
Or my lord, may I suggest one thing? My lord is not fixing any time. Let it appear on the as a first matter on that date. 15 minutes he will come.
I will see the list on that day. Then
Even if 3:30 is there any day, as your lordship
you
kind enough to
every
hear
day
it today,
3:30, what can be
your
done?
lordship can hear it on that day.